ಅಲ್ಲ ಏನು what that's an innocuous order sir. ಅದಕ್ಕೂ ನೀವು ಕೇಳಿಲ್ಲ ಅಂತ ಬಂದ್ರೆ ಆಗಲ್ಲ.
Court is passing an order saying that by virtue of the order passed by this honorable court in regard to speedy disposal, I am tied not to hear of any application apart from.
ಅದು ಮೂವ್ ಮಾಡಿ CPC court ಮೂವ್ ಮಾಡಿ sir. No, move the CPC court. Nothing. Move the CPC court. ಕೊಡಿ. That's an innocuous order. ನೀವು ಕೇಳಿದ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ ಎಷ್ಟೋ. ಸುಮ್ಮನೆ ಇದೆಲ್ಲ ಬೇಡ. Yes, wait madam. ಕೊಡಿ sir. Fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Now don't waste time. Please give all the fresh memos.
My lord.
Please give all the fresh memos. I will decide when it is posted. Give it. Please give.
My lord, the case and my lord.
ಎಲ್ಲ fresh memos ಕೊಟ್ಬಿಡಿ.
Kindly request case
2:30 ಯಾವ್ದಿಲ್ಲ fresh memos ಕೊಟ್ಬಿಡಿ.
My lord, it is a framing is, I mean charges will be framed on 16 my lord.
No problem.
There is no sitting my lord.
Nothing is going. Heavens are not going to fall. Heavens are not going to fall if charges are framed. If you have filed the petition before that date, give it. Yes.
My lord, case and counter
No
case.
sir. If you come, give it. Yes.
At least Monday my lord. At least Monday. Kindly my lord.
I can't take 1000 matters sir. Give it.
Yes and my lord.
Give all the memos. No, if you are not giving, I'll start calling the cases. Sir, please give the memos. No, ಯಾವ 2:30 ಯಾವುದು ಇಲ್ಲಪ್ಪ. So what? ಯಾವ್ದು ಮೇಡಮ್? ತಗೊಳ್ಳಿ.
Your lordships, this matter is covered by your.
ಕೊಡಿ ಸರ್, ಯಾಕೆ ಮೆಮೊ ಕೊಡಲ್ವಾ? ಕೊಟ್ಬಿಡಿ.
Your lordship, this matter is.
ಕೊಡಿ ಮೆಮೋಸ್ ಕೊಡಿ ಎಲ್ಲ.
Your lordship, the matter is.
Okay, give the memos.
Your lordship, the matter is covered by your lordship's
Please
judgment.
give it.
Another accused, the matter is
No
listed
problem,
today at
give it,
serial
yes.
46, your lordship.
Give it.
My lord, proclamation.
You want to withdraw? ತಗೊಳ್ಳಿ.
My lord,
give all the
proclamation has been
memos.
issued,
Yes,
my lord. Without.
Give all the memos. ಕೊಡಿ ಸರ್. So what sir, ಕೊಡಿ. No problem sir, ಕೊಡಿ. ಎಲ್ಲೂ heavens are ನೋಡಿ bail ತಗೊಂಡಿದ್ದೀರಾ, heavens are not going to fall, please give it.
ಬನ್ನಿ
ಅರೆ sir, bail ತಗೊಂಡಿಲ್ವಾ? We'll take it in the second week of February, ಕೊಡಿ. Second week of February. No problem sir. Give it. It is. If you want to give the memo, give the memo sir. ನೀವು ಕೊಡ್ತೀರಾ ಮೆಮೊ ಬೇಡ? ನೋಡಲ್ಲ ಸರ್. Events are going to fall ಅಂದ್ರೆ ಮಾತ್ರ 2:30.
ಅದು ಐಟಮ್ ನಂಬರ್ 42 ಇದೆ, ನಿನ್ನೆ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ, ಗೊತ್ತಲ್ಲಿ ಬರಬೇಕು. ಇವೆಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್ ಡೈರೆಕ್ಟರೇಟ್
42 ಬಂದಾಗ ಹೇಳಿ.
ಗ್ರೇಟ್.
My lord.
Give it. Court all.
Lordship.
VC, wait.
My lordship, on submission, last Thursday I have moved the.
No problem sir, give it.
ಅಲ್ಲ sorry, ಇದು
Give it sir, ಕೊಟ್ಬಿಡಿ sir.
charge sheet ಅದಕ್ಕೆ
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ sir, give it. Yes.
Monday
ನಿಮ್ಗೆ ಯಾರು escape ಆಗ ಕೇಳಿದ್ರು ಟ್ರಯಲ್ ನ, why should I show indulgence? I will post it after 4 months. Why should I show indulgence? Because you have escaped trial. ಅದ್ಲೇನ್ urgency?
Monday
ಟ್ರಯಲ್ escape ಆಗಿರೋದು ಹೌದು, ಮತ್ತೆ ಅದ್ರಲ್ಲಿ urgency ಬೇರೆ. No sir.
Petitioner my lord is external.
Give it.
Lordship, there is a stay by this honorable court, my lord, against Kengeri PS, my lord, for the investigation in relation to cyber crime, my lord. They are not, they are continuing with the investigation and there is a serious.
Oh, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ sir. No problem, give it sir.
My lord.
Give it.
Petitioner my lord is external.
There is no bail in this.
Take sir. Yes.
My lord, kindly maybe.
Take.
My lords, merely my lords, the petitioner.
Will you give the memo or not sir?
Please.
No mentioning, please give the memo. Compromise ಯಾವತ್ತು ಬೇಕಾದ್ ಬರ್ದು ಕೊಟ್ಬಿಡಿ. No mentioning, please give the memo. ಅದು ಮೇಡಮ್ ಮೆಮೊ ಕೊಡಿ, ಅದು 2:30. ಕವರ್ಡ್ ಬೈ ಬರ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಪರವಾಗಿಲ್ಲ ಸರ್.
My lord,
No.
there is a serious apprehension of.
Give it.
Your lordship may kindly permit me to submit a matter pending before court 7. Today is the in-charge court. Your lordship, the matter pertains to Sri Chamundeshwari temple. There is a lot of digging and demolition activity that started. Which is
Is it
impacting
listed
the
today?
program. Listed today before
Urgent
court
matter, then I'll
7.
take it.
No, there is an urgency in the matter. Over a period of 4 days, they have excavated.
Now what do you want me to do?
Kindly hear the matter
When?
on interim relief.
When?
Anytime today, as per the convenience of this honorable
ಅಷ್ಟೇ
court.
ತಾನೆ, I'll take it. Yes.
Grateful. It's listed before court 7, list to serial 21.
No problem. Yes. We'll see.
21. List 2.
Sorry?
There is a threat of arrest, my lord.
Why?
There is no
Sir,
bail in-
stay ತಗೊಂಡಾಗಿದೆ, threat of arrest ಅಂತ, ಏನ್ sir?
They are telling against some
Nothing
other-
doing, yes.
My lords,
Give it, if you give, if you're not giving the memos, I'm going to start, please give the memos. ಮತ್ತೆ ನೆನ್ನೆ ತರ ಮಾಡ್ಬೇಡಿ, please give the memos.
my lords,
Wait, please give the memos. ಬರಲ್ಲ ಕೊಡಿ ಸರ್, ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀರಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. Pending matter ಕೊಡಿ sir, it will come according to seniority of those designated days.
Next week, my lord.
No, why should a special concern be shown to you? No, pending matters according to seniority, they will come. In following some method, don't deviate it. Yes.
Matter is listed before the quota number 7, my lordship. Urgency is petitioner are suffering from rare disease, my lordship.
Wait, sir.
My lord,
My lord,
lordship,
my
this
lord.
is some other matter, my lord. In this, there is no pitching, my lord.
No problem, sir. Kodi, memo kodi.
Lord, there is a serious.
No, no, sir, memo kodi.
Kindly maybe 19th. my
ಅದು
lord.
ಕೊಡಿ madam.
My lord.
ಕೊಡಿ madam.
Kindly maybe 19th, my lord.
No, sir, give it. Stay ಇರೋ matter ಯಾರು move ಮಾಡ್ತಾರ?
That is some other matter. I have already handed
ಮತ್ತೆ
over.
what is that some other matter?
Even this also, my lord, there is a serious threat of arrest, my lord.
Why serious threat? ಯಾವ crime register ಆಗಿರೋದು?
Crime registered on 24th December, my lord.
ಏನ್ offense?
Offense is 318 and 319, so plus 2, my lord.
Folks, bail ತಗೊಳ್ಳಿ first.
My lord, kindly maybe 19th.
bail ತಗೊಳ್ಳಿ ಕೊಡಿ, ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ. ಬೇಕಾದ್ರೆ ಮಂಡೇ.
Monday.
Well, this matter may be listed on Monday, my lord. That's what, my lord, as I mentioned, my lord,
Pending matter.
it's a fresh matter, my lord.
FR number ಇದ್ರೆ ಮಂಡೇಗೂ ಬರಲ್ಲ.
Fresh matter.
my lord,
FR number.
FR number ಇದ್ರೆ ಮಂಡೇಗೂ ಬರಲ್ಲ. Yes.
Comply ಆಗಿದೆ,
may I-
Don't complain, don't
comply
complain.
ಆಗಿದೆ, my lord.
my lords,
No adjournments in the morning. Yes, call the case.
my lord, my lord, my lord.
No adjournments.
My lord,
Your lordship, fresh matter, your
my lord,
ಕೊಡಿ ಅಲ್ಲ.
may I be,
Monday.
Monday
my lord,
ಕೊಡಿ.
permitted to mention a matter, my lord.
If both of you tell, it's difficult. Yes.
Court Hall 7 matter, my lords. It's listed at serial number 27 in list 1 for hearing on stay, my lords. It's little urgent if may be taken up
We'll
today.
see. Yes.
My lord, may I please be permitted to make a mention, my lord? I apologize for being on
That
DC.
will happen.
My lordship, list
My
number
lord, I
2, number
apologize
16
for
before
being
the
on
quota
this
number
matter.
7, my lordship, may be taken up, my lordship.
My lord,
ಕೊಡಿ, all the cases madam.
2025
my
matter,
lord,
my lord.
may I
There is no
please be
interim order,
permitted
my
to
lord.
make a
ಕೊಡಿ
mention, my
sir.
lord? My lordship, may I please be permitted to make a mention, my lord? It's a tender matter. It's a tender matter. I have filed the writ petition on Friday itself, and the auction is being conducted on Monday. There is an urgency in the matter, my lord. The date was fixed for today for hearing, but because the learned single judge is not sitting today, it's not been listed. May I please request for 2:30 because my writ petition will become infructuous otherwise.
ಆಯ್ತಾಯ್ತು ಕೊಡಿ. Yes.
My colleague is going to hand over the memo, my lord.
There is no colleague of yours here. Yes. Call the case.
Serial number 43, my lords. Serial number 43.
Adjournment ಇಲ್ಲ sir, please.
Lords, petitioner has expired.
Indirect ಆಯ್ತು ಅಂದ್ರೆ ನಾವು ಮಾಡೋಣ. Petition has expired, abated ಆಗರೆ.
Please, my lord.
Closed. ಒಂದು ಎನ್ನೇದು ಒಟ್ಟಿಗೆ. Yes.
43, lords.
Yes, call the case. Wait. Mention at 1:30. Yes.
I appeal for petitioner in this case, my lord. Offense under section 409 and 420, my lord. Effect of A1, my
Yognesh
lord.
sir, all against A1 and A2.
A3 ಮತ್ತೆ 5.
A3 ಒಂದಿದೆ ಅಷ್ಟೇ, ಒಂದು ಲೈನ್.
My lord, this honorable court has granted a stay.
A1 A2ಗ ಕೊಡಿ, ಅದು ಕೊಡಂಗೇ ಇಲ್ಲ. ಕೊಡಿ ಇಲ್ಲಿ. ಎರಡು ಸೇರಿ ಕಳ್ಸೋಣ. Tag this petition along with so and so, list them both on 4th February for admission.
My lord,
Interim order, there shall be an interim order in the light of the fact that interim order is subsisting in the companion petition.
my lord, it may be called along with, my lord, criminal petition number 10988 of 24 and
ಏನದು?
connected matter, my lord.
ಏನದು?
Same petition.
ಇದಲ್ವಾ?
ಅದ್ರ ಜೊತೆಗೆ, my lord.
ಅದು ಬರ್ಕೊಡಿ.
Please, my lord.
Yes. 78-3.
Is the person runs a bakery shop and manages the entire gambling in the district with a bakery.
With the bakery?
The bakery.
That's the investigation.
Investigation.
Papers kodi. The learned additional SPP submits that the petitioner in the forefront runs a bakery shop and actually runs a complete gambling unit is the investigation conducted by the state. The investigation papers are placed on record. to hear the petitioner on the issue, list the matter on 3rd February. ಯಾವ ವರ್ಷದ ಮೇಡಮ್ ಇದು? 5th February. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ?
ಇಲ್ಲ. Please.
3 and 4 same.
3 and 4 same.
Where is the order of the appellate court? Page.
Appellate annexure page 34 minutes. 11 pages at page 35.
34, 35. ಇಷ್ಟೇನಾ?
ಹೌದು.
The petitioners are before this court. ಎರಡೂನು same order, Chetan. The petitioner is before this court calling in question an order dated 10/11/2025 by which the sentence of the petitioner is suspended on a condition that he would deposit 20% of the fine amount and execute a bail bond thereon. The heard so and so. The petitioner gets, the petitioner is the accused, the respondent is the complainant. The petitioner and the complainant have a transaction. The transaction goes wrong and the complainant approaches the concerned court invoking section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. The petitioner accused gets convicted of the said offense. The issue in the list is not with regard to the merit of the matter, i.e. the conviction of the petitioner. While filing an appeal against the order of conviction, the petitioner files an application seeking suspension of sentence. The said suspension is ordered by the following order. ಇಷ್ಟೇನಾ? ಪೂರ್ತಿ ಹಾಕಿಲ್ವಾ ನೀವು?
ಇಷ್ಟೇ ಇರೋದು. ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ.
So the petitioner aggrieved by the said condition of 20% of deposit of the fine amount is at the doors of this court in the subject petition. The learned counsel P. N. Manamohan, appearing for the petitioner, would vehemently contend that the law as laid down by the apex court is completely given a go by in directing the payment of 20% of compensation, 20% of the fine amount, 20% of the fine amount while granting suspension of the sentence. The learned counsel submits that the order must have been reasoned as to why 20% of the fine amount is a must in the case at hand. The learned counsel submits that the matter requires reconsideration at the hands of the concerned court. In the light of the issue being one of the suspension of sentence on certain conditions, no notice need be issued to the applicant. It is the admitted facts are that the petitioner gets convicted of the offense under section 138 of the Negotiable Instruments Act, and the order of conviction is sought to be stayed by the order quoted herein above. The apex court, considering an identical circumstance in the case of Jambu Bandhari 2023 10SCC page 446, has held as follows. The 446 tane adu alla Jambu Bandhari bere 446 correct alla 2023 10SCC 446 has held as follows. In the apex court holds that the concerned court must apply its mind as to why 20% of the amount is necessary to be paid in any given case while suspending the sentence. In the light of, if the law as laid down by the apex court is pitted against the order passed by the concerned court, it would run foul of the same. Therefore, the petition deserves to succeed for a remand to the hands of the concerned court to follow the law and pass necessary orders again in accordance with law. For the aforesaid reasons, the following order: allowed in part, quashed, the matter is remitted back to the hands of the concerned court to answer the application of suspension of sentence, bearing in mind the observations made in the course of the order, particularly the law as laid down by the apex court in Jambu Bandhari. In the light of the order of suspension being granted to the petitioner, the same shall continue till further orders are passed at the hands of the concerned court. Please. ಬೇರೆ ಎಲ್ಲ ಸೇಮ್ ಕೋರ್ಟ್ ಮಾಡಬೇಕಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಯಾವ ಪೇಜ್
but the next petition not
you should be fast sir,
please
iPad ಇಟ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ.
page 36 not is the order.
Order convention is better. Convention is better, I see.
12/11/2025 page 36 is the order.
Page 36.
But the one mistake, not that first page of the order not is not there in the first matter. Second matter it is.
Okay, I was seeing it.
Adu page number hanga hakidare. I am not, I placed that. No, just one more page.
ತುಂಬಾ ಬರೆದಿದ್ದಾರಾ?
ಇಲ್ಲ
ತುಂಬಾ ಬರೆದಿದ್ದಾರೆ.
ಇಲ್ಲ ತುಂಬಾ ಬರೆದಿಲ್ಲ.
ತುಂಬಾ ಬರೆದಿಲ್ಲ. All right, yes.
The complete order is there in the second matter.
All right, ಅದನ್ನ court, same connected matter, I don't know.
Connected matters.
Sorry, same order, yes.
Courts are different.
Both same.
Great.
Yes, next.
Here for petitioner's counsel.
Ah.
Lord, this is a matter where my lord CCB registered my lord FIR. Straight away, my lord, contrary to the notification as could be seen from the records. Lord, the notification at page 32, my lord, says that my lord only on the direction of the High Court or Supreme Court or my lord the DGIGP or the Commissioner FIR can be registered.
CCB straight away registered.
Straight away registered FIR, that's what my lord, as could be.
Over enthusiasm, CCB.
No, they have police station.
No, they have police station, but there is a condition.
Correct. Police station for a particular purpose.
Correct. Your lordship will see the
They are not
notification.
officers in charge of the police station
They are
in normal circumstances.
So your lordship will see the notification.
Yes, yes, page 32, clear.
Heard the learned senior counsel Arun Sham. I'm not on that. I'm not on that at all. Heard the learned senior counsel Arun Sham appearing for the petitioner. The petitioner is before this court calling in question proceedings in so and so. A perusal at the crime so registered would indicate that for an incident that happens in the year 2022, the allegation being that the petitioner would get additional deputy commissioner's job in the excise department, the complainant is said to have fallen prey for the said desire. But the desire ended in the year 2022. The crime springs only in the year 2025, 28/5/2025, 2 years and 5 months after the crime, after the said incident, without any explanation at all in the crime so registered against the petitioner. In the light of the said circumstance of delay, permitting further proceedings would run foul of the judgment of the apex court in the case of Hiralal so and so, 2023 SEC online SC 1124 and Chanchalapati Das, 2023 SEC online SC page 650. Therefore, there shall be an interim order of stay of further proceedings where the petitioner till the next date of hearing. CCB gogade illa now. Yes, next.
And there is other point also, my lord, section 23. Void contract, my lord.
ಅದು ನೋಡೋಣ ಬಿಡಿ. ಅದು ಕ್ರಿಮಿನಲ್ ಕೇಸಿಗೆ ಬರುತ್ತೆ ಸರ್ ಕಾಂಟ್ರಾಕ್ಟ್. ನೋ ನೋ ನೋ.
Anyway, my lord. My lord, this is post is SDA, not
talking of Premlata Shetty.
Lord. SDA post, my lord, it is.
ADC ಅಲ್ವಾ? SDA ನೇ ತಗೊಳ್ಳಿ. ಚೇಂಜ್ ಮಾಡಿ.
ಸಣ್ಣದಿದೆ.
ನೀವು ಬರ್ದಿರೋದು ನೋಡಿ ಏನು ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಯಾವ ಪೋಸ್ಟ್ ಇದೆ ನೋಡಿ.
ಅಲ್ಲಿ ಬರ್ದಿದೆ.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ ನೋಡ್ಬಿಡಿ. ನೀವು ಐಪ್ಯಾಡ್ ಬಿಟ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ಪೇಪರ್ ನೋಡಿ ಸರ್.
ಪ್ಲೀಸ್
ಈ ಐಪ್ಯಾಡ್ ಇಟ್ಕೊಂಡೆ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿರೋದು. ತಗೊಳ್ಳಿ ನೋಡಿ. ADC ಬರ್ದಿದ್ದೀರಾ SDA ಬರ್ದಿದ್ದೀರಾ?
Please.
Seriously. Yes.
Oblige. Great.
But for the petitioner in
This client won't keep quiet at all, is it? ಏನಾರ ಒಂದು ಮಾಡ್ಕೊಂತಾರಲ್ಲ. Why?
It was our client itself. So the de facto complainant is
correct. ಎಲ್ಲ ಕ್ಲೈಂಟ್. Why?
But even the complaint is totally fake.
The very good advocate actually. Why does he indulge in all this?
So even the client, even the complaint does not mention the time of giving when it.
ಎಲ್ಲ ಆಯ್ತು sir. I am not on merit. You may have 100% merit. Why you have a good career, then why do you do all this?
Convey this.
What will convey? He'll be somewhere, don't worry.
Page 24.
ಮತ್ತೆ bail ತಗೊಳ್ಳಿ. I'll protect you for a week. By then you take bail.
Yes. That's 2 weeks, my lord. The date is on 22nd.
Reject ಆಗಿದೆ.
Anticipatable reject ಆಗಿದೆ. ಇಲ್ಲ ಹಾಕಿ.
I have filed here, my lords. It's on 22nd.
Bail 22nd.
22nd is the next date of hearing for interim bail.
Bail ಅಲ್ಲ. 15 days ಬಿಟ್ಟು.
And it might not even reach, my lord.
Not even reach. 22nd won't reach.
22nd. It is subjected to PP filing objections for the main.
We don't take time. We don't file.
Correct. Bail 15 days time. List ಆಗಕ್ಕೆ.
Even in the trial court for an
urgency is on. Urgency and rush is only in this court.
But the police are hell-bent on arresting him, my lords. They are roaming around the office.
That's why he's not found here. Illa I would have seen a cap.
But the action is not correct.
There are many lacunae in doing. Many protections available for an advocate. Today this may be this advocate. Tomorrow you may arrest anybody.
No, Your Lordship, protect him,
That's
not
why-
on that.
That's why the learned counsel for the petitioner submits that the petitioner, there are several legal lacunae in registering the crime against the petitioner, including including non-compliance of the advocate protection, non-compliance of Karnataka Prohibition of Violence Against Advocates Act 2023. Inter alia, the petitioner submits that he has his anticipatory bail application has been rejected, and the anticipatory application has been the same has been sought at the hands of the coordinate bench, and the coordinate bench has fixed the date as 22nd. In the light of the several legal lacunae, I only deem it appropriate to protect the petitioner till the concerned coordinate bench would consider his bail application. Bail application. List the matter on 23rd. Till such time, the respondent state shall not take any coercive steps against the petitioner. Ashte.
Split up. Split up.
Split up. 399, 409.
But 379.
Alla onde. Yeah, there is no representation on behalf of the petitioner. In the light of the co-accused acquitted, there shall be an interim order of stay of further proceedings before the concerned court. List the matter on 19th February for admission. Yes, next. Preliminary hearing, WP, yes.
Therefore, petitioner. Page number 83, my lord, there is a.
My order, sir.
1 week time.
No time, madam. List
Please,
admel
madam.
admission list admel mugit.
Time, my lord, please.
No time.
We'll get instruction.
No instruction, madam. Yes, argument ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ close ಮಾಡ್ತಾ ಇರ್ತೀನಿ ನಾನು. Please don't anybody seek
2
time
days time.
unless it is warranted.
Kindly 2 days. madam.
If you
Please,
don't
madam.
cooperate for closure of the proceedings, I will not
Kindly
wait
2
for
days.
anybody.
Day after tomorrow.
No day after tomorrow, madam. Yes,
Kindly pass over the matter.
indirect adjournment. Yes. Pass over, right.
Please, Your Lord. Proceedings under the KPID Act and IPC have been initiated against these petitioners. The petitioners are not at all concerned with the Vikram investment.
ಆಯ್ತು, ನೀವು ಫಸ್ಟ್ ಪ್ರಹ್ಲಾದ್ ತಗೊಳ್ಳಿ.
Please, Your Lord.
ಹೇಳಿ.
I have taken criminal petition 602.
Yes, sir.
Please.
I am also there.
Please,
Multiple FIRs are registered.
please,
And all of them are clubbed together
please,
and being taken as a single charge sheet.
please.
No problem. Anything else?
Now, Your Lordship, that is in accordance with section 982 of the KPID Act, Your Lordship.
Yes, sir.
Now, the question that arises, each one of the complaint made by the parties on the basis of which this case
No
came.
problem, sir. There are about 24 FIRs registered.
Please,
22 does not name you. 2 name you. Enough.
Your Lordship, we will proceed on that basis, Your
Yes,
Lordship.
sir.
I am not concerned with them.
That's a matter of trials.
No, it's on face of it, Your Lordship. Face of it, Your Lordship. I have not concerned with it. I have not received any commission from Vikram Investment. It's all matter of record. It was given by them, individual parties, for commodity trading. It's all on record, brought by the prosecution themselves.
We will not answer Vikrama's akrama here. Yes.
Lordship, then what more can I submit?
Not one people, 148 people are there.
All the 148 will take, Your Lordship. In fact, here's the short, there are more than that. Each one of the statements we go on that basis. Not one of them are concerned with me.
Who are you?
I
You
am
are
just
yourself an investor.
I am a personal investor. I have lost money of nearly 40 lakhs each.
What were you in Vikram?
I am one of the investors. I am not employed, not concerned, nothing. I invested it, I encouraged him, I have put there, I'm making good money out of it.
Oh.
That encouragement has landed me into trouble. This is actually what has transpired. And it's a matter of record. Backed by documentations, whatever has happened, the income received has been declared to income tax. Would be one aspect of the matter. The second aspect of the matter is the transaction is trading on commodities by Vikram Investments, which had no authority to do it. Now, if it's a foul transaction, Your Lordship, contrary to the provisions of
No, if it's a
section,
foul transaction, fine. If it's a foul play in the transaction, then
Your
it's.
Lordship, then it can't. Then this court can, I would humbly submit that with matters related to being something illegal, I can't approach the court and say, give me relief there.
No, you can approach the court, say anything.
Yeah, but the court encourage that. Having indulged in something illegal.
Who is the complainant?
He has not
Who
appeared.
I'm for the respondent number 2, my lord.
Who is that?
I'm for PR Balaji, Bhaskar Enterprise.
Balaji.
Balaji Agarbatti and Company.
That is
Complainant,
that is another matter.
ಆಯ್ತು ಸರಿ ಇದರಲ್ಲಿ ಅಷ್ಟೇನಾ?
Same thing in all the cases.
ಅಲ್ಲ, the common stream that runs through all the cases, you are not concerned at all.
Please.
And without any rhyme or reason, you have been roped in.
No, I have introduced. I cannot dispute that.
Rhyme ಇದೆಯಾ, reason ಇದೆಯಾ?
Only the crime is that I have introduced. That itself is the crime.
So there is rhyme, no reason.
It can't be a rhyme. They have made money out of it. Now, after having earned out of it more than that they are invested, at a later date turning around and say, at my behest, I have lost the money. It's not that any one of them have lost. And the bundle of records produced before the court produces.
Kannada na English?
Pardon?
Kannada na English?
Which one?
Bundle.
English bundle only.
English.
Court records, I would say the documents on the basis of which the final report has been submitted. Itself produces the trading account statements of all of them.
Kannada ಆಗ್ಬಿಟ್ರೆ dismiss ಮಾಡ್ಬಿಡ್ತೀವಿ.
So my humble submission, it requires consideration.
It requires consideration, no doubt. Yes, Shankar Narayan.
Lord, I represent the Petitions Council in 9.3. I stand on an isolated basis. And so far, no charge sheet is filed against me. The complaint, the de facto complaint is available at page number 116. And I would read that where my role is 136, I'm sorry. 136, where absolutely no overact is alleged in so far. No, why I'm using overact is no role is even indicated towards me. I am one of the victims of this investment, having lost all my savings. And I would only read at page number 139, 4 lines. So there are 10 lines. And leave it to the Honorable Court whether the victim has to go through this ordeal. And nobody disputes that I am not a victim. Even the prosecution.
If that is not disputed, then we will close it.
Yes, why?
If there is no dispute that all of you are victims and have no role to play.
Please, Your Lordship. And that is the records.
Yes, ma'am. May I read that page number 139?
ಆಯ್ತು ತಾಳಿ ಒಂದು ನಿಮಿಷ. Additional SPP ಅವರ.
Yes, ma'am.
ಇವರು victims or they have made victims?
They have made 180 people victim by accused number 6.
That is Prahlad.
He received 40 lakhs rupees as a commission. He induced about 6.12 crores to be paid to the Vikram investors by 148 people.
ಆಮೇಲೆ
So similarly, my lord, other accused also have been
ಇವರು ಶಂಕರ್ ನಾರಾಯಣ ರಾವ್ ಸರ್ ಅಪಿಯರ್ ಆಗ್ತಿರೋದು
against. They are also been induced, my lord. The only problem is the large investigation was happened in crime number 73, and crime number 73 stay was obtained.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಹೌದು, crime number 70 there is 73 there is a stay. With respect to other crimes, my lord, charge was been filed. With 73 we could not file because there is a stay.
Who is the accused in 73?
Prahlad is also
the same Prahlad. Then, Your Lordship, it starts with crime number 73, in which I have taken stay.
Oh, yes.
Thereafter, this other 24 FIRs come into picture, which have all been coupled together in the other bundle. In all of them, it is my consistent stand, including the KPID. I have submitted my claim application there also before the competent authority.
My interim order, is it?
CH-63 of 2022, there is an interim.
602 ಅಲ್ಲಿ ಇಲ್ವಾ? ಇದೆಯಲ್ಲ?
There is an interim order.
Just Krishna Kumar.
As far as my case is concerned, the only case against me, I do not have any multiple FIRs. This is the only implication by which I'm almost what I would say that there is no other case. This factual position may be clarified by the XPP. I am only implicated only because the FIR says so. Ivaru iddare.
It's a matter of investigation, at least. How can investigation be interjected?
What we are trying to submit, your lordship, there is a complaint that amount was invested by me for commodity trading.
ಈಗ ನಿಮ್ ಡ್ರಾಪ್ ಮಾಡಬಹುದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ, ಯಾರಿಗೆ ಗೊತ್ತು?
They have added me already. They have added, and that's why we are before you.
ಕ್ರೈಮ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಾ ಅಷ್ಟೇ ಅಂದ್ರೆ?
Criminal stay ತಗೊಂಡಿದ್ವಿ. ಅದ್ರಾಗ already ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, but I have been shown as accused already. In all the cases we have been shown as accused.
Case ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರೆ ನಮ್ಮನ್ನು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಬಿಟ್ಟು ಮತ್ತೆ ಯಾಕೆ ನೀವು ತಲೆ ಕೆಡಿಸ್ಕೊಂತೀರಿ? ಸ್ಟೇ ಇದೆ ಅಂತ ಬಿಟ್ಟಿದಾರಾ?
ಅಲ್ಲ, I mean they have named us, but they have made a
ಶರ ಇದೆಯಾ?
ಶರ that there is a stay. We cannot go contrary to records.
In fact, we could have filed one charge sheet for all these things. Because of this stay, we could not file.
Not stay, because section 9A was not in existence in the KPID Act on the earlier position.
No,
Subsequently, that act included in scenarios of this nature.
Anyway, even otherwise, CRPC la ideyalla.
Please,
you can always club everything and do it. Yes, anything else?
139 ಓದ್ಬಿಟ್ಟೆ 4 ಲೈನ್.
ಅದು ಅವ್ರದ್ದು ಕೊಡಿ ಮೇಡಮ್.
Lordship, if otherwise I may be permitted to move for discharge and then.
Discretion is the best part of valor. Yes.
After seeing the wind blowing, I have to sometimes take a call, your lordship.
You should go with the wind, otherwise you'll be gone with the wind.
I would slightly go for a better ambition, a little better ambition if possible. Page number 139.
Comment
and then I would say that.
ಅವ್ರದ್ದು ಕೊಡಿ ಯಾವ್ದು ಮೇಡಮ್ ಅದು?
The de facto complainant.
Page 139.
Yes, my lord. It's a long, it's a 4-page complaint. I would only take the last paragraph, page number 139, where the petitioner's name will come. Nanu Vikram Investment Malikradha M. Raghu, my lord, get it?
Yes, sir. I am at 139, unnumbered last paragraph.
Nanu Vikram Investment Malikradha M. Raghavendra Srinath ಮತ್ತು ಸದರಿ ಕಂಪನಿ ಏಜೆಂಟ್ ಆದ ನರಸಿಂಹಮೂರ್ತಿ ರವರು ಮಾತನ್ನು ನಂಬಿ ನಾನು ನನ್ನ ಬಾಲಾಜಿ ಅಗರಬತ್ತಿ ಕಂಪನಿಯ ಮೂಲಕ ₹1,00,000 ಮತ್ತು ನನ್ನ PR ಬಾಲಾಜಿ HDF ಖಾತೆಯ ಮೂಲಕ ₹1,00,000 ಮತ್ತು ನನ್ನ ತಮ್ಮನಾದ PR ಭಾಸ್ಕರ್ HDF ಖಾತೆಯ ಮೂಲಕ ₹15 ಲಕ್ಷ ಒಟ್ಟು 11,74,00,000 ಹಣವನ್ನು ವಿಕ್ರಮ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಕಂಪನಿಯ ವಿವಿಧ ಸ್ಕೀಮ್ಗಳಲ್ಲಿ ತೊಡಗಿಸಿದ್ದು, ಆದರೆ ಕೆಲವು ತಿಂಗಳವರೆಗೆ ಪ್ರಾಫಿಟ್ ಹಣವನ್ನು ನೀಡಿ ನಮ್ಮಿಂದ ಹೆಚ್ಚಿನ ಹಣವನ್ನು ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಲ್ಲಿ ತೊಡಗಿಸಿಕೊಂಡು ಇದುವರೆಗೆ ಪ್ರಾಫಿಟ್ ಹಣವನ್ನು ನೀಡದೆ ಹಾಗೂ ನಾವು ತೊಡಗಿಸಿರುವ 11,74,00,000 ಅಸಲು ಹಣವನ್ನು ವಾಪಸ್ಸು ನೀಡದೆ ನಮ್ಮನ್ನು ನಂಬಿಸಿ ಮೋಸ ಮಾಡಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಡಿಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇಂಟ್ ಸೇ. ಲಾಸ್ಟ್ಲಿ he says, ಸದರಿ ಕಂಪನಿಯಲ್ಲಿ ಏಜೆಂಟ್ ಆಗಿ ನರಸಿಂಹಮೂರ್ತಿ ಪ್ರಹ್ಲಾದ್, KC ನಾಗರಾಜ್, ಸೂತ್ರಂ ಸುರೇಶ್ ಅವರು ಏಜೆಂಟ್ ಆಗಿದ್ದು ಅವರುಗಳು ಸಹ ಇದೇ ರೀತಿಯಾಗಿ ಸುಮಾರು 800 ಜನ ನಂಬಿಸಿ ವಿಕ್ರಮ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಕಂಪನಿಯಲ್ಲಿ ಹಣವನ್ನು ತೊಡಗಿಸುವಂತೆ ಮಾಡಿ ನಂತರ ಕಂಪನಿಯ ಕಡೆಯಿಂದ ಯಾರಿಗೂ ಹಣವನ್ನು ವಾಪಸ್ ಕೊಡದೆ ನನಗೂ ಸಹ ನಂಬಿಕೆ ದ್ರೋಹವೆಸಗಿ ಮೋಸ ಮಾಡಿರುವ ನೇಮ್ KC ನಾಗರಾಜ್ ಅವರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ. ದಿಸ್ ಇಸ್ ದ ಇಂಗ್ರೀಡಿಯಂಟ್ ಆಫ್ ದ FIR. ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ ಈಗ?
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನಾವಿಲ್ಲ.
ಅದೇ because of the stay.
Yes, madam. So I would only impress upon this honorable court that FIR, when it is read in its entirety, will not make out a case against me. I was suffered victim. I've been suffering even today. I'm a LIC agent. In fact, my LIC, the license came to be cancelled by forfeiture of commission. And there's a separate proceedings which I am pursuing. I'm only bringing it to the knowledge of the honorable court. But insofar as my role is concerned, I have not been assigned, I have not been alleged with any role. And therefore, my lord may exercise the discretion to quash the proceedings. Otherwise, my lord,
you will exercise discretion.
Undoubtedly, my lord, I will not be worsening my position by making this submission.
ನಿಮ್ಮ ಹೆಸರೇನು?
KC ನಾಗರಾಜ್.
A7.
Whole family is ruined.
ಜೈಸಿ ಕರ್ನಿ ವೈಸಿ ಭರ್ನಿ. ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, as you sow, so you reap.
ಅವ್ರು ಒಳ್ಳೇದೇ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಂಬಿಕೆ ಇದೆ ಅವ್ರಿಗೆ.
ಅದು ಅಕ್ವಿಟ್ ಆಗ್ತೀರಾ ಬಿಡಿ.
ಬೇಡ.
ನೀವೆಲ್ಲ ಕಮಿಷನ್ ತಗೊಂಡಿದ್ದೀರಾ lakhs to
No, your lordship. Let them show one account statement that they have paid commission to Vikram Investments.
40 lakhs.
We will not argue. Not even one naya paisa.
40 lakhs.
That is the return on my investment.
ನ್ಯಾಯ ಪೈಸಾ ಅನ್ಯಾಯ ಪೈಸಾ ಇದು.
No, that's not. I have received my profits on the investments made. But no commission of any nature has been received. And they
Yes.
cannot produce such a document.
ಬಾಲಾಜಿ ಅಗರ್ಬತ್ತಿ.
We have invested 11 crores 74 lakhs, my lord.
ವಿಕ್ರಮ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ಸ್ ಅಲ್ಲ, ಇವ್ರು ಹೇಳಿದ್ರ ನಿಮ್ಗೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡಕ್ಕೆ?
Shortcut
ನಾ
is only
ಹೇಳಿದ್ನಲ್ಲ,
shortcuts, my lord.
ಇನ್ನು ಶಾರ್ಟ್ ಕಟ್ಸ್ ಅಲ್ವೇ ಅಲ್ಲ. ಇಫ್ ಐ ಎಂಟರ್ಟೈನ್ ದಿಸ್, ವಿಕ್ರಮ ಜಕ್ರಮ ವಿಲ್ ಬಿಕಮ್ ಸಕ್ರಮ. ನೋ. ಎಸ್.
With liberty, my lord.
ನೀವು ಸರ್?
I leave it to my lord.
Yes. After arguing the matter at length, discharge, it is the petitioners are at liberty to urge all the contentions that are now projected before this court in the event they would want to file an application seeking their discharge, and needless to observe that the concerned courts will consider all these aspects and pass necessary orders in accordance with law. Heard senior counsels ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮಾಡಿ. Yes.
I appear for the respondent, my lord, complainant.
138. ಹಾ
38, my lord.
ಏನು ಗ್ರೌಂಡೇ ಇಲ್ಲ, ಏನು ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದೆ ಇಲ್ಲಿ ಹೇಳಿ? ನಥಿಂಗ್.
Weeks time, my lord.
ಸಾರಿ ಕೇಸ್ ವೀಕ್ ಆದ ತಕ್ಷಣ ವೀಕ್ಸ್ ಟೈಮ್ ಕೇಳೋದ್ರಲ್ಲಿ ಏನು ಅರ್ಥ ಇಲ್ಲ. ಎಸ್.
I'll seek instructions.
ನೋ
for settlement, my lords.
ನೋ ಸೆಟಲ್ಮೆಂಟ್.
I will try.
ನೀವು ಎಂಟ್ರಿ ಮಾಡಲ್ಲ, ಅವರು ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ. ನಥಿಂಗ್. ದೇರ್ ಇಸ್ ನೋ ಗ್ರೌಂಡ್ ಎಟ್ ಆಲ್. ಎಲ್ಲ ಗ್ರೌಂಡ್ಸ್ ಪ್ರೊಜೆಕ್ಟೆಡ್ ಆರ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ಇದೇನೋ ಒಂದು ವಾರ ಬಿಟ್ಟು ನಂದಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ. ಎರಡು ಕೇಸ್ ಇದೆ, ಎರಡರಲ್ಲೂ ಸೇಮ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಫಾಸ್ಟ್ ಅರ್ಜ್ ಎವ್ರಿಥಿಂಗ್ ದೇರ್.
1 week's time.
ನೋ 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 ಸರ್, ನಥಿಂಗ್. ಎಂಟ್ರಿ ಮಾಡೋ ತಗೊಳ್ಳುವಾಗ ಯಾವ ಉತ್ಸಾಹ ಇರುತ್ತೆ, ಮತ್ತೆ ಲಿಸ್ಟ್ ಆದಾಗ್ಲೂ ಅದೇ ಇರಬೇಕು. ದಟ್ ಈಸ್ ಅಡ್ವೊಕೇಸಿ.
2 years they have enjoyed the entry model.
ಮತ್ತೆ 2 ವರ್ಷ ಆಗೋಗಿದೆ ಕೇಸ್ ಇಲ್ಲದೆ ಇರೋದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು. ನಥಿಂಗ್ ಅಷ್ಟೇ. ಯು ಅರ್ಜ್ ಎವ್ರಿಥಿಂಗ್ ದೇರ್. ಯು ವಾಂಟ್ ಮಿ ಟು ಆನ್ಸರ್ ಆನ್ ಮೆರಿಟ್ಸ್? ಅಲ್ಲ, ಆನ್ಸರ್, ನಾಟ್ ಎ ಪ್ರಾಬ್ಲಮ್. ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ಅಂತ ಹೇಳಿ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಕವರ್ಡ್. ನಾವು ಅದೇನು ತೊಂದರೆ ಇಲ್ಲ. ದೆನ್ ಇನ್ ಮಿಕ್ಕಿದೆಲ್ಲ ಪೇಮೆಂಟ್ ಸ್ಟಾಪ್ ಬೈ ಡ್ರಾಯರ್, ಸರ್ವ್ಡ್, ಎಲ್ಲ ಎವಿಡೆನ್ಸ್.
Supreme Court has said, my lord, in respect of cash transaction also, my lord.
ಎವ್ರಿಥಿಂಗ್ ಚೆಕ್ ಯಾಕೆ ಕೊಟ್ರಿ ಸರ್? ಸರ್
In this matter,
ಹಾ ಸರ್,
I've been instructed, of course, that by month end he is making the payment.
ವಾಟ್ ಪೇಮೆಂಟ್?
The entire amount.
ವಿಚ್ ಮ್ಯಾಟರ್?
This is very check matter.
ಇದಾ?
So your lordship may have it on the 2nd or 3rd, on which day if the entire money is paid, then otherwise your lordship I will leave it to you.
ದುಡ್ಡು ಬಂದ್ರೆ ಬರ್ಲಿ ಬಿಡಿ.
Full amount is said, that's not.
The learned senior counsel, Kiran Chavli, appearing for the petitioner, would on instructions submit that the accused is making good the entire payment to the complainant in the next 1 week.
Second, by month end he gets the money.
Month end, by the end of this month. Therefore, showing last straw of indulgence to the petitioner, list the matter on 2nd February in the fresh matter, as 3rd February for admission. In the event no payment is made, no submissions would be entertained. Petition would stand dismissed, as there is no ground to entertain the petition at all.
And action should be taken, my lord, for wrongful submission also.
For what, sir?
My lord, they are giving undertaking before the court, and if they say that they will not pay, not from 2 years, my lord.
They'll not pay ಅಂತಂದ್ರೆ
Now they
dismissal.
say they'll pay.
Dismissal ಅಷ್ಟೇ.
If they don't pay, my lord, after
If they
taking
don't
time.
pay, ಅಲ್ಲಿ ಸರ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇಲ್ಲೇ ಮಾಡಿಸ್ಬಿಡ್ತೀರಾ?
ಅಲ್ಲ, three agreements are there.
ಅದಾಯ್ತು, ಅದ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲ. ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ. ಈಗ ಲಾಸ್ಟ್ ಒಂದ್ಸರಿ ಕೊಡ್ತಾರೇನೋ ಅಂತ ಒಂದು ಇದಕ್ಕೆ ಕೊಡ್ತಾ ಇದೀವಿ.
ಅದಕ್ಕೆ ನಾವು ಸುಮ್ಮನೆ
ಕರೆಕ್ಟ್, ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಅಷ್ಟೇ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇಲ್ಲೇ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Yes.
Name ತೋರ್ಸಿಲ್ವಾ? Yeah, respondent counsel. What's your name? Ali heard learned senior counsel, learned counsel Bipin Hegde representing the respondents counsel submits that no indulgence should be shown as there is no warrant to adjourn the matter. The petitioner has been dodging payment since 2 years. Since ಎಷ್ಟು ವರ್ಷ?
Lord, 482 is 2 years.
And since 2 years, all right. Our registry to print the name of so and so is appearing for the respondent ಅಂತ ಹಾಕಿ ಮಾಡಿ. Yes, next.
For the petitioner, my lord.
Complainant S. Prasanna Kumar.
There are 2 cases.
No
my lord.
Prasanna Kumar.
Just I'm appearing proxy counsel.
No, sir, I'm going to finish it. No proxy, no adjournment. Stay ಎಲ್ಲ ರೆಡಿ ಇರ್ಬೇಕು.
Kindly pass.
ಹಿಂಗೆ ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ದು ಎಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟು ಕೂತಿದೆ ಅಂತ.
Held up in another court.
No problem.
Kindly pass.
No,
I will
sir.
inform you.
ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ 498 306 ಫೋನ್ ಮಾಡಿ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂದ ತಕ್ಷಣ ಅಬೇಟ್ಮೆಂಟ್ ಆಗೋಗುತ್ತಾ?
Kindly pass. ಆಯ್ತು ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. Kindly pass.
ಈಗ I'll take it at 12:30 ಅಂತ ಹೇಳಿ. All passovers I'll call at 12:30.
I make a submission. There are 2 cases. Even we have filed a complaint, my lord. Even they have filed the petition.
ಒಂದ್ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಸರ್.
Great.
Oblige.
ಇಲ್ಲ ಅವ್ರು ಕೇಳಿದ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ನೀವು ಕೊಟ್ಟಂಗಾಗುತ್ತೆ. Yes.
This case, my lord.
This case I am appearing for respondent, my lord.
Sir.
There are other criminal cases.
ಪರವಾಗಿಲ್ಲ ಸರ್, ಇದನ್ನ ತೀರ್ಮಾನ ಮಾಡ್ಬೋಣ ಹೇಳಿ ಸರ್.
Objection ready ಇತ್ತು ಅದಕ್ಕೆ.
25 ದಾ ಇದು?
ಹೌದು ಸರ್.
ಇಲ್ಲ 24.
24.
Yes sir. Successive writ ನಾನು ಮುಂದೆನೆ ಬಂದಿದ್ದೆ.
ಹೌದು ಸರ್.
ಸರ್.
ನಾನು insofar as my lord my disability certificate and my lord that crime which they have committed and insofar as disability certificate which they have produced and doctor certificate also which they have produced, my lord, that showing that they have committed crime and my lord same day. Kindly see inquiry number 38 for a moment.
No, he says
last date of
he
hearing.
says he is disabled.
Disabled.
Not only disabled, my lord, I was not at all in the place of occurrence.
That is what my lord
produced the
I'm pointing
documents, my lord.
I'll point out. ಹಾರಹಳ್ಳಿಲಿ ಆದ ಕ್ರೈಮಿಗೆ ಬೆಂಗಳೂರಲ್ಲಿ 10:08 ಬಂದಿದೀವಿ ನಾವು ಅಂತೇಳಿ 8 ಗಂಟೆಗೆ ಆಗಿರೋದು ಕ್ರೈಮ್ which I am disabled and my lord kindly see doctor certificate.
You are also disabled.
Yes, my lord. Therefore I want to produce certificate.
What is disability versus disability here?
ಅದು ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಅವರು and there is a dispute among them and my lord that they have my lord they used to my lord there are several property issues ಬಂದು ನಮ್ ಗಲಾಟೆ ಮಾಡೋದು. inquiry number 38 may kindly be seen. inquiry number 38 ಇದರಲ್ಲಿ on the same day at 2:24 PM ಗೆ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಲೆಫ್ಟ್ ಶೋಲ್ಡರ್ ಗೆ ಅವರಿಗೆ ಗಾಯ ಆಗಿದೆ, ತೊಂಡೆಯಲ್ಲಿ ಹೊಡೆದು.
ಆಯ್ತು, ಇದು ಅವ್ರ ಕೇಸ್, ಅವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಎಲ್ಲಿದೆ ಇನ್ನೊಂದು ಕೇಸ್ ಯಾವುದು?
ಇಲ್ಲ ನಾವು ಇದರಲ್ಲಿ ಏನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. My case is that I was not at all in the place of occurrence. I have produced the CCTV footages, my lord, the photos of
10:30 CCTV footage kindly be seen.
6:25 AM.
25 and also at page 60, my lord,
23, my lord.
the certificate issued by my employee, my lord, employer.
ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್?
ಅದು ಅದ್ರೆ ಇವರ ಅತ್ತೆ,
ದಾಯಾದಿಗಳ ತರ
ಅವರ ಅತ್ತೆ.
ಮತ್ತೆ ಯಾಕೆ
fighting? My lord, there is a property dispute. Civil cases are going on. In between, my lord, they have initiated the criminal action.
ನಮ್ಮೇಲೆ ಇನಿಶಿಯೇಟ್ ಮಾಡಿ my lord since
and as on that day, my lord, I was not at.
Both of your family members sit and settle. Why all this? And both of you are disabled.
Please, my lord, that is not in dispute.
ಅದನ್ನ ಯೋಚನೆ ಮಾಡೋದು ಬಿಟ್ಬಿಟ್ಟು ಜಗಳ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿ? ಏನ್ ಡಿಸಬಿಲಿಟಿ ನಿಮ್ಗೆ?
My lord,
ಲೋಕೋಮೋಟರಾ?
Physical impairment and visual impairment.
33% ಇದೆ ಅದಕ್ಕೆ. ನಮಗೆ my lord my one hand is not functioning, that is about 55%.
But ಆದ್ರೂ mind to fight is functioning.
That is what my lord I'll since my lord that they have committed crime, I'll if they are ready, we are
I'll should be ready. ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಈಗ. Yes, Arun.
Please, my lord.
Yes. The parties to the list are members of the same family. Parties to the list, except the state is otherwise disabled, except the state suffer from disability. that would bring them under the Disabilities Act are fighting on account of certain property which is the subject matter of a suit. The offshoot of the said suit is the subject petition, as the petitioner is said to have hurled some blows and received some blows. Therefore, there are crimes registered. The petitioner seeks to project a plea of alibi that he was not present in the scene of occurrence of crime. Be that as it may, since the parties to the list are members of the family, the parties shall explore the possibilities of a settlement that would put an end to all litigation, more so in the light of the fact that the petitioner and the complainant both are disabled persons. List the matter on 5th February. Report settlement, if any, interim order, if any, subsisting shall continue to the next date of hearing.
Much of great.
Spot number 2 in this.
13 and 14, my lord, both matters, my lord. Complaint is
138.
the same complaint. One, she filed one complaint, my lord, under 138 of NA Act, and another one, my lord, Atrocities Act, stating.
Atrocities ಬಿಡಿ, ಇಲ್ಲಿ ಯಾವುದಿದೆ ಇಲ್ಲಿ?
First one is 138 of NA Act.
ಎರಡಿದೆ ಇಲ್ಲಿ. ಒಂದೇ ಇರೋದಿಲ್ಲ.
ಎರಡು ಇದೆ.
ಎರಡಿದೆ. 13,
ಎರಡು
14,
ಇದೆ.
13.
ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಂದು ಕೇಸನ್ನ
ಚೆಕ್ ಬೌನ್ಸ್.
ಹೌದು.
ಅದು ಮುಗಿಸ್ಬಿಡೋಣ. ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ಡಿಲೇ ಮೇಲೆ ಹೊಡೆದಾಗ್ತದೆ.
ಎರಡು ಇಂಟರ್ಲಿಂಕ್ಡ್ ಕೇಸಸ್.
ಬಿಕಾಸ್ 24/2023 ಇನ್ಸಿಡೆಂಟ್ ನ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ, 4.5 ತಿಂಗಳು. ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು. ಚೆಕ್ ಬೌನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅದನ್ನ ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅಟ್ರಾಸಿಟೀಸ್ FIR ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ PCR ಫೈಲ್ ಮಾಡಿರ್ತಾರೆ 3ನೇ ತಾರೀಕಲ್ಲಿ. ಇದನ್ನ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ, ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದೀವಿ.
36/2021, my lords, I issued legal notice. Legal notice is duly served to
138 case I will dismiss.
That's
but ಇನ್ನೊಂದು
there is no bona fide in even 138 NA Act also.
ಅಲ್ಲಿ ನೋಡಿ ಯಾವ ಗ್ರೌಂಡು ಇಲ್ಲ.
Please.
ಇದ್ರೆ ನಾನೇ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
Please.
138 and my lords, even ಅವರು they received the legal notice, my lords, they are not replied.
Don't be greedy, sir. ಒಂದು ಕೊಟ್ಬಿಡೋಣ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಡಿಲೇ ಮೇಲೆ ನಾನು ಐ ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಕ್ಲೋಸ್ ಇಟ್. ನಿಮ್ಗೇನು ಆಗಿರೋದು ಒಫೆನ್ಸ್ ಏನ್ ಹೇಳಿ? ಪೇಜ್ 35 ನೋಡಿ, ಕಾಲಮ್ ನಂಬರ್ 17, ಪೇಜ್ 35 in the second case ನೋಡಿ. ಯಾವತ್ತು ಇನ್ಸಿಡೆಂಟ್ ನೋಡಿ? 2/4/2023 ಇನ್ಸಿಡೆಂಟ್. If your modesty was outraged 5 months ago,
delay for filing complaint,
one person would not wait for 5 months to register a crime.
I have narrated the reason, my lord, because of my lords, my husband is met with accident, my lords. Have a document, my lords.
sir. ಆಮೇಲೆ ಸರ್, ಹಸ್ಬೆಂಡ್ ಆಕ್ಸಿಡೆಂಟ್ ನ ನಿಮ್ಮ 354 ಕವರ್ ಮಾಡಬೇಡಿ. 138 ಕೇಸ್, he has to go there only. I am not going to
even, my lords, they are not disputed the issuing of check, my lords.
ಅದಲ್ಲ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ ಬಿಡಿ ಸರ್.
138 may be.
Yes, Raju sir.
Proceed with 138, my lords. Time may be fixed.
ಎರಡು ನಿಮ್ದೇನಾ?
Joint petition.
Time may be fixed for this.
That I will do, sir. All that I will do. Yes. 138 case. The petitioner, first criminal petition 5629 of 2024.
Without any reasoning, my lord, I may permit to withdraw the petition with the liberty to urge all the grounds before the.
Yes.
130.
The learned counsel appearing for the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition and urge all the contentions that are urged in the case at hand before the concerned court. It is needless to observe the concerned court at the appropriate time would answer the same in accordance with law. Ordered accordingly. Second one.
Date of incident, my lord.
ನಾನೇ ಹೇಳಿದ್ನಲ್ಲ ಸರ್.
Please.
Yes. The petitioner is before this court calling in question proceedings in special case 286 of 2023 registered for offences punishable under so and so. The petitioners heard so and so. The petitioners and the respondent have a transaction. Respondent complainant have a transaction. The transaction leads the complainant to the transaction leads the accused to issue certain checks. The checks go wrong. The complainant institutes proceedings under the Negotiable Instruments Act and registers a PCR in PCR 388 of 2023. Process is issued on 3/8/2023 for the offence punishable under section 138 of the Negotiable Instruments Act. On 27/8/2023, a complaint comes to be registered against these petitioners, which becomes a crime in crime number 120 of 2023 for the following offences. The FIR will separate it. The police conduct investigation and file a charge sheet in special case 286 of 2023 within at a breakneck speed within 2 months on 26/10/2023.
Statutory limit.
Huh?
That's the statutory limit.
Charge sheet?
That's the statutory limit.
ಅದ್ರಲ್ಲ ಓಕೆ ಬೇಡ ಬ್ರೇಕ್ ನೆಕ್ಕು ತೆಗೆದ್ಬಿಡಿ ಎಸ್ so and so the charge sheet having been filed in the case at hand against the petitioners are before this court in the subject petition. The learned counsel appearing for the petitioner submits ಇಬ್ಬರದು ಹಾಕ್ಬಿಡಿ submits that the issue between these are an offshoot of a criminal case registered on account of dishonoring of a check. On a particular day that is narrated in the complaint, nothing of that sort has happened which would become an offence under section 354B of 341 or 354B of the IPC. The learned counsel submits that it is a counterblast, it is to arm twist these petitioners in yielding to the proceedings under the section 138, the crime is registered. The learned counsel appearing for the respondent would vehemently refute the submission in contending that the police after investigation have filed a charge sheet and the petitioners knew who the complainant was, and therefore it amounts to an offence under the Atrocities Act as they have hurled abuses in a place of public view or a public place as the case would be. The learned counsel submits that the other offences would undoubtedly require trial and it is for the petitioners to come out clean in a full-blown trial. I have given my source. The aforenarrated facts link in the chain of events and dates are all a matter of record which would not require any iteration. The complaint, since the entire issue has now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Page 24-25. The narration, the complaint is registered on 27/8/2023 of an incident that takes place 5 months ago on 22/4/2023. The fine explanation that is rendered while registering the complaint with a delay of 5 months is that the husband of the complainant had met with an accident and therefore the complainant was engaged in treating the husband. Except the said explanation
in the complaint itself,
except the said explanation, complaint quote madidini, except the said explanation, there is no indication as to when the husband of the complainant met with an accident, what was the treatment taken, when was it discharged, and when the crime comes to be registered. Therefore, it is a case, it is a complaint that sprang out of vagueness. The police, after investigation, file a charge sheet. The charge sheet is as follows. The summary of the charge sheet is as follows, page 35. If the complaint and the summary of the charge sheet is read in tandem, the own certificate idea, read in tandem, what would unmistakably emerge is that the complaint is registered only to arm twist the petitioners to yield in the case under section 138 of the Negotiable Instruments Act. As an incident on 4/2/2023 is complained of after 5 months, and the allegation is that the complainant has been beaten black and blue and also hurled abuses, where the abuses are hurled and how the complainant is beaten is or an injury sustained is not coming forth, as there is no wound certificate appended to the petition. Therefore, the complaint being registered after 5 months is full of embellishments. This is what the apex court holds, that complaints registered after considerable delay must be viewed with circumspection, as they would be filled with embellishments. The apex, it becomes apposite to refer to the judgment of the apex court in the case of Hiralal, so and so 2023 SCC online SC page 1124, court para 1920, and the apex court in the case of 2023 SCC online SC page 650, Chanchalapati, state of West Bengal was Chanchalapati Das. ಅದರಲ್ಲಿ para 15 to 17 ಇರಬೇಕು ಕೋಟ್ ಮಾಡಿದ್ರು. In the light of, if the law as laid down by the apex court is considered, if the facts obtaining in the case at hand is considered on the bedrock of the principles laid down by the apex court, permitting further proceedings would run foul not only of the judgment of the apex court, but become an abuse of the process of the law and result in miscarriage of justice for the aforesaid reasons also. Yes, sir. Withdraw ಮಾಡಿದ್ರಲ್ಲ ಬಿಡಿ, ಚೆಕ್ ಬೌನ್ಸ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ. ನೀವು ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆದ್ರೂ ಮಾಡಿಸ್ಕೋಬೇಕಾಗಿತ್ತು ಒಂದು. ಮತ್ತೆ ಅದೇನ್ ಕಷ್ಟನಾ?
64 ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಸೀನಿಯರ್ಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಅವ್ರು ಹಾಸ್ಪಿಟಲ್.
ಸೀನಿಯರ್ಗೆ ಹುಷಾರಿಲ್ವಾ?
My lord.
RP ಆರಾಮಾಗಿದ್ದಾರಾ?
ಇಲ್ಲ my lord.
ಅವ್ರಿಗೂ ಹುಷಾರಿಲ್ವಾ?
ಇಲ್ಲ my lord, ಅವ್ರು ಬಂದಿದ್ದಾರೆ, but my lord, I am.
ಸೀರಿಯಸ್ ಆಗಿ ತಗೊಂಡ್ಬಿಟ್ರಲ್ಲ ಅದನ್ನ. Yes.
In fact, in the last occasion also they have told me. Then I asked him.
ಏನ್ ನಾರಾಯಣ್ ಸುಮಾರೆ?
He was not feeling ಹುಷಾರಿಲ್ಲ ಅಂತ ಆಫೀಸ್ಗೂ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದಾ? ಯಾರು ನಿಮ್ ಸೀನಿಯರ್?
ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್.
ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್.
My lord, my submission, my lord, is on 21/8/2024. This honorable court had restrained me from withdrawing any money, my lord. This money
2 years
is.
ಇಂದ withdraw ಮಾಡೇ ಇಲ್ವಾ ಮನಿ?
ಮಾಡೇ ಇಲ್ಲ my lord. At least so much so with respect to the security expenses, my lord.
But how are you managing it now?
My lord, from my own expenses, my lord, I am paying from my own savings. I am paying to the security, my
Why
lord.
RP is over indulgent?
My lord, there's a direction from the CJ, my lord, wherein I have been appointed as the court commissioner. I was handed over possession of the property, which is a subject matter of dispute over
He
here, my
says
lord.
he's not well. I'll give one date only because of illness.
My lord, but almost 31 lakhs from that day till today have been paid, my lord.
We'll ask everything to be reimbursed, madam.
My lord, but my next month, 3 months, my lord, we're taking buffer from the security
We'll not
agency.
take it next month. We'll only take it next week.
Then, my lord, Monday, my lord, if I'm.
Not Monday, Tuesday. If it's 23, the 24, the 24 adre Wednesday.
27.
Next week. No, sir, not according to you, according to the court. Yes, list on 24th.
My lord, if a time.
You adjust your calendar. Yes.
My lord, same admission list, my lord, if you may.
Admission is same stage. List the matter. The learned counsel for the petitioner submits that the senior counsel engaged in the matter is indisposed today. Therefore, list the matter on 20. 24, madam.
My lord, 20th or 21st, my
No,
lord, that's
madam.
Tuesday or Wednesday.
I have set the calendar. You have to set your calendar according to the court's calendar. Yes. Madam, 24 matter idu. 22nd. Thursday. 21st. List on 21st.
Interim orders may kindly give.
Interim order subsisting in the case at hand shall continue to the next date of hearing.
Great.
The petitioner is accused number 3 in a check bounce case, my lord. She has retired from the partnership. Partnership came to be, a firm came to be established in the year 2019.
My interim order.
Please. Firm came to be established in 2019, my lord. She has retired from the partnership on
4/11/2022. Check is
Year
issued on what
later.
date?
My lord, on 20th of December 2023. That is a year later, my lord. My lord, I have also produced certain additional documents. One document shows that the checkbook is of the series when the firm, when she was a partner, that 2019 series check is used.
You are not a signatory?
My lord.
My lord, I was a partner of the, I was a partner of the
Madam,
firm at that.
have you signed the check or not?
My lord, it is a signed check which is misused by them.
No, that's all it. You have signed it.
Yes, my lord, its signature is not disputed. My lord, but I was not a partner of the firm on the date when the check was presented, my lord. On the date when the check was presented,
That's not the actual date.
My
The
lord,
apex court holds it is the date on which the check is issued.
my lord, check is also issued, presented in 2023. They have utilized the check after I have come out of the partnership. I was no longer a partner of the firm, my lord.
Yes, sir.
I am a proposal.
Proposal.
Yeah, my lord. In this matter, my lord, the
Impleading.
petition.
Israel have impleading.
I am filing a ready pay.
No, sir.
So,
Then
my
who
lord,
are you?
My lord, in
Who
this
are
matter,
you?
I am the
partner of the Ambal Priya Fuel Station, say, the petitioner joined as a proposed partner, not invested even a single rupee, and made a 3 crores misappropriation in the petrol bank fund, my lord. We are also sufferers
Why
in
are
this
you
matter.
getting implicated here, sir?
My lord, 31/10/2025,
madam.
my lord, his
That's a matter of
applications were
evidence.
rejected.
We also suffer in this matter, madam.
That's all right, sir. Yes. That's a
lord, in
matter of
this-
evidence, madam.
My lord, in this case, we have already retired from the partnership. My lord, the register of firms also says that in 2022, the partnership was reconstituted. I am no longer a partner of that firm, my lord. My lords have only
You
observed.
have
my
signed the check.
My lord, it is a signed check which was kept in their custody
No,
after I
that's a
had
matter
come
of
out, my
evidence,
lord.
madam. I have held so. If you're not the signatory, tell me, we'll do it. If you are the signatory to the check, no. That's a matter of evidence.
My lord, check is, the accused are the firm. Accused number 2
ಹೌದು
is,
ನೀವು ಚೆಕ್
is the
ಇಟ್ಟಿದ್ರಿ,
partners of the firm.
ಯಾವ್ದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ, ಮಿಸ್ಯೂಸ್ ಆಗಿದೆ, ಇದೆಲ್ಲ 482 ನೋಡಕ್ಕಾಗಲ್ಲ. On the given dates, yes, you are not the
Yes,
partner, but check is signed by you.
No, that aspect.
So whether you are there, not there, check is signed, kept, ಎಲ್ಲ ಅಲ್ಲೇ.
My lord, whether the check was signed, that aspect I will verify. My lord, it may be
ನೀವೇ
called
ಹೇಳಿದ್ರೆ
next
ಚೆಕ್ ಸೈನ್
Wednesday.
ಆಗಿದೆ ಅಂತ.
ಇಲ್ಲ, ಅದು check ದು copy
ಎಲ್ಲಿದೆ
ನನ್ನ ಹತ್ರ
ಚೆಕ್
ಇಲ್ಲ.
ಎಲ್ಲಿದೆ? The serious allegations against you.
The check is not produced by me, my lord.
Anyway, ಎಲ್ಲ matter of evidence there, madam.
My lord, I will verify with respect to that aspect. I shall inquire and I shall make my submission, my lord. Next Wednesday it may be.
Yes, finally.
Please.
ಚೆಕ್ ಎಲ್ಲಿದೆ?
ಆ ಚೆಕ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಪೆಟಿಷನ್ ಅನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
138 or 406?
138. Check is not produced by me.
One moment. The petitioner, there is an interim order operating in the case at hand. The interim order is granted on the premise that the petitioner, at the time when the check was presented and dishonored, had resigned as a partner from the firm, and the firm partnership had been reconstituted. But the fact remains that the petitioner has signed on the check when she was a partner. The check may have been presented earlier. The learned counsel for the petitioner submits that the check that was kept with the other partners has been misused. This admittedly will be a matter of trial. The learned counsel submits that that she would place on record the check and verify whether she has signed on the check by placing it before the court. For the said purpose, as a last chance, list the matter next Wednesday for admission.
Of February.
No? Yes.
Interim order may kindly be.
Interim order subject to the aforesaid shall continue to the next date.
Charges are framed in this case, my lords. 18/3/2024 charges are framed.
ಗೊತ್ತು, ಅದಕ್ಕೆ ಅವ್ರ ಟೈಮ್ ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಅಂತ. This court on 7/1/2026 had passed the following order. The charges admittedly have been framed in the case at hand, and the matter is at the stage of evidence. As the crime is of 13 years vintage, therefore there is no warrant of interference at this stage with in exercise of jurisdiction under section 482 of the CRPC. Meenakshi Bala anta hakbittu. In the event charges are not framed, the petitioner is at liberty to get the subject proceedings revived. Savane?
Let's the post pass interim order. I'm told that now the investigation has been completed and even the prosecution sanction is also obtained. Only the charge sheet is yet to be submitted.
They will submit. ಆಮೇಲೆ challenge ಮಾಡಿ.
Let's see the background of that. I may be given a liberty to approach this court if it's advised after.
The counsel for the petitioner submits that, the learned counsel for the Lokayukta Baby Patil submits that the charge sheet is ready to be filed before the concerned court. In the light of the interim order subsisting, it has not been done. The learned counsel Parmeshwar Hegde, appearing for the petitioner, now submits that in the light of the charge sheet being ready to be presented and sanction also being in place, he may be reserved liberty to knock at the doors of this court in the event of need in future. Leaving open all the contentions to be urged before the concerned court. The liberty so sought to approach this court is granted.
Please.
With observation, petition stands dismissed.
Please.
Yes, sir. Idu ashte 7A.
DA.
Oh, idu 13.
DA. But this is similar to that same issue involved, my lords, as.
ಎಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ವಾಪಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಇದು ಬಂದಿಲ್ಲ. This was.
ಅಲ್ಲ, ಇದು ಅದು ಬಂದಿರೋದ್ರಿಂದ ಇದು
Covered under Nirankanath Pandey ಕೇಸಲ್ಲಿ ಅದು
ಯಾವುದು ಸರ್?
Nirankanath
ಪಾಂಡೆ ಕೊಡಿ ಸರ್.
ಇದರಲ್ಲಿ IT returns is filed by both son and
ಎಲ್ಲಿದೆ
daughter.
ಕೊಡಿ ಸರ್, ಪಾಂಡೆ ಕೊಡಿ ಸರ್.
ನಮಗೂ ಕೊಡಿ ಒಂದು ಕಾಪಿ.
IT ರಿಟರ್ನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಕಾಸ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಕೊಡಿ ಸರ್. ಅದು ಒಂದಿದೆ, ಜಸ್ಟಿಸ್ ವಿಕ್ರಮ್ನಾಥ್ ಅವ್ರದ್ದಿದೆ ಒಂದು.
ವಿಕ್ರಮ್ನಾಥ್ ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಿ ಒಂದು ಕಾಪಿ.
The petitioner has rendered service of 35 years in total. In between the source report, what has been prepared, in that, they have not accounted the income tax returns that is filed. 1 crore 20 lakhs is the income tax that is declared in the.
Look into this judgment. Income. This has ramifications. ಎಲ್ಲ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ. Next Wednesday. List on 24 or 25.
This case, the accused number 2 is before your lordship. This was heard. But she is a divisional officer. And my lord, the
7A.
ಟ್ರಾಪ್ ಮಾಜರ್ ಅಲ್ಲಿ ಅವರೇ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದಿದೆ, ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀನಿ. ಪ್ರೀ ಟ್ರಾಪ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಪ್ರೀ ಟ್ರಾಪ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಡಿಮಾಂಡ್ಸ್.
It's all right.
ಟ್ರಾಪ್ ಮಾಜರ್ ಅಲ್ಲಿ 20 ಆದ್ರೂ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ ಅವರು. ರೆಕಾರ್ಡಿಂಗ್ ಇದೆ,
is a very vague.
ಮಾರ್ಕ್ ಮಾಡಿ ತೋರಿಸ್ತೀನಿ.
ಕೇಸ್ ಇದ್ದಕ್ಕೆ ಇಲ್ಲ, ಅದಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ ಈಗ?
ನೋ ಮೈ ಲಾರ್ಡ್ಸ್.
ಹಾಕದ್ಮೇಲೆ ಬನ್ನಿ. The matter is at the stage of crime. The offense is the one punishable under section 7A of the Prevention of Corruption Act, inter alia. Illa onde 7A of the Prevention of. Now 17A is also gone. Split verdict. Yes. So, of the Prevention of Corruption Act, the interim order was interim protection to the petitioner was granted owing to the piquant circumstance as on the said date. The learned counsel B.B. Patil submits that pre-trap mahazar did not contain the name of the petitioner for a demand or acceptance, but the trap mahazar does contain. It would become, and he would submit that the investigation in the lease should be permitted to be continued. In that light, I deem it appropriate to reserve liberty to the petitioner to knock at the doors of this court once charge sheet is filed. In the event charge sheet is filed. Yes.
Please, deeply obliged.
With the aforesaid observation, petition stands disposed.
Deeply obliged.
Yes.
Okay, for petition. The offense under section 500, 504,
For a week's
490.
time in this matter, my lord. It's a
Objection
court or
ಹಾಕಿದ್ದೀರಾ?
move matter. ಇಲ್ಲ, my lord.
Stay ಇದೆಯಾ?
Stay.
For 2
Even
weeks'
entire
time.
complaint, there is no individual voters against this petitioner. Only allegation against accused number 2 and accused number 5.
ಏನು ಒಂದು ನಿಮಿಷ, ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾತ್ಸವ ಎಲ್ಲ ಯಾಕೆ?
ಕಂಪ್ಲೇಂಟ್ ಅದರಲ್ಲಿ 500 ಬಿಫೋರ್
FIR
ಅವರು ಅಪ್ರೋಚ್
ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, FIR ಮಾಡಕ್ ಹೋಗಲ್ಲ, ಡೈರೆಕ್ಟ್
ನೀವೇ ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾತ್ಸವ ಹಾಕ್ಬೇಕು? ರೆಫರ್ ಮಾಡಿದಾರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ?
ಮಾಡಿ.
ಮತ್ತೆ ಇಟ್ ಕುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಬಿನ್ ರೆಫರ್ ಟು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ 500 ಇರೋದ್ರಿಂದ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ವೆದರ್ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ಆರ್ ದೇರ್ ಆರ್ ನಾಟ್ ದೇರ್ ಅಷ್ಟೇನೆ.
Yes. Even the grievance of the complaint is that he misused the government fund. The other accused person gave the representation to the department.
Yes, Namita.
2 weeks' time, my lord.
Why?
I have to take instructions, my lord.
The learned
Complaint. I pay
learned
for the
counsel
complaint.
appearing for the complainant, Namita Mahesh, seeks 2 weeks' time to secure instructions and make submissions. List the matter on 4th February as a last chance. Made clear, no further adjournment for filing of the objections would be granted.
Interim order.
Interim order subsisting will continue till the next date of hearing.
Yes.
Next.
Lots, allegations are. Lots, the allegations are under sections 341, 504, 506 and 323, my lords. Lots, I'm canvassing 3 points.
Canvassing. Yes, sir.
First, my lords, the whole.
14%.
Yes, my lords, please.
Yes, sir.
My lords, first, the allegation is inherently improbable.
Howda?
Second,
Why, sir?
please, my lords. My lords, my lords, if at all the contents of the FIR.
341, 340, 353.
Please, if at all the contents of the FIR, the supplementary statement and the charge sheet are read in tandem and juxtaposed with each
Who is the complainant?
Lords, complainant is my relative, my lords.
353 ಯಾಕೆ?
353 ಇಲ್ಲ, 323 ಇದೆ.
ಇಲ್ಲ, ಒಂದು ನಿಮಿಷ ತಾಳಿ.
323,
My lords, number 9937, my lords.
9937.
9937.
Oh, 341 ಮಾತ್ರ.
341. My lords, if at all.
53 ಯಾವ್ದ್ರಲ್ಲಿ next petition ಇದೆಯಾ? Next matter.
323, my lords.
My lords, if at all the contents of the FIR, the supplementary statement and the charge sheet are read in tandem, my lords, it would be clearly, my lords, apparent that the whole issue is a canard. That is, it has been laid down imaginarily, my lords. Material contradictions have been generated by the complainant himself on all aspects of the offense. That is, time of offense, place of offense, duration of offense, sequence of offense, and the subject matter of offense. Second contention, my lords, there are no essential ingredients to bring home any of the said offenses. 341, my lords, the allegation is that gadige eki addalagi bandu. My lords, 341 is an offense against human body and not against a vehicle. My lords, this court relying on Keki Har Musa Garda in Shivalingappa Kerakalamatti, my lords, has held that, my lords, the offense of 341 is against human body, not against a vehicle. My lords, again, 504, 506, my lords, 2023 SEC online, SC page 951, Justice Pardiwala, Muhammad Wajid. My lords, 504, only Avacha Shabda, specific wordings have not come out. 506, my lords, mere allegation that, my lords, Jiva Bedrike. My lords, Jiva Bedrike should be given with an intention to cause commission or omission of any act which the person is not bound to do. My lords, hence, no essential ingredients, my lords. So, next, my lords, 323, my lords. What all he says, my lords, is that Kayalli Hodedu, Kalalli Oddu. Nature of injuries is not explained. The place or the body parts is not explained. Nothing. And now medical certificate has been produced, my lords. What the complainant says is that, my lords, he was taken to a hospital by.
Mic off ಮಾಡ್ಬಿಡಿ. ಹೇಳಿ.
The complainant says he was taken to hospital by his nephew at 4:25. Medical certificate reflects 5:50 time and taken by some other person's wife.
Some other person's wife.
Some other person's wife. This medical certificate is clearly doctored, my lords, and there's no, if at all this is permitted, my lords, anyone, my lords, can set a criminal law in motion. Last contention, my lords,
Seriously?
the conviction of bleak. Lords, it is clearly apparent, my lords, that the witnesses have been implanted. There is 38 days delay and 43 days delay in taking statements of the witnesses. And what the IO has booked up, my lords, instead of arranging for an investigation parade, photographs of the complainant have been shown. Lords, Honorable Court has deprecated this practice in Gopal Saranand.
Yes, sir.
My lords, in his ground number, in his grounds, page number 25 and paragraph number 29, my lords, he specifically takes a contention of plea of alibi, my lords. Plea of alibi, that is physical impossibility, cannot be urged here is my.
That's matter of trial.
Exactly,
All
my lords.
right.
My lords, I'll respectfully submit your lordship's judgment in 2024 KHC 34776 held in page number 11 and paragraph number 13. My lordship were very categorical and cutthroat in saying that. Yes,
Where am I cutthroat?
You are very categorical in saying very clearly, my lords, that any plea of alibi can be and should be taken in during the course of trial only. And also, my lords, in 2002 1 ACC 351 page number paragraph number 2 and 3, in Munshi, it is very clearly stated, my lords, that even though the same case is here, ಇಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ ಇವರು ಅಂತಂದ್ರೆ 1 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ನಾನು ಇಲ್ಲಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಈವನ್ ದೆನ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಮುನ್ಷಿ ಕೇಸಲ್ಲಿ ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ ದಟ್ ಅವರು ಕೂಡ 700 to 800 meters yards ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮೈ ಲಾರ್ಡ್ಸ್, ಇನ್ ದಟ್ ಕೇಸ್ ಆಲ್ಸೋ ಇಟ್ ವಾಸ್ ಸೆಂಟ್ ಟು ಟ್ರಯಲ್. ಮೈ ಲಾರ್ಡ್ಸ್, ಆಲ್ಸೋ he says that witnesses ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. Witnesses in, my lords, in 5 eyewitnesses were there, and also, my lords, discharge, he files a discharge twice. He has come to this honorable court not with the clean hands. Why? Because once the discharge was filed and it was dismissed. Second time he files and it was dismissed. Even though if he has any kind of remedy, it should be in the appeal and not in this honorable court.
No, discharge dismissal will not tie the hands under 482.
Yes, my lords. Even then, my lords, it is the case of evidence. He is presenting only evidence in the ground number 20, paragraph number 29. It is very clear that what is he urging. So, in that case, my lords, I have, and also in lordship in 2022, in criminal petition number 6794 of 22, lordship again has clearly held in paragraph number 8 that it was dealing with the case of call records, where he was not there anta heli heltidru, when lordship has clearly held that call records anyway it is so it should be urged in the during the course of trial anta heli. My lords, I don't have a problem to go to trial. When this being the case, it may be sent back to
How
trial.
can you have a problem to go to trial? He has a problem.
Yes.
I will differentiate it, my lords. The citation which has denied. This is a case where I was willfully withheld the documentary evidence of alibi and certain evidences.
Alibi, if you are on alibi, trial.
I'm not alibi, indeed, I'm relying on one judgment of this honorable court as well. Govindraj is the state of Karnataka. No fetters have been imposed on the power of the court to the
Sir, that I know, you need not tell that. 10 times discharge is rejected also, I can entertain.
And perhaps discharge, despite I have relied on much Nityalamanda alias Stalin, where perhaps the court, the IO had withheld evidence, but the honorable trial court did not consider it. Despite.
Now, 1 minute. You take section 339 IPC. The offense is 341. You take 339. L meet agide ingredients head. 341. 323, 504, 506 ನೋಡ್ಕೊಳ್ಳೋಣ ಆಮೇಲೆ. 341 ಎಲ್ಲಿದೆ? Wrongful restraint by use of force that you will not be able to move in any direction is the purport of 339. 341 ಅಲ್ಲಿ ಅದಿದೆಯಾ ಹೇಳಿ. ಕೇಳ್ಕೊಳ್ಳಿ ಅಂದ್ರೆ.
ಗಾಡಿ ಓಡಿಸ್ತಿರ್ತಾರೆ ಮತ್ತೆ ಗಾಡಿನ ಫೋರ್ಸ್ಫುಲ್ ಆಗಿ ಅಡ್ಡಾಕ್ತಿರ್ತಾರೆ ಅನ್ನೋದು ಅಲಿಗೇಷನ್.
It's very difficult.
Even
then, too vague allegation to drive home the ingredients. Now 323, 504, 506, yes, we'll see.
My lords, he's 70 years old as on today. My lords, he is giving statement and he'll come to court.
What is the dispute between both of you?
My lord, dispute arises out of a loan. ನಾನೊಂದು ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಬೇಕಾಗಿತ್ತು, ಅದನ್ನ ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡೋದು ಅವ್ರಿಗೆ ಇಷ್ಟ ಇರಲಿಲ್ಲ. ನಾನು ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೀನಿ, ಐ ಹ್ಯಾವ್ ಕ್ಲಿಯರ್ ದ ಲೋನ್. ದೆನ್ ಮೈ ಲಾರ್ಡ್ಸ್, he approaches me and said, why did you clear the loan? I had an interest in that loan ಅಂತ ಹೇಳಿ ಅವ್ರು ಹೇಳ್ತಾರೆ, and then he hits me. This is the allegation.
Wait, sir.
This kind of giggling.
It's not. You're in a court of law. You're an advocate. Then you must encourage restraint on many things.
In this regard, my lords, let him approach the trial court, my lords. We are.
No, if the offense is not at all met even to its semblance, particularly of 341, should not the excise jurisdiction be excised, you tell? ಬೈದಿರೋದು ಅಥವಾ 504, 506 ಮಾಡ್ಕೊಳ್ಳಿ. 341 will quash.
Grateful, my lords.
In ಮಿಕ್ಕಿದ ನಾನ್ ಕಾಗ್ನಿಸಬಲ್ offenses ಮಾಡ್ಕೊಳ್ಳಿ.
My lords, our argument, it was very clear on the grounds of alibi. And also, while taking the interim order of stay,
see, major cognizable offense will quash. The other offenses you can always get it.
Interim.
ಗೊತ್ತು, ಅದಕ್ಕೆ 341 quash ಮಾಡ್ತೀನಿ. ಅದರಲ್ಲಿ 504, 506 ಇದೆ. ಗೊತ್ತು. Yes, sir.
My lords, all the during the course of argument, his only plea was alibi. And then, my lords, our lordship order may be perused at 39/2024 ಅಲ್ಲಿ. He specifically says that I was not there ಅಂತ ಹೇಳಿ.
We'll pass an order on 31st. Dictate ಮಾಡೋಣ.
Grateful, my lords.
Heard the learned counsel appearing for the learned, the petitioner in person, so and so, 31st. DO. N DO. Huh? DO. Interim order subsisting, will continue to the next state.
Grateful.
Idu 353.
Yes, notice, my lords, notice to the complainant, my lords.
ಆಗಿಲ್ವಾ? ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್? ಅಲ್ಲ ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? ಮತ್ತೆ 340, 353 ಅಲ್ಲಿ ನೀವೇ ಸರ್.
By name, by name he has been made as party.
So what, sir? Blocking official duties ಅಂತ ಹೇಳಿದ್ರೆ ಅಸಾಲ್ಟ್ ಇದ್ದಿದ್ರೆ ಬೇರೆ. ರಾಂಗ್ಫುಲ್ ರೆಸ್ಟ್ರೈಂಟ್ 353 ಎರಡೇ ಇರೋದು.
Complaint against the treatment that is the method of the concerned officer. That is there forthcoming actually around page 57.
Yes, it is, sir. Complainant is police inspector only. ಅದೇ ನೇಮ್ ಇದ್ರೇನು ನೇಮ್ ಇಲ್ದೇ ಇದ್ರೇನು. And he is ಮೌನೇಶ್ವರ್, so he has not come at all. ಮೌನವಾಗಿದ್ದಾರೆ. ಇವ್ರದ ಇದು ಹಾಗಾದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. ಎಸ್, ಸ್ಟ್ರಾಂಗ್ಲಿ 2011 ಆಗಿರೋದು. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಗೊತ್ತು, ಅದೆರಡು ಚಾಲೆಂಜ್ ಮಾಡಿದೆ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಯಾವ್ದದು? ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತದು? ಸರ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ ಅಂತ ಕೇಳಿದ್ದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ ಸರ್. ಸೀರಿಯಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲ, ನಾವು ಅಷ್ಟೇ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದಿದ್ದು. The petitioner is before this court calling in question proceedings in 3886 of 2016 registered for offences punishable under so and so. The petitioner heard so and so. The petitioner is an advocate by profession, and on an incident that happens on 29/2011, a crime comes to be registered by the second respondent on the score that the petitioner had blocked or stopped the complainant from moving anywhere, which would become an offence under section 341 of the IPC, and had blocked his discharge of official duties by use of force, which would become an offence under section 353 of the IPC. On the said complaint, a crime comes to be registered in crime number 386 of 2011 for the aforesaid offences. The police conduct investigation and file a charge sheet against the petitioner, which is now pending as CC 3886 of 2016. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that none of the ingredients of section 341 or 353, as the case would be, is met even to its semblance in the case at hand, as the petitioner ಯಾಕೆ ಹೋದ್ರಿ ನೀವು ಸ್ಟೇಷನ್ಗೆ? ಸ್ಟೇಷನ್ಗೆ ಯಾಕೋ ಗಲಾಟೆ ಮಾಡಿದ್ರೆ? Court premises. The learned counsel submits what has happened is in the court premises, and in no way offense under section 341 or 353 can be met in the case at hand. The learned HCGP appearing for the respondents would submit that there is clear blocking by the petitioner of movement of the accused, the police inspector, PSI, a police sub-inspector, which has happened in the court premises, and therefore no lenience should be shown, and the petitioner should be directed to face trial and come out clean in a full-blown trial. I have given my so-and-so. The four narrated facts are not in dispute, an incident happening on the court premises on ಯಾವತ್ತದು 20th September 2011 becomes a 2011 leads the second respondent complainant to register the complaint. The complaint, the page, complaint. ದೇವನಾಗರಿ ಲಿಪಿಲಿದೆ ಇದು. ಅದು ಹೇಳಿ. 28 to 32. Yes, sir. ಹೇಳಾಯ್ತು. 28 to 32. Police, after conduct of investigation, have filed a charge sheet. The summary of the charge sheet as obtaining, page. As obtaining in column number 17 reads as follows. Page, Ezekiel 96 al mark ಮಾಡಿ. If the issue now would be when the complaint and the summary of the charge sheet read in tandem would amount to the offense or otherwise. The offenses alleged are the ones punishable under section 341 and 353 of the IPC being the primary offenses. Inter alia 332 ಇದೆ ಗೊತ್ತು. Yes, inter alia. Section 341 and 353 read as follows. For an offense to become punishable under section 341, the ingredients as obtaining under section 339 of the IPC should be necessarily met. The complaint or the charge sheet so filed is not indicative of the fact that the second respondent complainant was not allowed to move in any direction by use of force by the petitioner. That being so, it would run foul of the judgment of the apex court in the case of 2009 6 SEC page 475. Therefore, the offense under section 341 is loosely laid against the petitioner. The next offense is the one punishable under section 353 of the IPC. For an offense under section 353 of the IPC, the ingredients as found in section 351 are necessarily to be met. Section 351 reads as follows. Interpretation of section 351 of the IPC need not detain this court for long or delve deep into the matter. The apex court in two of its latest judgments, 2025 SEC Online SC 574 has held as follows, para 1619. A little earlier to the said judgment, later to the said judgment, the apex court in the case of so and so 2025 SEC Online SC page 1066 has held as follows, para 17 to 25. In the light of the aforesaid judgments, which clearly indicate what would become an offense under section 353 of the IPC, the allegations would not be met even to its semblance, as the petitioner has not, by use of criminal force, stopped the complainant, a public servant, to perform his official duty. Moreover, the incident is said to have happened in the corridors of the court of law, where the complainant was ostensibly free to move. In that light, none of the other offenses have sprung only from the aforesaid incident, which is inherently improbable. In that light, the further proceedings, if permitted to continue, notwithstanding the fact that the trial has travelled to the proceedings have travelled to some extent, permitting further proceedings would become an abuse of the process of the law and result in miscarriage of justice and fall foul of the judgment of the apex court. Charge sheet bada bidi, adi fall bada, so and so cost. Next alva. ಕೋರ್ಟ್ ಅಲ್ಲಿ 7 1 ತಗೊಂಡ್ರೆ ಎಲ್ಲ ತಗೋಬೇಕಾಗತ್ತೆ, ಎಲ್ಲ ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ. See, 3:30 we have this recruitment interview. How much can I, 10 o'clock in the ಕೂತಿದ್ದೀನಿ, how much can I do? You don't want me to get up for lunch? ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಪಾಸ್ಟ್ 3 days ಅಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಈಗ ಎಲ್ರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತಾರೆ, ಏನ್ ಮಾಡ್ತೀರಾ? I'll have to see every case then. Now everybody will say urgency is there. Then I'll have to see everybody's case. ಅದು ಗೊತ್ತು ಸರ್. Let's see, wait. ಇನ್ನು 11:30. ಇಲ್ಲಿ ಯಾವುದು ಇಲ್ಲ ಇಲ್ಲಿ. ಈ ಕೋರ್ಟ್ ಹೌದು, ಬಟ್ ಯಾವ ಫೈಲು ಇಲ್ಲ ಇಲ್ಲಿ. ದಿ ಪ್ರೊಸೀಜರ್ ಇಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಲಿಸ್ಟೆಡ್. ಅಲ್ಲೇ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಅಲ್ಲೇ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮೂವ್ ಮಾಡ್ಬೇಕಷ್ಟೆ. ಎಸ್ 24 ಇದು ಇವ್ರದಲ್ವಾ? ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ ಇವರು? ಎಷ್ಟರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದೀರಾ ಸರ್? ಸೀರಿಯಲ್ ಒಫೆಂಡರ್ ಅಲ್ಲ, ಸೀರೀಸ್ ಒಫೆಂಡರ್, ಯು ಆರ್ ದಿ ಡಿಫೆಂಡರ್. ಅದು ನೆಕ್ಸ್ಟ್ ಸೇಮ್ ಅಲ್ವಾ? ಅದು ಒಫೆನ್ಸ್ ಸೇಮಾ? 41 ಸೇಮ್? ಹಂಗಾರೆ ಟ್ಯಾಗ್ ಮಾಡ್ಬೋಣ, ಟ್ಯಾಗ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋಣ. ಎಸ್, ಎಲ್ಲ ಸೇಮ್, ಆಲ್ 3, 23, 24, 48. ಅವರೇ ಮೌನೇಶ್ ಏನ ಕಂಪ್ಲೇನೆಂಟು ಎಲ್ಲದ್ರಲ್ಲೂ?
Different crime, different complaint.
ಯಾಕೆ ಇನ್ಯಾರ್ಯಾರು ತೊಂದರೆ ಕೊಟ್ರಿ ನೀವು? 2003 ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ? ಎಸ್ ಜಗದೀಶ್ ಸರ್, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ? ಟ್ವೆಂಟಿ 48 ಸೇಮ್ ಹಾಕಿರಿ, ನಾನು ಹೇಳ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ವಿನ್ಸೋ.
This is the predicate offense.
ಅವರಲ್ಲಿ ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್
ಅವರು 42. 42. This, my lords, I have, like the camel and the tent, I have squeezed into Mr. Chowta's brief.
This is foundational, my lord. If my lord senior, Mr. Sajan and Mr. Sandesh are able to shake the foundation, my lord,
superstructure will fall.
Yes.
All right.
Lords, I have a limited prayer in this.
I have permitted investigation to cooperate with the investigation.
No, kindly see, my lords, what's happening on that. My lords, your lordships may keep the papers aside.
Yes.
June of 2024, my lords, a complaint is filed. The complaint is 4 lines indicating that on the Windsor platform, some third party has actually misused the PAN card of this lady.
1,200 rupees.
1,100 rupees tax deduction at source. So it is not that by cheating I have made money, by cheating I have given them money because I have done TDS. Now that's the allegation. In a parallel letter, my lords, to Windsor, which is with the investigating officers, the lady says, I am not making an allegation on Windsor. You have brought it to my notice. Therefore, and you have asked me to file the complaint. I have. Therefore, please take it from me that I have no allegations on Windsor. My lords, in June to October, precious little is done but a notice issued to me in 24. There is, my lords, in November an interim order of no investigation. From November, my lords, of 2024 to January of 2026, my lords, nothing happens. No, it's not that it was an ex parte order. My lords, notice was served and then an interim order was granted. Despite all of that, nothing happening. On the last occasion, my lords, my esteemed friends stand up to say, as if heavens will fall, let there be investigation. Your lordships modify the order and said, let the lady participate in the investigation, no precipitation. I go there, my lords, on 2 dates. On 12th of January.
After this order.
After your lordship's order. On 12th of January, my lords, I go there between 11 o'clock and 6 o'clock. I am with the officers. On the next day, my lords, I go from 3 o'clock, they asked me to go at 3 o'clock. I go from 3 o'clock, I remain with them till 6 o'clock. I have
Nothing is
answered all.
done?
I have answered all questions.
Answered.
Now the problem, my lords, is this. And my lords, the precipitation for me is not just, my lords, these are not in silos. I have, my lords, a larger ED proceedings which I am contesting, which we are also before your lordships on a jurisdiction question. The ED's investigation is on, my lords. My esteemed friend Madhu is here as well. That investigation, my lords, is culminating and they have to, my lords, file their complaints by 23rd, 24th, whatever, 24th, 25th. My lords, I am dealing with that. Suddenly, all of a sudden, my lords, if the investigating officers here in the predicate offense start summoning me for the whole day, I need to sit here. The questions, my lords, then suddenly become similar. My lords, that leads to precipitation. I'm only praying, therefore, that I'm not even seeking quashing at my lord's hands today. Your lordships had given me protection. Please continue that protection. Let me finish. I have a larger devil to deal with, my lord, which is ED. Let me finish my matters with the ED. I will come back to this investigating officer because by end of the month, ED proceedings, at least in terms of investigation.
Investigation karnak hogi.
Let them then not precipitate at least till the end of the month.
Arrest ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
No, not arrest, my lords. Kindly see what's happening, my lords. If I have to spend the day there, I have, my lords, ED, there are two directors.
ಎರಡು ಒಂದೇ ದಿನ ನಡೀತಾ ಇದೆ.
One is in custody, the other, my lords, I'm the only person out. And therefore, my lords, the breather is what I seek. It's not that, my lords, 8 months, nothing is done. And suddenly, my lords, if this precipitation comes in 2 years, why? Because there's an ECIR. I have no problem with the ECIR. We're dealing with the ED. And ED is investigating. Therefore, my lords, your lordships have said no precipitation. Your lordships said go and participate. I participated on due dates.
That you want me to continue?
Please give me the breather for, my lords, 2 weeks. That's all it
ಇಲ್ಲ
is.
ಇದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಲ್ವಾ?
Please, my lords.
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ. Now the cat will come out of the bag.
Cat has always been out, my lord. It had never been inside the bag.
No, my lords. Okay, subject to some corrections, my lords. Could I just point this out? Now, ECIR which is registered is based on 4 predicate offences. 3 predicate offences, closure has been filed, accepted. Fourth predicate offence is what is before my lords, where there is an order of stay. And this matter pertains to misuse of a PAN card to the use of 1,128. Now, kindly notice this, my lords. For this offence, all the proceeds of the crime put together in the predicate offence is about 10 lakhs, my lords. What ED does in the ECIR is they freeze accounts worth 800 crores. This is what has happened. This is where we are stuck, my lords. And in this case, when it is a TDS of 1,128.
No, that's precisely why I have in the interim order, modified order, I have told that there must, the investigating officer said, his statement was that it's something more than what meets the eye.
Correct.
So it's only a tip of the iceberg. It's only the projected is only TDS, but there's something behind.
My lords, let me take it at face value, my lords. Let's take it at face value that it's tip of the iceberg. The only prayer, my lords, I have is between June of 24 to January of 26, nothing was done. If it is an iceberg, my lords, it can't be ignored. But be that as it may, let them please defer their investigation until I finish my ED bit. I am one lady. I am dealing with, my lords, 2 large investigations going on. Suddenly there's precipitation here. Therefore, my lords, all that I seek is your lordships gave me that protection for, my lords, 1 year.
I heard both of them and then modified the order.
But that modification, my lords, is now leading to
Modification,
saying,
investigation cooperate ಮಾಡಕ್ಕೆ ಹೇಳಿ. Cooperate ಮಾಡಿ.
Cooperate ಮಾಡಿದ್ದೇನೆ. Now, apart to these 2 dates, I'm a director. What else can I do now? There is nothing else.
That we don't know. See what investigating officer wants, we don't know. And it's not that they're taking any coercive action, precipitative action against you in the garb of investigation. That also I have protected.
My lords, deferral till the end of the month is all that I seek because I have to
I will continue this interim order till the end of the month, not a problem.
Please see the interim order that your lordships had previously granted. Your lordships had said complete investigation to my lords. So I am not even seeking that. Your lordship said now please cooperate. I have done so. I have showed my lords my conduct in terms of going on the, and now I'm summoned on Friday. I have to deal with, my lords, the ED. I'm the only person of the company who's the authorized director outside. The other person is in custody. And therefore, that's the problem, my lords. Friday again, I have to go from 11 to 6.
11 to 6? Ashtot 7 hours?
11 to 6, they made 12, they called me 11 to 6. I was there till 11 to 6. It's not that I was not.
You may see the report, my report, my lord, second page. Second page.
One submission.
ಒಂದು ನಿಮಿಷ ಮಧು, I'll get 42 42 ಅಲ್ವಾ?
42.
ಒಂದು ನಿಮಿಷ ಇದು ನೋಡಿ ಮುಗಿಸ್ತೀನಿ.
ASG ಕಾಮತ್ ಸರ್
ಬರಕ್ಕೆ ಹೇಳ್ಬಿಡಿ. Yes.
Matter with your lordship, my lord, I had submitted as my lord mentioned. Last time, my lord, only one petition was filed. One more petition is also filed. That could also be, my lord.
ಆಯ್ತಾಯ್ತು.
Yes.
Wait. Quit playing games. Windsor games.
So, but the act that is coming to force will no come from any games anymore.
Yes, yes.
The act is in force now. All this is what is happening, right?
No, the Backstreet Boys.
Before your lordship sees the report, what is the allegation? Income Tax Act under 194AB, there is an amendment which said, any money being paid by an online gaming company to anybody, there should be TDS. There was an
No,
amendment,
no.
my lord, in 2006.
Sergeant sir, one nimisha. Yes, in what is it?
No, Lordship may see the report now. Fourth paragraph.
ಯಾವುದು ಇದ್ರಲ್ಲ ಕನ್ನಡದಲ್ಲಿ
Second page, next page.
ನಂತರ
Yes, ma'am.
ಹಾ
Last 4 lines.
ಅದು ನೀವು ಹೇಳೇ ಹೇಳ್ತೀರಾ
ಅಲ್ಲಲ್ಲ.
ಅಲ್ಲ see the let him also see, no problem, ನೋಡಿ
It's not a CD, my lord, we can see that.
ಸಾರಿ
I don't think, my lord, it's a CD.
ಅಲ್ಲ ಅದು ಕಾಲ ಹೋಯ್ತು ಸರ್, ಈಗ ಪೆನ್ ಡ್ರೈವ್
My lord, I meant.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ ಗಮ್ಮತ್ ಸರ್ 42 ತಗೊಂತೀನಿ. ಇದು 28 is going on between the same parties. I asked you to come because next ಅದು ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲಿ Sergeant sir, the fourth unnumbered paragraph on the next yes ನಂತರ 12/1/2026 ಅಂದು
ಡಾಕ್ಯುಮೆಂಟ್
My lord, Justice Gawai, my lord, in the last judgment has said,
ಅಲ್ಲ
this is the
ಏನು
scenario
ಕಂಪ್ಲೇಂಟ್
to say,
ಏನು
only confession is cooperation. Anything less than confession is not
cooperated.
I am a lady, I have stood there for 3 hours. In 3 hours, if they cannot get an answer from me, my lord, it talks upon their efficiency, not on mine. When the previous from 11 to 6, I am there, my lord, if they don't get an answer which they think, my lord, they deserve, it's not a scenario. All therefore.
Also, a questionnaire
No, we
which
will-
is being given, my lord. Questionnaire doesn't pertain to this transaction at all. My lord, there can't be an investigation of what the ECIR verified precisely. My lord,
That's what is happening.
ಆಯ್ತಾಯ್ತು ಒಂದು ನಿಮಿಷ.
The question is only this. They said, give me all the accounts of all the directors. Give me all your transactions that is going on. For my lord, multiple financial years. I'm happy to give it. There's no problem about it. But the allegation that is made here is one PAN card is used. That is being made into a mountain to say there is identity theft because there are millions of users. There is not another complaint on a PAN card. My lord, if even assuming this PAN card is stolen. PAN card is stolen to transfer money to that person, not to make money. There is no personal implication. There is no.
No, that is only a 1,200 rupees transaction. That's
That
all
also
right.
is paid out, not made money. It's not that the PAN card is used and the company has made. Company has paid out that money in terms of paying TDS. Net result therefore is by all means let them be. But the investigation cannot, I can't have a scenario where I'm dealing with an investigation in ED. I will deal with them in full force. I'm dealing with them. Because a parallel similar investigation being started in this scenario. Precipitate should be in this interim. Therefore, please give me the interim. By the 23rd, ED proceedings will complete at least in terms of what investigation. Let them thereafter, call me, I will continue to go. That's all my prayer is, and nothing beyond that. Your lordship have otherwise said no precipitation.
They will not take any precipitative action. See, we can't, I'll tell you, Sergeant sir. In exercise of this jurisdiction, I cannot tie the hands of the investigating officer unless I completely stay it.
There are 11 months of stay on this complaint.
I know nothing had happened.
Not
It is.
even a movement to say please vacate.
No, stay irodrinda, Allah, of course, I myself, on hearing the parties, I said, and it was accepted that we will cooperate with the investigation. There was no hitch in cooperating with the investigation. Now, yes.
I will respond to everything. Please at least exempt me from appearing before them for this 1 week. Let me finish my.
That's all right.
Let them give me anything. I will answer all of it. If I don't answer there before your lordship to say I am not cooperating.
ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಸರಿ ಕರೆದಿದ್ದೀರಾ?
ಎರಡೇ ಸರಿ ಬಂದಿರೋದವರು. ಮೊದಲನೇ ದಿವಸ ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ, ಎರಡನೇ ದಿವಸ ಬಂದಿದ್ದಾರೆ. She was there from 3 to 6. We are not disputing about it. They can't say that we have no capacity to investigate.
No,
They come with a full shield and.
That is not what Sergeant said. Capacity ಇಲ್ಲ ಅಂತ ಏನು ಹೇಳಿ.
If they cannot elicit information in 3 hours, it's.
No, that's
not correct.
Confession is cooperation ಅಂತ ಆ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದು.
I'm not saying it's
in the context of the judgment, he said, it's not, what is cooperation is confession. That's what Supreme Court has said.
We are not asking for a confession, we are asking for information. If information is a confession, let them say there's a confession, then we will not ask.
No, that we'll see. Will not tie the hands of the investigating officer. Whatever order I have passed, it will continue, but they will not take prescriptive action. That doesn't mean that you will not cooperate with the investigation.
I'm only seeking my personal appearance be exempted at least for a week so that I can finish the ED proceedings.
ED ಮುಗ್ದೋಗುತ್ತೆ ಅಷ್ಟರಲ್ಲಿ.
No, because they have to file a complaint. After they file a complaint, they will.
Of course, after they file a complaint, it's.
And that is imminent. That should happen on the 22nd, 23rd, etc. And I'm the only person out. And there are so many other accused, nobody is. In this, I have given information to them on the 3 people who misused this PAN card. 2 of them are in West Bengal, 1 is in Uttar Pradesh. There is not even a notice to them. There is another company called Real 11 which has used it. Now, where did this PAN card come from? It came from Scribe, which is the public domain. We have also found it is in Telegram. Nobody is
Scribed is in public domain, yes.
In public domain, Sajan Boya's PAN card is in public domain. That is used in 8 companies. 3 people who have used it, information is given to the investigating officer. None of them are called. I have this one lady who is a director. Unfortunately, I am facing ED proceedings.
I started day before yesterday, and they want everything to be done in.
Deferral by 1 week. I am not asking for stay of personal appearance at least so that I deal with others.
ಮತ್ತೆ ಹೆಂಗೆ ಫೋನಲ್ಲಿ ಹೇಳ್ತೀರಾ?
They will raise. They have anyway given me questionnaires. I will answer all of it. Any further questionnaires, I will receive and answer it. But let me finish. I need to make sure that my material for whatever the ED needs is available, because once that complaint goes in, I have a reverse burden in the ED case. It's not that easy for me in the ED scenario. So this 1 week precipitation, then
We'll continue the interim order. We will, no exemption, wait. ED ಇದರಲ್ಲಿ. Now come to 42.
No, he's saying he'll cooperate with us, so.
ಯಾವ್ದು ನಿಮ್ ಜೊತೆಗಲ್ಲ ಅದು.
ಅಲ್ಲಲ್ಲ, he said, I will appear before the ED authorities, I will cooperate with them ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Yes, sir.
So what survives?
No, but he is on the question of jurisdiction. That requires an answer.
I heard my learned friend just say, let me appear before the ED and give information.
On the ED's investigation, your lordships have already passed an order in no precipitation because I am already on bail. And whatever the ED has asked, it is not ED's case. After my bail, I am not cooperating, etc. The ED is not proceeding with this investigation. My reach before your lordship is on a foundational factor of whether the
Jurisdiction.
Your lordship rightly said that should be considered. It can't be an ad interim order. That could be considered. Your lordship may defer it for another.
No, what I'll do is, I'll take these matters on the 2nd of February.
May I request, subject to, of course, my lord's, may I request it now for the 23rd Friday?
This
say half day.
That's a half day. Anyway, I'm sitting short of half day.
Half day before your lordship's court is better than many days in other.
That's all.
But I'll take my chance.
23rd.
ಇಲ್ಲ ಅಲ್ಲ ಸಜನ್ 29th
ಅದು ಅಷ್ಟೇ ಅವತ್ತು 3:30ಗೆ.
29th, my lord, the learned attorney is here.
Oh, that matter is there.
Therefore, I'm seeking 23rd.
23rd early.
Very well.
I'll take my chance. And anyway, my friend will be happy to see me.
But you'll cooperate with the investigation.
I will certainly cooperate, but your lordship.
I'll extend the order. I'll extend the order. And next when are you calling?
Lord, let the cooperation in our proceedings as well.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಇಲ್ಲ. ಅಲ್ಲ ನಾವು ಫ್ರೈಡೆ ಕರೆದಿದ್ದಾರೆ, ಫ್ರೈಡೆ ಹೋಗ್ಬಿಡಿ. 11 to 6.
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಡೇ ನಾವು ಕರೆದಿರೋದೇ 3 ಗಂಟೆಗೆ, 11 to 6 ಕರೆದಿರ್ಲಿಲ್ಲ.
No, easy, sir. ಅದು ASG ಅವ್ರದ್ದು ಆಯ್ತು. That's precisely why I said cat will be out of the bag.
The petitioner's job now is to cooperate with the agencies.
I'll take this on 23rd. By then, ಯಾವತ್ ಫ್ರೈಡೆ ಕರೆದಿರೋದು ಹೋಗ್ಬಿಡಿ. ಆಮೇಲೆ you will be called only after the case is taken up.
There is an order not to that may be clarified. It says
ಅಲ್ಲ ಅರೆಸ್ಟ್ ಮಾಡಬೇಡಿ.
But
let them appear in the investigation.
He said he's cooperating. ಅಲ್ಲ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ ಬಾಕಿ ಇರೋದು.
We have never said that. I don't know where they, my learned
ಅದು
friends.
ಏನು
ಅಲ್ಲ, that
non-cooperation.
that it has been completed, I don't know where they got from.
ನೋಡಿದೀವಿ. They are better informed.
They are better informed. So I.
So.
So that itself requires investigation.
That's okay. Yes.
Permission
Now,
of my, Lordship,
yes,
one
ma'am.
submission with permission of my senior also.
Ah.
Lordship, their argument is that they cannot go to police investigation because this investigation is there. I only, because
ಅದು ಇದು ಸಂಬಂಧ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಅವ್ರಿಗೆ ಒಂಚೂರು ಸರ್ ಒಂದೆರಡು ಮೂರು ಸಮನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೋಬೇಕು ಬಂದ್ರೆ ನಾವು
ಯಾರು ಇಡಿ ಅವರ?
ಹಾ ನಮ್ದು
ಇಡಿ ಅವ್ರು ಕೋಆಪರೇಟ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ಇಲ್ವಲ್ಲ ಅವರು? Yes, that they will not. ನಿಮ್ದು ನಾಳೆ ಫ್ರೈಡೆ you take it. Next you after 23rd you may call.
No problem. One request. One request. You've asked for details of certain employees in the office and certain information about the IP address and other things. Let them come and give day after tomorrow.
ಅದು it's a 11 to 6 ಏನ್ ನಿಮ್ಮನ್ನ ಕೂರ್ಸಲ್ಲ. Information ಕೊಡಿ ಹೋಗಿ, then 23rd I'll take it. Will next investigation I will direct.
We need to seek for other people. If they provide those information, we can continue investigation. Otherwise, we will not be able to continue investigation.
One request to the lady. This entire FIR is registered pertains to this one PAN card. Now, in the guise of investigation, if you are going to be expanding the scope to say who are others who are cheated, that doesn't come under the scope of this investigation at all. Now, there are cases where there are multiple FIRs, they get clubbed along to one investigation is fine. But this is.
Sir, you mean to say an investigation on a particular incident should confine itself to that only, as if it is an encyclopedia of offences?
To that incident, my lord, the only difference is, my lord, cases of 420 that we get, my lord, the difference is you have multiple FIRs, which then is entrusted to one agency for investigation. But not, my lords, where you have a complaint and investigation is going on that, you can't seek information to say, I'll find out everything, expand scope.
No, we'll see what information they want, you just see. The 23rd you finish it, then next will be after, sorry, 23rd ಅಲ್ಲ, ಈ Friday ಏನೋ ಕರೆದಿದಾರಲ್ಲ ಅದು ಮುಗಿಸ್ಬಿಡಿ, then next investigation will be after an order passed by this court. That will.
But it's a connected matter.
ನೀವು ಯಾವ್ದು ಸರ್? ಈಗ ಕಸ್ಟಡಿ ಇರೋರು ಹಾಕಿದ್ದೀರಾ ಈಗ? Yes. No, till he made that submission, I was a little doubt. ಅಲ್ಲ, jurisdiction ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ. ಅವ್ರು ಯಾವಾಗ ಹೇಳಿದ್ರು shooting from your shoulder ಅಂತ ಗೊತ್ತಾಯ್ತು.
My friend said.
It was only a thought that got cemented after this case.
I remember an instance, you know, there was a criminal appeal that was being argued before the Lordship Justice Anandvara Reddy. Well, the lawyer was missing. He read the papers, he started dictating. It's a big case for acquittal, we'll do it. Then, my lord, I don't know from where the lawyer came running, gasping, my lord, panting. He said, no, you can't dictate an order without hearing me. Then he asked, who are you? And I am advocate for appellate. Wait, he said, no, you have to hear me. Then, my lord, he told the general proper strike off everything that we will hear. And I think it's a big case to sustain the conviction.
That's all.
I don't think that I was anyways.
ಅಲ್ಲ, ಕಾಮತ್ ಸರ್ ಇರ್ಲಿಲ್ಲ ಅವತ್ತು ಅದಕ್ಕೆ. Different story.
Churchill said that you have to watch who's behind you and not so much who's there.
Most important. Yes, sir. ಆ 23rd ಬರ್ಲಿ ಜೊತೆಗೆ ಕೊಡಿ, whatever. Heard the learned senior counsel, ಎಲ್ಲಾರ್ದು ಹಾಕ್ಬಿಡಿ, learned additional solicitor general, all names. This court, by its order dated previous order there, had modified the subsisting interim order and directed the petitioner to cooperate with the investigation. In furtherance of the said order, it transpires that the investigating agency has called the petitioner twice over and recorded certain statements, which according to the prosecution is short recorded. In that light, they have called the petitioner again on the 16th. The petitioner shall appear before the investigating officer on the 16th and whatever investigation to be conducted shall be concluded and not all day over. The learned senior counsel Sergeant Poya submits that the petitioner is cooperating with the investigation conducted by the Enforcement Directorate, who also are wanting to record statements. In that light, the petitioner shall cooperate with the investigation of the Enforcement Directorate and record statements as is now projected. The next investigation by the state will be after the direction on the 23rd. List the matter on 23rd.
With respect to petitioner.
On petitioner only, the petitioner, yes. ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದು ಅವ್ರದ ಪೆಟಿಷನ್ ಈಗ ಮೂವ್ ಮಾಡಿದ್ ನೀವು.
ಹಂಗಾದ್ರೆ ಅವ್ರನ್ನೂ ಕರೀತಿ.
No, Lordship. The interim order interim order subsisting subject to the aforesaid shall continue till the next date.
Very well, grateful.
Yes.
Lordship, 2 cats are out of the 2 bags.
At least we are cats.
No, adike let the investigation complete. We'll see skeletons from the cupboard.
Well, we have cats have 9 lives, fellow.
That is what. So skeleton agode illa.
No, and for all we know, this could be the 9th.
That Kamath says punch. Yes, sir. 42 also same. Yes, sir. Tag. Yes, sir.
504, 506
ಏನಿಲ್ಲ ಇದರಲ್ಲಿ PIL ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
Directions ಇತ್ತು my lords, ಅಲ್ಲ previous statement.
Remains absent. The petitioner is before this court seeking the following prayer. On hearing the counsel appearing for the petitioner and the state, this court on 7/1/2026 had passed the following order. In terms of this, it was clearly indicated that the second respondent's counsel had remained continuously absent, and in the event he would remain absent, the matter would be heard, the petitioner's counsel would be heard, and appropriate orders would be passed. In the light of his absence, the petitioner and the state, counsel for the petitioner and the state are heard in the matter. The petitioner is the accused, the second respondent, the complainant. A complaint comes to be registered which becomes a crime in crime number 376 of 2024 for offences punishable under section 504, 506, another 504, 506 and 34 of the IPC. The police, after investigation, filed a charge sheet in the case at hand, which is now pending as CC 8580 of 2018. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the petitioner has no role to play in the offences alleged. It is against the accused number 1 or 2 as the case would be. The allegation against the petitioner is that he has that the accused number 2 and 3 have threatened the complainant on a particular call received from accused number 1. Barring the said statement, there is nothing against the petitioner is what is projected. The learned HCGP would however contend that it is for the petitioner to come out clean in a full-blown trial, as the accused number 1 sitting in the prison has threatened the complainant to withdraw the PIL. The aforesaid not in dispute, so on. Complaint and charge sheet extract ಮಾಡಿ pages complaint ಎಲ್ಲಿದೆ?
Complaint page number 48 minutes.
Charge sheet
55.
55, 48 and 55. The offences are the ones punishable under section 504 and 506 of the IPC. The petitioner is accused number 3. The interpretation of section 504 and 506 need not detain this court for long or delve deep into the matter. What is necessary for an offence to become an allegation to become an offence under section 504, 506 is the ingredients found in section 503 of the IPC. Section 503 reads as follows. The apex court in the case of Mohammed Wajid versus State of Bihar 2023 SEC online SC page 951, interpreting 504, 506 is held as follows. If the elucidation of law by the apex court is pitted against the charge or the complaint against the petitioner, it would run foul of what is held by the apex court. In that light, allowed question. Next.
My lord, I'm the respondent number 2 in this case.
Yes.
A private complaint is filed.
Correct. 138 ಹಾಕಿದಾರಾ?
138 ಹಾಕಿದ್ದಾರೆ.
138 ಹಾಕ್ದೇನೆ private complaint ಹಾಕಿದಾರಾ?
ಹೌದು.
ಏನು ಚೆಕ್ ಬೌನ್ಸ್?
ಚೆಕ್ ಬೌನ್ಸ್. ಅಲ್ಲಲ್ಲ. Case is my lord is that 406 and 420.
ಇದು 406, 420 ಗೊತ್ತು ಸರ್.
Yes, yes.
What is the ingredient?
My lord, he has supplied certain goods. And the petitioner paid my lord some amount. And remaining amount he has not paid for the purchase of goods. For that, my lord, he has filed a private complaint.
ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
18 lakhs.
18,68,790.
18,68,000.
Goods supply ಮಾಡಿದಾರಾ?
Supply ಮಾಡಿದ್ದಾರೆ.
ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ?
Some business failure.
ಅಲ್ಲ.
Business failure ಆಗಿ
ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. All the proceedings will end.
Now civil remedy, my lord.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ.
That is civil remedy, my lord, not a criminal offense of 406 or 420.
We'll see, sir. ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ.
No, my submission, my lord.
We'll answer whether it is remedy, civil, criminal, 406, 420.
Yes.
ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ.
ಸದ್ಯಕ್ಕಿಲ್ಲ ಇವಾಗ.
Your Honor.
Wait, sir. You want money or you want something else?
Your Honor, what happened? After check bouncing, I visited him and I requested him.
No, you have not initiated proceedings for 138?
Already he has been convicted. He went for 6 months. Yes. Pleaded guilty.
He pleaded guilty, convicted. He suffered some imprisonment for 6 months. And again, he filed section for recovery 421. After that, this is filed.
It is maintainable. Supreme Court has said.
Yes, I'm not disputing whether these, my lord, allegations made in the complaint.
The peculiar facts will sustain.
Yes, my submission, my lord, my lord, in the private complaint, section 1, Priyanka Srivasta's case is not followed. Referring.
Charge sheet ಹಾಕಿದ್ಮೇಲೆ ಬೇಕಾಗಿಲ್ಲ.
What steps he has taken?
It is judgment of the apex court after filing of charge sheet Priyanka Srivatsa goes. ಆಮೇಲೆ 2025, sir.
ಗೊತ್ತು.
Yes, sir.
The ingredients of, my lord, allegations, my lord, does not amount to 420 or 406. 406 and 420 doesn't go together.
ಈ ಕೇಸಲ್ಲಿ ಹೋಗುತ್ತೆ.
ಇಲ್ಲ ಆಗಲ್ಲ.
Hold, sir. Delhi Race Club ಇದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಲ್ಲ. ಇದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಲ್ಲ.
Same judgment. I am relying upon same judgment. Whether, my lord, non-payment.
ಆಗಲ್ಲ ಯಾಕಂದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ರೆ ಅದಕ್ಕೆ. Either you'll have to travel to Supreme Court.
Right now, I don't have such amount, my lord, that amount.
Much amount ಅಲ್ಲ, such amount ಎಷ್ಟಿದೆ?
That amount, whatever he is demanding. ಇವು ಸದ್ಯಕ್ಕಿಲ್ಲ ನಮ್ಮ ಹತ್ರ.
ಎಷ್ಟಿದೆ?
ಗೊತ್ತಿಲ್ಲ.
ಏನಿಲ್ವಾ?
I will
ದುಡ್ಡು ಕೊಟ್ಟು ಸಸ್ಟೈನ್ ಮಾಡೋದೇನು ಕಷ್ಟ ಅಲ್ಲ.
I will consult my client and submit.
I'll give you 2 weeks time.
Your Honor, these are just dealing tactics.
Don't worry. Yes. When the court is with you, you should be quiet. Yes. We'll take it on, ಯಾವ ವರ್ಷದ ಸರ್ ಇದು? 25. We'll take it on 5th February. ಅಷ್ಟರಲ್ಲಿ ನೀವು ಕೊಟ್ರೆ ಪರವಾಗಿಲ್ಲ. ಆಮೇಲೆ ಇಲ್ಲ ಆನ್ಸರ್, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆನ್ಸರ್ ಮಾಡ್ತೀನಿ ತೊಂದ್ರೆ. Heard the learned counsel as Rajendra Reddy appearing for the petitioner. The issue in the list is with regard to the offence punishable under section 406 and 420. The fulcrum of the list is with regard to certain checks being issued by the accused that having been dishonored. The petitioner pleaded guilty of the offence under section 138, therefore was convicted, was housed in prison as well. Supreme Court challenge ಮಾಡಿದಾರೆ ಅದನ್ನ?
ಇಲ್ಲ.
So and so. After but no amount is paid. The respondent appearing in person submits that he initiated proceedings under section 421 of the CRPC as well for recovery of the money, and the money is not yet recovered, and therefore the offence under section 406 and 420 is sought to be registered. The amount that is to be paid is 18,75,000 and odd. The issue is whether a proceeding for offence punishable under section 406 and 420 can be initiated after the conviction. The issue is now referred to a larger bench by the apex court in the case of 2022 SSC online SC page 1010. However, the learned counsel submits that he would secure instructions from the respondent as to whether the petitioner whether would fulfill the demand of repayment of the amount.
Your Honor, I want to say something here.
Say.
Of when NI 138 case was going
And then
on.
you can't walk back in history and come to the present.
I just want to update few things here.
No, we'll
So parallelly, when NI 138 case was going on, at the same time PCR was in filed. Not after the conviction and all this. That is number one. And number two,
petition after the conviction during the subsistence of the said proceeding, the respondent had initiated for offence punishable under section 406, 420. All right.
Number two, he pleaded guilty, but check was given by zero balance account. So charge sheet has been filed and it has been converted
Don't
into
worry,
CC.
we'll see. Yes. Last chance. Ildar avattu next flight to Delhi. Yes.
Great, good.
It appears that there are two more applications that have been filed, copies of which have not been served.
Respondent in person.
Party in person.
Yenaitu, madam.
My lord, I had filed FIR against my husband and 4 more relatives, but then they have come for the squash, and in the facts of the case itself, they have lied to the court. So I have put one perjury application, my lord. I had discussed the same objections. I had raised it in the objections, but I was not heard.
Your husband is the accused, is it?
Yes.
Husband and relatives are the accused, please, my lord.
In 498,
498, 85 BNSS.
My lord, can I walk you through the petition?
No, wait.
There are 2 IAs that have been filed on
What IA?
12th. I have not been served a copy, my lord. So
Which,
I'm not-
what IA, madam?
IA number 1 and 2 of 2026.
Vacating stay. Copy kotilva.
My lord, I have served it. It went to
Because
the
IA
KGF.
number 1 and 2 of 2026, my lord, was filed on 12th. That's what the website reflects. Those copies have not been served.
12th of January.
12th of January.
My lord,
What is that?
if I go to his office, he tells I threatened him. So I served it to.
She's
through
in fact
post.
threatened, my lords. I will not go into that aspect. She's
What?
spent.
She's threatened.
She's walked into the office, threatened me, saying, "Why have you filed a complaint
Because.
against me? Why have I filed
Madam.
PCR?" My lords,
No, wait. Yes.
my lords, in fact, my colleague was threatened in the office. We have the entire recording on CCTV camera. My lords, I do not want to make such allegations before the open court while she's an advocate herself. Let us have the copy, but she's sent it by post and the post has not even been received. Hence, there's not even objections that have been raised by the
One moment.
office of the court.
One the copy kodi, madam.
ಕಾಪಿ ನಾನು ಆಲ್ರೆಡಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅವ್ರಿಗೆ ಹತ್ರ ಇಲ್ಲ. ಈಗ
ಕೊಡ್ತೀನಿ.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
Perjury application, and I want to be heard now itself because.
Now?
Yes. My
Unless you serve a copy.
he's already received the objections which I have served
Objection
in
ಅಲ್ಲ,
July.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಲ್ಲ ಎರಡು.
ಅದನ್ನೇ ಹೈಲೈಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಅದನ್ನ ಹೈಲೈಟ್ ಮಾಡಕ್ ಮುಂಚೆ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ.
1 second I need, my lord. He has the objections.
1 second you
with
take.
him.
Eye on the clock.
Please, my lord. In the FIR complaint, I have mentioned that the gold was kept in the bank locker, and in the affidavit, the petitioner has stated that the gold was kept with his mother. That I have stated in the FIR. He has mentioned like that.
ಏನಾ?
ಅಷ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ, 2 petition ನಲ್ಲಿ.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್? ಗೋಲ್ಡ್ ಪ್ರಾಬ್ಲಮ್ ಅಥವಾ ಅವ್ರ ಜೊತೆ ಇರೋ ಪ್ರಾಬ್ಲಮ್?
ಜೊತೆ ಇರಬೇಕು ಅಂತಾನೆ ನಾನು objections ಕೊಟ್ಟಿದ್ದು. Divorce on cruelty basis, and they're saying I'm of unsound mind. And he has filed PCR on me, my parents, everyone, my parents and relatives, because.
You have not challenged that?
No, because still I've not received the notice. 1 PCR got rejected because I filed perjury there also. Because he had not given one document itself.
Well, PCR was rejected basis because of Priyanka Srivastava was not followed. Subsequently, another PCR has been filed. Notice yet to be issued by the court. Now, my lords, in light
the husband.
For the husband and the relatives, there are 2
relatives will see. Husband, I will not entertain.
My lords, the peculiarity of this matter is she herself has issued a notice seeking for divorce.
No problem.
And we have replied saying we will give you a divorce. Subsequently, 6 months later, she's gone ahead and filed this complaint. We are saying we are okay to give her the divorce.
How long
now,
were you together?
5 months, my lords.
Marriage ಆದ್ಮೇಲೆ 5 months ಮಾತ್ರ.
5 months matra. In between that, she, on the day of the, where the separation happened, she has assaulted the petitioner in,
Assaulted the husband.
the husband's mother. And she has been subject, been taken to the hospital, and those records also will be placed before the court. Now, my lords, if, then also the legal notice, there are no allegations. Subsequently, these allegations come up in the complaint.
2025. I'll take this on 5th February. Serve the copies. No more adjournment on that
Yes,
date.
my lord, thank you.
Heard the learned counsel appearing for the petition of the respondent in person. Lest the matter on February the 5th, 2026. All applications filed in the case at hand shall be exchanged by the next date of hearing. ಮತ್ತೆ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಬಾರ್ದು. Yes.
ನಾನು ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ ಇವರು ಆಫೀಸ್.
ನೀವು ಏನ್ ಮಾಡ್ತಿರೋ ಮಾಡಿ. Yes.
29.
29. Yes, sir.
Pass over.
ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾಗ್ತಾ ಇದೆ?
We have filed a charge sheet, further additional charge sheet also been filed. There are
But
18
what
plus-
is, why is he here?
18 plus volumes of charge sheet.
ಅಲ್ಲ, why is he here?
Challenging the initial charge sheet.
It may
ಹೆಂಗ್
pass over.
ಉಳಿಯುತ್ತೆ?
ಅಲ್ಲ, pass over, my lord. It may pass over.
Have it on
Or else
31st.
or else it may be taken on 19th, my lord.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ಏನಿಲ್ಲ. List the matter on 5th February.
Yes. 19th, my lord. 19th.
ಇಲ್ಲ sir. 5th February.
Fresh matter, my lord.
Fresh matter. Yes. Madam, one ನಿಮಿಷ. ವಾಟ್ಸ್ಆಪ್ ಆಮೇಲೆ ನೋಡಿ ಸರ್. ಕೇಸ್ ಆರ್ಗ್ಯೂ ಮಾಡಿ.
ಅಲ್ಲ, ಕೇಸ್ 30 ಸೀರಿಯಲ್ ನಂಬರ್ ನೋಡಿ.
ಏನ್ ಸೀರಿಯಲ್ ನಂಬರ್?
ಸರ್ ಹೊರಗಡೆ ಹೋಗ್ಬಿಟ್ಟು ಅದಕ್ಕೋಸ್ಕರ.
ಎಲ್ಲಾ ಕಡೆ ಫೋನ್ ನೋಡೋದೇ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ, 7980 serial number check ಮಾಡ್ಬೋದು. My lord, last occasion the Sound Court has been directed to furnish the ID cards and other things, my lord.
Other things
ಅಂದ್ರೆ ಅವ್ರದ್ದು members to ID card ಮತ್ತೆ directors to within 7980 KP Act, my lord.
ಯಾವ್ದು interim order ಇದೆ?
7980
KP Act. Under bar, my lord. 7980 KP Act. They are playing under bar.
Has been already quashed the same.
Under bar. ಎಷ್ಟು ದುಡ್ಡು ರಿಕವರ್ ಮಾಡಿದ್ರಿ?
4 lakh changes.
ಅದಲ್ಲೇ ಇರ್ಲಿ ಬಿಡಿ, ಅದು ವಾಪಸ್ ಕೊಡಲ್ಲ. ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಎಲ್ಲ ಕಾಸ್ಟ್ ಮಾಡ್ತಿರೋದು, ದುಡ್ಡು ಸೀಸ್ ಆಗಿದ್ದು ಅಲ್ಲೇ ಇರ್ಲಿ. We'll ask them to donate it to charity.
ಕ್ಲಬ್ದು ಅದರಲ್ಲಿ ಇಬ್ರು ಡೈರೆಕ್ಟರ್ಸ್ ನ
ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಲ್ಲಿಗಲ್ ಸರ್. ಇದು ಆಲ್ ಟೆಕ್ನಿಕಲ್ ಇಶ್ಯೂಸ್ ಮೇಲೆ ಕಾಸ್ಟ್ ಮಾಡ್ತೀವಿ. ಆಲ್ ಆಫ್ ಯು ಇಂಡಲ್ಜ್ ಇನ್ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಗೇನ್.
ಸ್ಟಾಫ್ ಮೇಲೆ ಹೋಗಿ ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ.
ಅದು ನಿಮ್ದೇನಲ್ವಲ್ಲ ಬಿಡಿ, ದುಡ್ಡು ನಿಮ್ದಲ್ವಲ್ಲ, ಕ್ಲಬ್ ತಾನೆ.
ಅಲ್ಲಿ ಇಬ್ರು ಡೈರೆಕ್ಟರ್ಸ್ ಇದಾರೆ.
ಅಲ್ಲ, ದುಡ್ಡು ಅವ್ರ ಕ್ಲಬ್ ತಾನೆ.
ಕ್ಲಬ್
ಡೊನೇಟ್ ಟು ಚಾರಿಟಿ ಇನ್ಮೇಲೆ ಆರ್ಫನೇಜ್ ಗೆಲ್ಲ ಡೊನೇಟ್ ಮಾಡ್ತಾ ಬಂದ್ಬಿಡಿ. ಆನ್ ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ಸ್ ಇಫ್ ದೀಸ್ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್ ಆರ್ ಕಾಸ್ಟ್, ವಿ ವಿಲ್ ನಾಟ್ ಡೈರೆಕ್ಟ್ ರಿಟರ್ನ್ ಆಫ್ ದಿ ಮನಿ. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಅದನ್ನೇ ಮಾಡ್ತಾರೆ.
ಫಸ್ಟ್ ಟೈಮ್
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಾದ್ರು ತೀರ್ಮಾನ ಮಾಡಿದ್ರೆ ನೀವು ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಅವಾಗ ಇಟ್ಕೊಳ್ಳೋಣ. ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಆರ್ಫನೇಜಸ್ ದೇ ವಾಂಟಿಂಗ್ ಮನಿ.
ಕ್ಲಬ್ ಅಲ್ಲಿ ಎವ್ರಿಡೇ
ಕ್ಲಬ್ ಅಲ್ಲಿ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಬಿಡಿ.
ಅಲ್ಲ, ಎವ್ರಿಡೇ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಆಗುತ್ತೆ.
ಏನ್ ಕ್ಲಬ್ ಸರ್ ಇದು?
ಇಸ್ ಅ ರಿಜಿಸ್ಟರ್ಡ್ ಕ್ಲಬ್.
1500 ಏನ್ ಮಾಡ್ತೀರಾ?
ಜೆಪಿ ನಗರ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಕಲ್ಚರಲ್
ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್, ಅದ್ರಲ್ಲಿ ಅಂದರ್ ಬಾಹರ್
ಅಲ್ಲ 1500 ಮೆಂಬರ್ಸ್ ಇದಾರೆ ಮೇಡಮ್. ಸೊ ಎವ್ರಿಡೇ ಅರೌಂಡ್ 500 ಮೆಂಬರ್ಸ್ ಬರ್ತಾ ಇರ್ತಾರೆ, ಹೋಗ್ತಾ ಇರ್ತಾರೆ. ದಿಸ್ ಕ್ಲಬ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಬ್ಬರನ್ನ ಡೈರೆಕ್ಟರ್ಸ್ ನ ಪಾರ್ಟಿ ಮಾಡಿದೆ. ಸೀಸ್ 4,50,000. ದಿಸ್
ಅದು ಇಟ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತು?
So there it is. They were
ಸಪರೇಟ್ ನೋಟ್ ಅದು.
under bar, my lord. Amount was seized.
ಅಮೌಂಟ್ ವಾಸ್ ಸೀಸ್ಡ್. ಈ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಂತಾನೆ ಏನ್ ಗ್ಯಾರಂಟಿ? ನೀವು ಮಾಡೋದು ಸರಿಯಾಗಿ ಮಾಡಲ್ಲ. ನೀವು ಎಲ್ಲ ಹ್ಯಾಪಿ ಆಗಿ ಮಾಡ್ತೀರಾ. ಯು ಲೀವ್ ಲೂಪ್ ಹೋಲ್ಸ್ ಇನ್ ಲಾ ಅಂಡ್ ಎವ್ರಿಬಡಿ ಗೆಟ್ ಅವೇ. ಅದಕ್ಕೆ ಏನು ಕರೆಕ್ಟ್ ಆಗಿ ಪ್ರೂವ್ ಆದ್ರೆ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಬಾರ್ದು. ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು ನೀವು ಅದನ್ನ. ಸೊ ಇನ್ನೊಂದರಲ್ಲಿ ಜಗದೀಶ್ ಸರ್ ಹೇಳಿದ್ರಲ್ಲ, ಮುಂದ್ಗಡೆ ಬೇಕ್ರಿ, ಹಿಂದ್ಗಡೆ ಎಲ್ಲ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಹೌಸ್.
ಸಿನ್ಸ್ ದಿಸ್ ಕ್ಲಬ್ ಇಸ್ 1980-81 my lord.
ಆಯ್ತಾಯ್ತು. ಇದ್ರಲ್ಲೇನ JP Nagar residents welfare, don't do that.
Similar matter, my lordship has been passed.
Yes. Name order. Next.
Public. Page 21 is the complaint. I want to kindly turn to page 23. No single allegation against A2. A2 is before your lordship.
All right. Respondent, complainant yaru?
The bank, Indian, that's the bank.
Bank.
ICICI Bank.
ICICI Bank. Serve ಆಗ್ಬೇಕಲ್ಲ ಮತ್ತೆ ಅವ್ರಿಗೆ. Heard the learned senior counsel, P.R. Ramesh appearing for the petitioner. This court on 5/1/2026 had passed the following order. No notice was directed against the complainant. Since the complainant is necessary to be heard in the case at hand, a petitioner shall serve on any panel counsel representing the complainant ICICI Bank. ICICI ಏನಿದು? ICICI Bank. List the matter on 5th February. Interim order subsisting will continue to the next date. Not to file charge sheet if not already filed.
Please.
Investigation ಇದು ನಡೀತಾ ಇರಲಿ.
Blood offenses is 419, 406, 420, 465 and 468, 471 Mallots. Complaint incident started happening in the 2020 anta ಹೇಳ್ತಾರೆ. Complaint has been registered on 2023 24/5/23 Mallots. Entire complaint is like 6-page complaint ಇದೆ Mallots. Entire complaint ಮೇಲೆ complaint ಅಲ್ಲಿ ನನ್ನ ಮೇಲೆ allegation.
Coordinate bench has permitted continuance of investigation. So what is the stage of investigation?
Almost completed, my lords. In another week or 2 weeks, my lords, we will file the charge sheet.
But the problem is they are
Who is the investigating officer is here? Since the investigation is already permitted, we'll see. Don't file the charge sheet without the leave of the court. 2 weeks bit, I'll post the matter. Heard the learned counsel Anita SM appearing for the petitioner.
There is a protection order anta
adide enide.
Just because of that, I'm keep on harassed by the police officer.
No, wait, we'll see. Yes. Because of the coordinate bench's order, I'll have to follow it. Heard the learned counsel Anita SM appearing for the petitioner. The learned counsel, the coordinate bench of this court on 25/9/2025 had passed the following order. The coordinate bench had clearly held that in the garb of investigation, the petitioner should not be repeatedly called and unnecessary summons be issued or harassed. The investigating officer is present. What's his name? Bharat S. Reddy is present before the court and would submit that if 2 weeks time is granted, the investigation would stand concluded and a final report would be ready to be filed before the concerned court. In the light of the order of the coordinate bench, I list the matter on 5th February. The final report shall not be filed without the leave of the court on the next date. Yes.
Melods, I was in the 14 days police custody le idde Melods. Now
Aito.
they were like lookout notice ಆಗ್ತೀನಿ.
Madam, there is already an order of the coordinate bench. That is the reason. Yes. Ian, what is the offense?
419.
Getting to one chomstick.
Chomba.
Testing of a metal. I owns a company to conduct the metal test Melods. I'm a scientist.
ಏನು ಚೊಂಬ್ ಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವರು?
No Melods. A1 sent me a metal sample Melods.
ಏನ್ ಅಲಿಗೇಷನ್ ಅಂದ್ರೆ ಚೊಂಬು ಅಂದ್ರೆ ಹೆಂಗ? Yes. List on 5th.
Grateful.
The respondent.
I have to secure the records, my lords.
25 stay ಇದೆಯಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ದಿ ಗ್ರೌಂಡ್ ಆಫ್ ಡಿಲೇ ಐ ಎಕ್ಸ್ಪ್ಲೈನ್ಡ್.
Investigation conducted till date. ಏನು offense?
64, page number 26, my lord of the complaint. I invite my lords to page number 27. my lords.
ಏನು offense?
64.
Rape.
ಮಾಡಿಲ್ಲ ಅದು ಅಲಿಗೇಷನ್ಸ್ ಅವರ.
ಅಲ್ಲ ಕರೆಕ್ಟ್.
ಅಲ್ಲ 2 minutes.
ಏನ್ ಡಿಫೆನ್ಸ್?
Defense, last time he said affair ಇದೆ, ಅದು ಇದೆಲ್ಲ, which your lordship.
When I lodged the
Ultimately, your
complaint-
lordship was pleased to inform to secure the records, considering the complaint. Therefore,
Correct.
Lords,
ಎಷ್ಟು ವರ್ಷದಿಂದ ಗೊತ್ತು ಇವ್ರು ನಿಮ್ಗೆ?
My lords, 2 minutes, page on 27, my lords, sorry.
ಪೇಜ್ ನಂಬರ್ 27.
27 ಹೌದು. Our complaint.
ಅದೇ ಅಲ್ಲೇ ಇದೀನಿ 36 ಅಲ್ಲಿ ಇದೀನಿ.
36 ಬೇಡ.
ಯಾಕಂದ್ರೆ ಸೆಕೆಂಡ್ ಅದು.
ಅಲ್ಲ 27 ಪೇಜ್ ನಂಬರ್ our complaint.
27 ಹ್ಯಾಂಡ್ ರಿಟನ್ ಸರ್.
ಹೌದು, manuscript.
ಯಾಕೆ ಟೈಪ್ ಕಾಪಿ ಇಲ್ವಾ? ಮಾಡಿಲ್ಲ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಈಗ.
Sorry.
ಹ್ಯಾಂಡ್ ರಿಟನ್ ಹೆಂಗ್ ಹಾಕಿದ್ರಿ ಇಲ್ಲಿ?
I'm sorry, my lords.
ಏನ್ 27 ಅಲ್ಲಿ?
Actually, page, para number 2, my lords. When the matter stood thus, I got introduced to Mr. Himanshu, that is the petition number 1, who is the brother of Imantika, that is the petition number 3, and Mr. Sanjay Kumar, who is the petition number 2, who is my maternal uncle of Himanshu during the December 2024. On occasion, Himanshu and Sanjay visited my residence along with Imantika when I had invited only Imantika for the lunch during the December 2024. Thereafter, on 21/12/2024, as Himanshu already knew my residence and so on, so on. 2 point, my lords. They say that I got introduced on the December 2024. I was not in India at all. I came to India on 17th of December 2024, my lords.
ಇದು ಯಾವತ್ತು?
ಇದು ಅವ್ರು ಹೇಳೋದು ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ ಹೊರತು
ಡೇಟ್ ಇಲ್ವಾ?
26/12.
So the second point is, my lords, 21/12 ಅಲ್ಲಿ ನಾನು ಇಂಡಿಯಾದಲ್ಲಿ ಇದೆ, because 17th is the visa, 23rd only for 5 days I came to India to be next
5 days ಅಲ್ಲಿ ಇದೆಲ್ಲ ಆಗೋಗಿದ್ಯಾ?
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಯಾಕಂದ್ರೆ ನಾನು ಹಾಕೋದ್ ಮೇಲೆ ಇವನ್ನೆಲ್ಲ ಮಾಡಿರೋದು ಅವರು. This is in respect of petition number 1 is concerned. My lords, if my lords please turn to page number 29, my lords, para number 2. When this being the situation on 26/12, this allegations is against the petition number 2. So petition number 1 ಗೆ 21/12 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. If I have already committed a crime on 21/12, my lords, why did they allow me inside on 26/12, my lords? My lords, third point, my lords, page number, my lords.
Point to be noted.
ಅಲ್ಲ, ಅದು ಏನಾಗುತ್ತೆ ಒಂದೊಂದ್ಸಲಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ತಮ್ಮ ಮುಂದೆ ನಮ್ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಮನ್ಸೊಳಗಡೆ ಅಯ್ಯೋ ಹೇಳ್ಬೋದಾಗಿತ್ತು ಸಾಹೇಬ್ರಿಗೆ. And my lords, 26/12 ಅಲ್ಲಿ ನಾನು FIR ಹಾಕ್ತೀನಿ 498 ಅಲ್ಲಿ. My lords, the FIR came to register at on 12 ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆಗೆ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. I produced the FIR copy. The incident has taken place on 26/12 according to the complaint. The FIR
ನೀವು 498 ಹಾಕಿ.
ನಾನು 498 ಅಲ್ಲಿ petition number 3 has lodged.
Petition number 3.
ಹೌದು.
Yes.
If my lords please come to.
All right.
Page number 15.
Yes. Investigation papers.
I will secure.
You will secure it. I will stay everything now. If you don't, this is on 8/1/2026. I have directed you to secure the records.
Earlier stay was been granted, my lord. Unfortunately, my lord.
It was granted.
Yes.
Unfortunate again, I think.
Then the stay application put up. And Mahesh also, I hope he doesn't dispute about that. After arguing, my
ಈಗ put up ಆಗಿದೆಯಾ?
Earlier ಅಂದ್ರೆ other bench ಅಲ್ಲಿ, and the last occasion he did not dispute. ತಾವು ಕೊಡ್ಲಿಲ್ಲ. Investigation ಇಲ್ಲ ಇದೆ.
ಏನಿದೆ?
Complaint ಅಲ್ಲಿ.
ರೇಪ್ ಇದೆಯಾ?
ಇಲ್ಲ, ರೇಪ್ ಅಂತ. But other offenses, sexual offenses are certain. They should also tell you the reason as to why there was a delay. And sexual offenses, my lord.
What is rape here? 64 ಯಾಕೆ? 64 ಯಾಕೆ ಮತ್ತೆ?
ಪೊಲೀಸ್ ಅವರು ಹಾಕಿದ್ದಾರೆ.
ಏನ್ ಬೇಕಾದ ಹಾಕ್ತೀರಾ ನೀವು? ಅವ್ ಕಂಪ್ಲೇಂಟೇ ರೇಪ್ ಅಲ್ಲ, ಅದು ರೇಪ್ ಹಾಕೋದು
ಅಷ್ಟೇ.
ಏನ್ ಅಷ್ಟೇ?
ಅಲ್ಲ ಸಾರಿ, ನಾನು ಕಲಿಗೆ.
Why sir? Clarified. Is there a complaint about rape here?
I mean, attempt ಇದೆ, he has.
ಅದು 511. 511 ಹಾಕಿ ತೊಂದ್ರೆ ಇಲ್ಲ. 64 ಹೆಂಗ? 64 is 375 sir.
That I am not disputing that also.
376.
164 ಆಗಿದೆ ಅಂತ. That's what my instruction is. Therefore, your lordship was pleased to
see the records, Devraj. Until
ಅಲ್ಲ, ಮತ್ತೆ ನಮ್ಗೆ
ಏನ್
had the benefit of it, but I'm not in a position to enjoy it.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, that is the difficulty.
6 ತಿಂಗಳಿಂದ ಏನೂ ಆಗಿಲ್ಲ. Let them secure. If there is nothing.
Appears to be frivolous.
That I will submit. I will reserve my submissions after my friend Devraj submits.
6 months. ನಾನು 2 ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ಮೇಲೆ ಬರ್ತಾರೆ ಇವರು.
ಅದರಲ್ಲಿ
My lords in their own judgment allowed 2 ಜಡ್ಜ್ಮೆಂಟ್ on them.
ಬೇಕಾದಷ್ಟು ಬರುತ್ತೆ.
ಅಲ್ಲ, ತಾವು ಇದು ಇದೆ, ಡಿಲೇ ಮೇಲೆ ಕ್ವಾಶ್ ಮಾಡೋಗಿಲ್ಲ ಅಂತಾನು ತಾವೇ ಬರ್ತಿದ್ದೆ.
ಎಲ್ಲ ನಾನೇ
ಅದಕ್ಕೆ.
Until then some security.
ಏನಾಗಿದೆ? ಏನಾಗಿಲ್ವಲ್ಲ? ಅರೆಸ್ಟ್ ಮಾಡಿದಾರಾ? ಬೇಲ್ ಇದೆ ಅಲ್ವಾ?
ಬೇಲ್ ತಗೊಂಡಿಲ್ಲ.
ಯಾಕೆ 6 ತಿಂಗಳಾದ್ರೂ ಏನು ಮಾಡಿಲ್ವ ನೀವು ಬೈಲ್?
My lords, I had to come back again from Dubai, my lords.
Oh, where are you?
I'm not in India, my lords. Only for to assist my sister, I came to India, my lords.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಸರಿ, ಅದಕ್ಕೆ ಅಸಿಸ್ಟೆಂಟ್ ಸುಮ್ಮನೆ ರೆಂಡರ್ ಮಾಡಬಾರ್ದು.
ಅದೇ ನನಗೆ ಇವಾಗ ಅನಿಸ್ತಾ ಇತ್ತು, ನಾನು ಯಾಕಾದ್ರೂ 3 ದಿವಸ ಬರಕ್ ಹೋದ್ನ India.
ಮತ್ತೆ
It was
ಯು ಆರ್ ಬ್ಯಾಕ್ ಟು ದುಬೈ?
ಅಲ್ಲ, I work in Dubai, my lords.
ಅಲ್ಲ, ಈಗ ನಾವು ಯು ಆರ್ ಬ್ಯಾಕ್ ಟು ದುಬೈ?
Now I'm back to
ಅಲ್ಲೇ ಇರಿ, ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್
until then.
ದುಬೈಲಿ ಇದ್ದೀರಾ, ಯಾಕೆ ನೀವು ಸ್ಟೇ ತಗೊಂಡು ಏನಾಗಬೇಕಾಗಿದೆ?
Number 2 is suicide in Uttar Pradesh. 3 ಜನರ ಮೇಲೆ ಹಾಕಿರೋದು, ನಮ್ಮ ಅಂಕಲ್ ಮೇಲೆ, ನಮ್ಮ ಅಣ್ಣನ ಮೇಲೆ, ನನ್ನ ಮೇಲೆ.
Yes, we'll see next time. Investigating papers ಕೊಡಿ. List the matter on 2nd February in the fresh matters list.
Great.
ಅವತ್ತು ನೋಡುವ.
Please.
Next.
Back to appear first. Case and counter case. I have filed complaint.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ
ಇವ್ರಿಗೂ ಕೊಟ್ಬೋಣ, ಅವಾಗ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂದ್ರೆ ನೀವಿಬ್ರು ಹಿಂಗೆ ಹೊಡೆದಾಡ್ತಾನೆ ಇರ್ತೀವಿ. ಏನು ಅಸಾಲ್ಟ್ ಯಾರು ಮಾಡಿದ್ದಾರೆ?
ಅವರು ನನಗೆ ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರು, ನಾನು ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ. ಸಿಸ್ಟರ್ ಇಲ್ಲ,
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್,
ಹಸ್ಬೆಂಡ್
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್.
ಹೌದೌದು.
ಹಂಗಾರೆ ಏನು ಅಸಾಲ್ಟ್ ಇಲ್ಲ, ಬರೀ ಸಾಲ್ಟ್. ಎಸ್, ಸೊ ಯು ಕ್ಯಾನ್ ಸೆಟಲ್ ಅಂತ ಹೇಳಿದ್ದು. In the light of the interim order subsisting in the companion petition, there shall be an interim order stay in NR Naik's case also. Since the members of the family are the warring parties in the case at hand, I deem it appropriate to direct the parties to explore the possibility of settlement and report such settlement on the next date. List the matter on 6th February.
Please.
Settle ಮಾಡಿ.
Please.
For the petition.
Charge sheet ಹಾಕಿದ್ಯಾ?
Split up charge sheet.
ಸ್ಪ್ಲಿಟ್ ಅಕ್ವಿಟ್ ಆಗಿರೋದು ಯಾವ?
1595
offense ಏನು?
399.
Application number 482 ಇದೆ ಸ್ವಾಮಿ.
399 402.
Preparation.
ಆಯ್ತು, ಈಗ ಸ್ಟೇ ಮಾಡಿರುವ ಕಂಪ್ಲೀಟ್ ಇದ್ದಾಗ ಮಾಡೋಣ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್
ಅದರ್ ಅಕ್ಯೂಸ್ ಗೆ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಸರ್.
ಗೊತ್ತು ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ. Yes. They list the matter on 6th February. There shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing in the light of other accused getting acquitted and the split charge being drawn against the petitioner. Iva time illa adike. Out madu.
Petitioner mother, this is a counter case.
Respondents.
The family members.
Oh, adana don't take cue from that order.
Oh, sir.
ಅದೇ ತರ ಇದರಲ್ಲೂ ಹೇಳ್ತೀನಿ, ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
And even they were.
My lords, I appear for the next matter, my lords. Next matter, this honorable court has already granted stay. It's case and counter case, my lords. The first complaint was of mine. The second complaint, that crime number 147 is of mine.
First blow ಯಾರು ಕೊಟ್ರು? Who gave the first blow, sir?
First complaint is mine.
ಅಲ್ಲ,
Second complaint.
ಇದು ಏನು? ಬ್ರದರ್ಸ್?
Lords,
Between the sister and
between the brothers, civil dispute is pending. When the civil dispute is pending,
There are only brothers in this or others are there?
others also are there.
others.
And entire family members are there.
Family members are stay.
ಎಲ್ಲ revolves around family.
Yes, my lords. But unfortunately, they made even the school going kids and the college going kids also the bar pulled down to
ಯಾಕೆ ಇದೆಲ್ಲ?
litigation.
ಏನ್ ಸಿವಿಲ್ ಸೂಟಾ?
How civil suit is pending, partition suit is pending before the.
ಇದಾದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಅಂತನಾ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿದ್ರೆ ಎಲ್ಲ ಪ್ಯಾಕೇಜ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಸಿವಿಲ್ ಕೇಸ್ ಹಾಕಿದ ತಕ್ಷಣ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕ್ಬೇಕು. ಅದು ನನಗೆ ಗೊತ್ತಿದ್ದು ಫ್ಯಾಮಿಲಿಗೆ 498 DV Act 125/24 ಇದ್ರಲ್ಲೂ ಆಗ್ಬಿಟ್ಟಿದೆ.
Sister had filed a suit for partition. One advocate has involved into the fourth son is an practicing advocate. He was restored into confidence and a partition was made. A compromise petition was done, in which 5 members are there, 40 acres are each should get 10 acres, my lord. Subsequently, after the compromise, we got to know only 6 acres was given to the share of other members. They have taken more than 22 acres for. No, that is under challenge.
That is pending.
Subsequently, my lords, now he's trying to alienate the property. Lebanese sketch was applied, and when he was measuring the land, then this quarrel started.
ಮೆಜರಿಂಗ್ ಅಲ್ಲ, ಮನೆ ದಾರಿನ ಮಾಡ್ಕೊಳ್ಳೋ ಸಮಯದಲ್ಲಿ ಅದು ಗಲಾಟೆ ಆಗಿರೋದು.
ಆಯ್ತು.
ಇವನ್ ಪಾರ್ಟಿಷನ್.
Yes. Sudhindra,
Please.
look into it. Use, both of you use your good offices to close, not to generate litigation.
Yes.
ಯಾಕೆ ಬೇಕಿದೆ?
Yes,
ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ, ಏನಿದೆ ಅದು?
ಆಯ್ತು.
ಅದು ಪ್ರೀವಿಯಸ್ ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್, ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಸೇಮ್ ಆರ್ಡರ್, ಸೇಮ್ ಡೇ.
Please.
ಎಸ್.
Stay. And the second case is already stay is granted, interim order may be
Interim
extended.
order in the second case stands extended, interim order in the first case stands granted.
Great.
ನಿಮ್ಗೆ ಇರ್ಬೇಕಾದ್ರೆ ಅವ್ರಿಗೆ ಬೇಡವಾ?
ಕೊಡಿ, I am not objecting for it. Grateful.
ಫ್ಯಾಮಿಲಿಲಿ ಎಲ್ರಿಗೂ ಸ್ಟೇ ಇರಬೇಕು.
Yes.
ಒಬ್ರಿಗೆ ಸ್ಟೇ ಇದ್ದು ಇನ್ನೊಬ್ರಿಗೆ ಸ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ.
Great.
ಈಗ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಇಲ್ಲ ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Please.
ಎಸ್. ಎಸ್ ಮೇಡಮ್.
ಅಫೆನ್ಸ್ ಬಂದು 304B ಮತ್ತೆ 498.
304B 498 lethal combination, nothing. ನೀವು ಹಸ್ಬೆಂಡ್ ಸಾಧ್ಯವಿಲ್ಲದ ಮಾತು. ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡ್ಬಿಡಿ. ಅದು ಆದಂಗಿದೆ 227, ಅದು ಆಗೋಗಿದೆ. ನೋ ಮೇಡಮ್.
ಒಂದೇ ಒಂದ್ ಸೆಕೆಂಡ್.
ಏನು
ಇಲ್ಲಿ ಏನ್ ಮದ್ವೆ ಆದಾಗಿಂದ ಇಲ್ಲಿ ಟಿಶ್ನನ್ನ ಬಿಟ್ಟು ತಾಯಿ ಅವ್ರು ಏನಿದ್ದಾರೆ ಅಲ್ಲೇ ಅವ್ರ ಜೊತೆಯಲ್ಲಿ ವಾಸ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಸಪ್ರೇಟ್ ಇದಾರಲ್ಲ.
304B
ಅಲ್ಲಿ ಅವರೇ ಮಾಡ್ಕೊಂಡಿದ್ದಂಗ್ ಬಂದು, ಬಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಅವರೇ ಕೊಲೆ
cruelty and dowry death is a lethal combination, will not do that. Difficult. Yes, ಏನ್ ಮಾಡ್ತೀವಿ?
ಬಾಡಿಲಿ ಯಾವ್ದೇ ಅದೊಂದ್ ಬಿಟ್ರೆ ಬೇರೆ ಯಾವ್ದೋ ಅದು ಡೌರಿ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ದಾರೆ
ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ನೋಡಿ, ಫೋಟೋಗ್ರಾಫ್ ಸರ್ ಹಿಯರ್ ಸೆಂಟ್. The daughter-in-law is 302 ಇಲ್ಲ ನಿಮ್ ಪುಣ್ಯ.
ಚಾನ್ಸ್ ಕೊಡ್ಮೇಲೆ ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ, ಹಾಗಾಗಿ ಅವ್ರು ನನಗೆ
ಕೇಸ್ಗೂ ಹುಷಾರಿಲ್ಲ. ಕೇಸ್ is also not well.
ರಿಕ್ವೆಸ್ಟ್ ಒನ್ ಶಾರ್ಟ್.
No madam. Yes. Dismissed. ಆಮೇಲೆ ಬರ್ಕೊಂತೀನಿ. Yes, next.
Picked up case number 38.
List on 6th February. Interim order idea?
Illa.
In the light of the acquittal of the co-accused, there shall be an interim order of stay of further proceedings quae the petitioner till the next date of hearing. List on 6th February in admission. We'll dispose it on that day. Your time illa. Yes.
39. Dance class ಗೆ ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
Dance class ga?
Dance class. Classes ಗೆ.
You had rented the premises for a dance class?
Dance class. They have not
What
paid
has
rents. They did not pay rents. And then we exchanged legal notices. Adadmele in the legal notice, she in the advance legal notice, she says, I'll file a sexual harassment case against you. In the advance legal notice.
I'll file ಅಂತ threaten ಮಾಡಿದಾರೆ.
Threaten ಮಾಡಿ, then they have filed. ಅದಕ್ಕೆ ಮುಂಚೆ ಇನ್ನೊಂದು ಸ್ಮಾಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆ, ಅದಕ್ಕೂ she has filed.
So this is dance without music.
ಅದು ಕ್ಲಿಯರ್ ಆಗಿದೆ 56.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. The petitioner is before this court calling in question proceedings in charge sheet agilla.
Charge sheet agilla.
In crime 4, ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆ ನಂಬರ್, ಬಟ್ ಹಳೇದು. Crime number 420 of 2025. The learned senior counsel submits that the complainant is a tenant running a dance class in the premises owned by the petitioner. Rent is not paid, rent is demanded. Legal notice is caused, and in the legal notice it is already indicated that if you demand rent, I will file a case for sexual harassment against you. Eventually it is filed. Therefore, there shall be an interim order of stay of further proceedings, further investigation by the petitioner till the next date of hearing. Next.
Please. Obliged.
One HCGP, madam, one HCGP, 2 emergent notice ಅಂತ ಮಾಡಿ.
Please.
Next.
lordship, insofar as serial number 40.1 is 40 is concerned.
ಏನಾಯ್ತು?
My lords had said that some observations have to be made.
Shadi.com.
My lord, observations may be made, my lord, because, but the only thing is, my lord, here we're looking at also the victims, my lord, she's also going through counseling. It's not really, in fact, what I did, my lord, last time has done more damage.
Settle
because-
ಮಾಡ್ಕೊಂಡ್ರಾ?
My lord, no monetary transaction. I've only said there's an acknowledgement.
Where are the parties?
Parties are all here, my lord. My lord, accused number 1 is in JC. His father's filed an affidavit on his behalf.
Who's the complainant?
Complainant here. She's here.
Who's accused number 1 is in JC?
Yes. May I just place the settlement on record, my lord? There is an acknowledgement saying that yes, there was a relationship. There's an acknowledgement also. There's an apology which is also given from their side. Because there were 3 families involved, my lord, and we also tried to sit across and then see if we can do anything.
That's all right, yes. Who is the accused number 1?
The accused, insofar as serial number 40.1 is concerned, is accused, the petitioner is accused number 1. In serial number 40, the petitioners are accused number 2 to 5, who are the family members of accused number 1.
Why family members are drawn into the web of crime?
They have also been arraigned as
Why?
parties.
If my lords were
Why,
to recall,
sir?
my lord, if my lords were to recall, this is where, my lord, the videos.
All right, but why family member? The accused number 1 has circulated,
Okay, my
may
lord,
have been, may have circulated.
Since we are settling the matter, I don't want to go into the merits, but I'm just saying one thing, my lord. If my lords were to
No,
recall,
why
this is where.
indiscriminate roping in of family members?
This is where, my lord, if my lords were to recall, I said that we had a profile on Shadi.com. He introduces me saying that this is his
That
parents.
is all fine.
There were, my lord, incidents which happened in the, my lord, in the same house. I don't want to go into that, my lord, because now it may not be right that they're here also. I may not.
All right, it's okay. Let bygones be bygones. All is well that ends well.
Please.
In offense of rape illa tane idra?
Illa, 69, my lord.
Promise to marry.
Please. Deception, because what the word is used is deception.
Deception on promise to marry.
Please, please.
In fact, 69 and 351 of the BNS is.
May I just give my wakalat also in the connected matter?
The learned counsel Siddharth Suman enters appearance for the respondent complainant.
Respondent number 2 in the connected matter, 40.1. Adral agli ide, 40
The
ide.
subject crime. Eradu nimdena?
In fact, in serial number 40, I've just now handed over my NOC Vakal.
Yavudralli sir?
Serial number 40 now.
You are appearing, is it?
Yes, instead of Mr. Uday Prakash Mulia.
Tagiladna?
Yes, please.
The registry to print the name of Samir Sharma as appearing for the petitioner in place of Uday Prakash. The subject, these petitions arise out of as a crime that is registered in crime number 209 of 2025. Let me not observe. We'll do it in an appropriate case. Yes, I'll not get it. During on registration of the crime, the accused number 1 is said to have been taken into custody and still remains in custody. The parties to the list have now settled the dispute amongst themselves and have drawn certain conditions, by drawing certain conditions of such settlement. Compounding application hakidira?
Ide, my lord.
Yes. And have filed an application seeking compounding of the offense. Compounding
hakilla. Adu joint affidavit with.
I filed a joint affidavit. The joint affidavit reads as follows. Tumba hakidira, give an electronic copy of this.
Sorry, my lord.
Give an electronic copy of this.
I'll do that.
Yes.
I'll do that. I'll do that.
So and so. In the light of the settlement arrived at between the parties as noted here in above in the joint memo, notwithstanding the fact that the offense is the one punishable under section 69 of the BNS, I deem it appropriate to accept the joint memo, obliterate the proceedings, qua the petitioners in both these cases. In the light of stay kottidina illala?
Illa stay illa.
In the light of the accused number, what's his name?
Vedic Viresh.
So and so, in the light of the accused number 1 being in judicial custody and it's a matter being settled between the parties, a direction is to be issued to the prison authorities to release the petitioner forthwith in accordance with law. We release accused number 1 in accordance with law. For the aforesaid reasons, the following order. The criminal petitions stand disposed. The crime in crime number so and so Crime number 20, ಇನ್ನೊಂದೇನು ಒಂದೇನಾ?
ಒಂದೇ.
Crime number 209 of 2025 stands quashed against these parties. The accused number 1, who is, the registry is directed to communicate this order to the prison authorities to release the accused number 1 without broking any delay in accordance with law. Ordered accordingly.
I'm grateful.
Yes.
Grounds of arrest, my lords.
Not grounds of arrest, my lord. Accused was not produced before the magistrate.
ಏನು settlement? Operative person. ಇದು
Not the accused.
Siddharth or Samir, the recent order, I'll release the operative portion now itself.
Please.
So direct the registry, I've already directed the registry.
Please.
Let there not be a delay.
That email, if it can go, my lord, because
That
that
registry
becomes.
I have directed to
Please.
communicate, then that will happen. But the signatures ಮಾಡು.
ಅದನ್ನ ಮಾಡ್ತೀನಿ. Please. Great.
Accused was,
Next week, my lords, I'll secure the record.
Lord, the accused was not produced before the magistrate within 24 hours.
ಯಾವುದು ಸರ್ ಇದು?
The serial number
41, serial number 41.
41
Page number 60, my lord, arrest memo.
24 hours ಆಗಿಲ್ವಾ?
24 hours ಆಗಿಲ್ಲ. 1 hour 55 minutes of delay ಇದೆ.
Yes, sir.
From the official arrest, my lord, there is 20.
I'll get the records, my lords, grounds of arrest.
ಮೊನ್ನೆ ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಸ್ವಾಮಿ, ಮಂಡೇ ಇತ್ತು.
ನೀವು ಈ ತರ ಆದ್ರೆ ಆಗಲ್ಲ. ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕು ಅಂತ ಬರ್ಬೇಕು. ನೋಡಿ 12/1 ಆಗಿತ್ತು.
Page number 60, Swami. Entire records I have only produced, my lord.
Monday,
Arrest memo also I have only produced. Page number 60, column number
Bail
5.
court ಹೋಗ್ಬೇಕು actually. ಅದು 24 hours ಅಂತ ಹೇಳ್ತಿರೋದ್ರಿಂದ I am entertaining ಅಷ್ಟೇ. We'll see. List the matter on Monday 19th in the fresh matters list. In the event the order dated 12/1/2026 is not complied, this court would be constrained to direct release of the petitioner from prison.
Much obliged.
Yes. Next.
My lord, I'm for responding, my lord. The other 4 matters, my lord, listed on the 3rd February, my lord. Furnishing list, my lord.
ಏನು?
Other 4 matters, listed tomorrow, my lord, given date on 3/2026.
ನಾಳೆನಾ?
Yesterday.
Yesterday,
4 matters.
yesterday na tomorrow na?
Yesterday, my lord. Listed 3-4 matters. Furnishing the 4 list of, my lord.
ಕೊಡಿ tag along with me. ಅದ ಅಬೇಟ್ ಆಗೋಗಿದೆ.
ಇಲ್ಲ ಆಗಿದ್ದಿಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಸಿ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೆ.
Sir, the petitioner is no more, ಅಬೇಟ್ ಆಗಿದೆ.
ಹೌದಾ? They moved matters, my lord. They moved the matter.
ಹೌದು ಸರ್,
Please.
ಅಬೇಟ್ ಆಗಿದೆ ಅಂತ ಮೂವ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ.
Please.
Petitioner is no more, ನೀವೇನ್ ಮಾಡ್ತಿರೋದು? ಎಸ್, ನೆನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ, ಅದು ಕೊಟ್ಬಿಡಿ ಮಾಡಿ. ಅದಕ್ಕೆ ಮಾಡಿ. ನೆನ್ನೆ ಆಗಿದೆ. Next.
Petitioner, my lords, I seek for a short date, my lord, since 420, 409, and 120B.
Next week.
Yes, for any date.
Next.
And serial number 52.
23rd. 20, ಯಾವತ್ತು ಮೇಡಮ್ ಇದು? 25, 24. List on 21st.
Okay.
Agata?
Serial number 52 also. Serial number 52, my lord.
Yes, 24, list on 21st, yes.
My lord, the stay was granted by this honorable court, but to stay the investigation, my lord. Yet they have filed a charge sheet, my lord. Even after the intimation to them, my lord.
Yes, sir. Comment.
Yes, sir. Let's say charge sheet was filed on May 24,
Interim order ಯಾವತ್ತು ಸರ್?
27/8/2024.
ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
18/5/2024.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಬೇರೆ ಏನೋ ಗ್ರೌಂಡ್ ಇದೆಯಾ?
Page 9, my lord.
27th August, my lord.
27th August is the interim order, sir.
Yes, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ಯಾವತ್ತು?
In the month of September, my lord.
ಹೌದಾ?
Yes, my lord.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
My lord, sir, page 9, my lord.
9 of?
18/5/2024.
Page?
My lord, sir, page 9 in my paper book.
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
Additional.
I have filed an I-8 along with that I filed charge sheet as well.
Sir, 18/5, sir. What is this?
ಚಾರ್ಜ್ ಶೀಟ್ ಡೇಟ್ ನೋಡಿ ಸರ್ ಅಲ್ಲಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ನಂಬರ್ ಆಗೋದು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಆದಾಗ ದಟ್ ಇಸ್ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಿ filing of the charge sheet. Or they have presented the charge sheet long before the interim order was granted.
Please, my lord. My lord,
Charge sheet challenge ಮಾಡಿಲ್ವಾ ಈಗ ನೀವು?
ಇಲ್ಲ madam.
ಮಾಡಿ ಮತ್ತೆ.
Yes, madam.
Yes. Charge sheet, madam. ರೇಖಾ madam ಕೊಡ್ತಾರೆ. Liberty, you may move a memo. We'll take it at 2:30 on the set.
As well, please, madam.
Yes. Next.
For respondent number 2, please.
Senior undergone surgery, requested next week.
Let's, I have filed the vacating stay.
But senior has undergone surgery.
They're enjoying the stay, Priyanka Srivatsav case.
ಹೌದು ಸರ್, ಸರ್ಜರಿ.
Sorry, my lord.
My lord.
I'm sorry, my lord.
ನೀವೇನು ಅವ್ರ ಸರ್ಜರಿಲಿ ಸರ್ಜಿಕಲ್ ಸ್ಟ್ರೈಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
Yes, ಕೇಸ್ ಲಿಸ್ಟ್ ಮಾಡಿಸೋದೇ ಕಷ್ಟ ಆಗಿದೆ. ಡೇಟ್ ಮೇ ಬಿ
ನಾನೇ ಕೊಡ್ತೀನಿ ಸರ್ ಡೇಟ್, ನೀವೇನು ಕಷ್ಟಪಡಬೇಡಿ. ಯಾವತ್ತು?
28th.
28th.
Please.
List the matter on 29th. 29th.
Yes.
The learned counsel appearing for the petitioner submits that Rajeshwar PN has undergone a surgery and is unable to attend the court proceedings.
Procedural surgery.
ಅದೇನು ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಪ್ರೊಸೀಜರ್ ಅಲ್ಲೂ ಇದೆಯಾ? ಸರ್ಜರಿ ಅಂತ ಹೇಳಿ ಸಾಕು. Yes, so and so. The learned counsel for the respondent would object, saying that he has filed an application seeking vacation of the interim order. Therefore, list the matter on 29th as a last chance. In the event the petitioner would not make his submissions, it would be answered on hearing the application seeking vacation of the interim order. Charge sheet ಆಗಿದೆಯಾ?
Charge sheet
ಆದ್ಮೇಲೆ ಪ್ರಿಯಾಂಕ ಬರೋದೇ ಇಲ್ಲ. ಸಿಂಪಲ್.
And they are enjoying the stay.
ಲೇಟೆಸ್ಟ್ ಜಡ್ಮೆಂಟ್. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾತ್ಸವ್ ಬರೋದೇ ಇಲ್ಲ. ಇನ್ನೇನು ಯಾಕೆ ಹಿಪ್ನೋಟೈಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಗಾಬರಿ ಆಗ್ಬಿಟ್ರ?
ಅಲ್ಲ, ಬೇರೆ ಗ್ರೌಂಡ್ ಇದೆ.
ಬೇರೆ ಗ್ರೌಂಡ್ ಏನಿದೆ?
ಜಡ್ಜ್ಮೆಂಟ್
ಅಷ್ಟೇ.
ಅಲ್ಲ,
ನೋಡಿ ಜಡ್ಮೆಂಟ್ ತಂದಿದ್ದಾರೆ.
ಇಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ.
ಪ್ರಿಯಾಂಕಾ ಅಲ್ಲ ಸರ್.
ಅಲ್ಲ,
ಈಗ ಲೇಟೆಸ್ಟ್ 2025 ಡಿಸೆಂಬರ್ದು.
ಪ್ಲೀಸ್
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ನೋ ಪ್ರಿಯಾಂಕಾ. ಇರ್ಲಿ, ಸರ್ಜರಿ ಆದ್ರಿಂದ 29th. Yes.
Interim order
will continue. Interim order continues till the next date.
Grateful.
Police report.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಕಾಲ್ ಮಾಡಿದಕ್ಕೆ ಅವರು ಅಡ್ವೊಕೇಟ್ ನ ಸರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಂಡೋಸ್ಮೆಂಟ್ ಕೊಟ್ಟವ್ರಂತ ಎಂಡೋಸ್ಮೆಂಟ್ ಇದೆ.
ಆಯ್ತು, ನೋಟಿಸ್ ಮಾಡೋಣ ಬಿಡಿ ಹಂಗಾರೆ.
My lord, it is already there. It is a 406, my lord. He is also one of the director, my lord. Or there is no allegation except that
post emergent notice, second respondent complainant returnable by the second week of February. Interim order subsisting will continue to the next date of hearing.
my lordship.
Interim order case urgency ತೋರಿಸಿದ್ರೆ ಹಿಂಗೆ ಆಗುತ್ತೆ. Yes, next.
My lord, there is no allegation except
So
for
what? Interim order ಇದೆ ತಾನೇ ಈಗ? We'll take it on a designated day. Yes, next.
A date may be given.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. Second week February ಬರುತ್ತೆ ಬಿಡಿ. Next. ಆಯ್ತಲ್ಲ 49. vacating stay.
For the petitioner in this case, I raise
Respondent
time to
number
file the
2,
objection. to
Raise
the-
time, no grant time. Yes.
There is a objection in the vacating IA. IA number 1 is office objection raised. IA number 2, second objection is
ನೀವು ರೆಡಿ ಇಲ್ವಾ?
My lord, senior is indisposed due to health reasons, my lord.
there are 2 FIR registered in same cause.
ಆಯ್ತು, anyway indisposed ಅಂತ ಬಿಡಿ. List the matter on 5th February. ಅಲ್ಲ 4th February. Interim order subsisting will continue to the next date. Okay, next.
Still not here. And trial is.
Vacating stay.
Yes, will.
Yes, sir.
FIR challenge ಮಾಡಿ.
Charge sheet has already been filed, my lords, in the court below.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ನ.
I'm for the petitioners in this case.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Charge sheet filed, will.
ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನು?
No, after filing of the charge sheet only the stay is granted.
Oh, that's all right. What's the matter?
Not 498A,
ನೀವು ಯಾರು? ಹಸ್ಬೆಂಡ್?
the husband and in-laws.
In-laws will.
In-laws stay ಆಗಿದೆ.
Husband.
Not husband ಆಗಿಲ್ಲ.
ಸರಿ ಬಿಡಿ.
Lord, the sister-in-law, Lord, she is residing in the US for the last 20 years. She is
also accused.
She is also implicated.
Very good.
Lord,
ಆಮೇಲೆ?
one submission, Lord. I reproduced because the father of the victim, I mean, wife, Lord, he is a practicing advocate. He threatened, ನನ್ನ ವಿರಾಟ ಪರ್ವ ತೋರಿಸ್ತೀನಿ ನಿನಗೆ ಅಂತ ಹೇಳಿ.
ವಿರಾಟ ಪರ್ವ?
ಹೌದು. I reproduced. ಹೇಳ್ತಾರೆ ಅವರು, because I recorded his statement. ನನ್ನ ಮಾತು ಕೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ವಿರಾಟ ಸ್ವರೂಪ ತೋರಿಸ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರು ಅಡ್ವೊಕೇಟ್
ಅಡ್ವೊಕೇಟ್ ಈಸ್ ಹಿಯರ್.
ಇವರಾ?
I am so sorry to tell this, my lord, the submission which she has been making, my lord.
I reproduced.
All false submissions, she is making false submission. It's a matter of trial, your lordship.
ಇಲ್ಲೂ ತೋರಿಸ್ತಾನೆ ಇದೀರಾ ನೀವು?
Matter of trial, unnecessary ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಮ್ಮ.
ತೋರಿಸ್ಬೇಕಾದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿದೆ ಇರ್ತೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರು ಹೇಳ್ತಾರೆ
I pray your lordship, my lord.
ಅವಳ ಪಾಸ್ಪೋರ್ಟ್ ನ ಇಂಪೋರ್ಟ್ ಮಾಡಿಸ್ತೀನಿ, ಅವಳು ಪರ್ಮನೆಂಟ್ ಆಗಿ ಇಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕು. He threatened.
ಅಲ್ಲ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
I am a doctor, my lord.
It's all right. Advocates outside are like that. Inside ಆತರ ಇರಲ್ಲ.
ಅಲ್ಲ ಔಟ್ಸೈಡ್
ಇವರು ಇಲ್ಲ unnecessary ಆಗಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇನ್ಸೈಡ್ ಹೇಗಿದ್ದಾರೆ?
ನಾನು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದು.
ಕರೆಕ್ಟ್ ಸರ್. ಈಗ ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಏನಿಲ್ಲ.
ಇಲ್ಲ ಹಸ್ಬೆಂಡ್ ಎಲ್ಲ ಇನ್ಲಾಗಳೆಲ್ಲ ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿ ಹೊಡೆದಿದ್ದಾರೆ.
US ಅಲ್ಲಿ ಇರೋರು ಯಾರು ಇನ್ಸ್ಟಿಗೇಟ್?
ಅವರೆಲ್ಲ ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ರು ಮಾಸ್ಟರ್.
ಫೋನ್ ಅಲ್ಲ?
ಹೌದು. ಯಾವಾಗ್ಲೂ ಫೋನ್ ನಲ್ಲಿ ನಿರತರಾಗಿರ್ತಾರೆ.
ಯಾವಾಗ್ಲೂ ಫೋನ್ ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ರಾ?
ಮಾಡಿ ಮತ್ತು
ಸುಮ್ಮನೆ ಇರಿ ಸ್ವಲ್ಪ.
ಸ್ವಾಮಿ ಎಲ್ಲ ಮೊಬೈಲ್ ನಂಬರ್ ಕೂಡ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಸಿಮ್ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದ ಮೊಮೆಂಟ್ ಇಲ್ಲಿ ಕೇಸ್ ಹಾಕಿದ ತಕ್ಷಣ ಅವ್ರು ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು ಸ್ವಾಮಿ. ವೈ ಶಿ ಹ್ಯಾಸ್ ಟು ಚೇಂಜ್ ದಟ್ ಒನ್ ಮ್ಯಾನರ್ಸ್.
ವೈ ಹ್ಯಾವ್ ಯು ಟು ಚೇಂಜ್?
ಚೇಂಜ್ ಮಾಡಿದ್ರು ಮೊಬೈಲ್.
Yes. Anything else? The petitioner.
in-laws are residing in
There is a
Davangere.
medical certificate, my lord.
Davangere
It is sustained injury, my lord.
Who sustained?
Accused number.
Sustained injuries due to the blow of the husband.
Husband.
What are the others doing here?
ಅವರ ಒಂದು ಪ್ರೇರೇಪಣೆ ಮೇರೆಗೆ ಇಷ್ಟೆಲ್ಲ ಕಷ್ಟ ಆಗಿದೆ.
ಪ್ರೇರಣೆ.
ಹೌದು ಸ್ವಾಮಿ.
US ಇಂದ ಪ್ರೇರಣೆ.
ಹೌದು ಸ್ವಾಮಿ. ಎಲ್ಲ ಕಾನ್ಸ್ಟೆಂಟ್ ಆಗಿ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮಾಸ್ವಾಮಿ.
FBI ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕಾಗಿತ್ತು. The petitioner is before this court calling in question proceedings in so and so, registered for offense so and so. ನೋಡ್ಕೊಂತೀರಾ ಮೇಡಮ್? Heard so and so. Yes. The petitioners are accused.
2 to 5.
One ಇದರ ಇಲ್ಲಿ?
ಒಂದು ಹಸ್ಬೆಂಡ್, ಅವರಿಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
But husband is here.
Husband is here.
The petitioners are accused 1, 2, 3, 4 and 5. They are the husband, Phil, Mill, Sil and the father-in-law, mother-in-law, brother-in-law, sister-in-law. Yes, so and so of the complainant, the second respondent. The second respondent and the accused number 1 get married on 13/2/2022. It transpires that the relationship between the husband and the other accused flounders. On floundering of the said relationship, the complaint comes to be registered by the wife against the husband and other members of the family. The registration of charge sheet hakidara? The police, after investigation, file a charge sheet. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner submits that this court, owing to the fact of indiscriminate drawing of other members of the family into the web of crime, had granted an interim order of stay. The only against accused number 2 to 5. Investigation or trial was permitted to be continued against accused number 1, the husband. The learned counsel appearing for the petitioner taking this court through the documents appended to the petition would seek to demonstrate that the allegations against the petitioners accused 2 to 5 in particular, even if it is taken on its face value, would not amount to any offense that would become punishable under section 498A or otherwise. The learned counsel would illustrate that the accused number 5, who lives in the United States of America for the last 20 years, has also been drawn into the web of crime. This to demonstrate the abuse of the process of the law. She would seek quashment of the proceedings and submit that his husband is facing trial and he would continue to face trial. The counsel for the respondent, appearing for the respondents, would vehemently refute the submission in contending that the police have filed a charge sheet, and in the light of the filing of the charge sheet, it is for the petitioners to come out clean in a full-blown trial and seeks dismissal of the petition. I have given my so and so, so and so. The aforenarrated facts, relation between the parties is a matter of record. It would not require any iteration. Insofar as the husband is concerned, the complaint and the summary of the charge sheet is obtained. Elli charge sheet?
1 to 2.
Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 18 to 23. The police, after investigation, have filed a charge sheet. The summary of the charge sheet as obtained in column number 17 is as follows. Will flag ಆಗ್ತೀನಿ madam.
Five only.
1 to 5 minutes. FIR.
ಎಲ್ಲ ಹಸ್ಬೆಂಡ್ ಮೇಲಿದೆ. ಹೊಡೆದಿರೋದೆಲ್ಲ ಹಸ್ಬೆಂಡ್.
ಹೊಡೆದಿರೋ ಹಸ್ಬೆಂಡ್ ಮತ್ತು
ಇನ್ಸ್ಟಿಗೇಷನ್ ಇವ್ರದ್ದು.
ನನ್ನ ಮಗ ಕ್ಲಾಸ್ 1 ಆಫೀಸರ್.
ಹೌದು.
ಅವ್ನ ಬೆಲೆ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ ಹಾಗೆ ಹೀಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಅದೆಲ್ಲ ಡೈವರ್ಸ್ಗೆ ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇದ್ ಮಾಡಿ ಪ್ರೇರೇಪಿಸಿ ಎಲ್ಲ ಇದ್ ಮಾಡಿ ನೀವು ನಮಗೆ ಕ್ಲಾಸ್ 1 ಆಫೀಸರ್ ಆದ್ರಿಂದ ಇವತ್ತು ಕೂಡ ಕ್ಯೂ ಅಲ್ಲಿ ನಿಲ್ತಾರೆ. ಇವನ್ ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್ಗೆ ನಮ್ಮ ಮನೆ ಮುಂದ್ಗಡೆ ನಿಲ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದಟ್ ಇಸ್ ದಿ ಎಲಿಗೇಷನ್ ಮೇಡ್ ಮೈ ಲಾರ್ಡ್. ಡೈರೆಕ್ಟ್
ಆಯ್ತು, ಅದೆಲ್ಲ ನೀವು ಬೇರೆ ಪ್ರೊಸೀಡಿಂಗ್ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ದಟ್ ವುಡ್ ನಾಟ್ ಅಮೌಂಟ್ ಟು ಕ್ರುಯಲ್ಟಿ ಆಸ್ ಡಿಫೈನ್ಡ್ ಅಂಡರ್
ಇನ್ಸ್ಟಿಗೇಷನ್ ಅನ್ನೋದಕ್ಕೆ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೇನೆ.
ಇನ್ಸ್ಟಿಗೇಷನ್ ಇದ್ದಿದ್ರೆ ನಾನು
ಪ್ರೇರೇಪಿಸಿದ್ದಾರೆ ಅಂತ.
See, we will not spare anyone who has committed any overact, be it a 70-year-old father-in-law. If he is overtaxed ಇದ್ರೆ overtaxed ಇದೆ.
ಹೆಣ್ಮಗಳು ನಂಬ್ಕೊಂಡು ಬರ್ತಾರೆ,
ಯಾರನ್ನ
ತವರನ್ನ ಬಿಟ್ಟು ಅತ್ತೆ ಮಾವನ್ ಮನೆಗೆ ಬರ್ತಾರೆ.
This is not that should be
ಎಲ್ಲ ಬಿಟ್ಟು ತವ್ರ ಮನೆ ಬಿಟ್ಟು ಅವರೇ ತಾಯಿ ತಂದೆ ಅಂತ ಬರ್ತಾರೆ.
That should be elsewhere, not here. Yes, the summary of the charge sheet as obtaining and column number 17 reads as follows. Illide madam, flag hakideni. A perusal at the complaint or the summary of the charge sheet would clearly indicate horrendous offences committed by the husband who has indulged in grave overtax upon the wife. While the petitioners accused 2 to 5, the allegation is only instigation, instigating the husband to behave in the manner that he has behaved on the wife. Insofar as accused number 5 is concerned, it is an admitted fact that she is not even residing in India for the last 20 years. The counsel for the respondent would accept that accused number 5 over the phone used to instigate over the phone used to instigate accused number 1 to behave in the manner that he has behaved. In the light of nothing being found against accused number 2 to 5 and everything found against the husband accused number 1, permitting further proceedings against the accused number 2 to 5 would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following order allowed in part. Insofar as the accused number 1 is concerned, the petition stands dismissed. Insofar as the accused number 2 to 5 are concerned, petition stands allowed. It is made clear the observations made. Yes. In husband sustained, dismissed. Husband trial ನಡೆಯುತ್ತೆ.
Is remained as accused number 1.
Oh, yes sir. 2 to 5 ಮಾತ್ರ cost.
Great suspicion that arises.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ ತೋರಿಸ್ಬಿಡಿ.
ಏನಂದ್ರೆ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡೋದು ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಕ
ಸಿಮ್ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ.
All that will
is a great suspicion, my lord. Why suddenly she has to change the SIM? The moment
ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ ಸರ್.
The moment if the complaint which has been lodged before the police, concerned police, my lords.
Even she didn't attend the marriage.
ಈಗ
ಅವಳು ಬರಲೇ ಇಲ್ಲ, ಅವಳು ಮದುವೆಗೆ ಬಂದಿಲ್ಲ.
ಈಗ ಆಯ್ತು, ಕೇಸ್ ಆದ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ?
ಅಲ್ಲ
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಈ ತರ ಅಲಿಗೇಷನ್ಸ್ ಎಲ್ಲ ಮಾಡಿಬಹುದು. ವೋಟ್ ಎಕ್ಸೆಸಸ್ ಅಲ್ಲ. ನಾವು ಕೂಡ I have got my responsibility.
Excesses is not the issue. Excesses ಇರಬೇಕು. Yes, next.
Great privilege.
That's appearing for the petition minutes.
Appear for respond number
51, my lords.
ಏನು ಮೇಡಮ್ ಇದು?
Yeah, appear for respond number 2, your lordships.
Yes sir.
Sir, your lordships, there's a connected matter, your
ಕೊಡಿ
lordships.
sir.
There is one more connected matter which is.
Tag the petition along with so and so 5th February. Interim order subsisting.
Earlier date, your lordships.
Is short date, lords.
5th February. 12th February.
Yes.
Interim order subsisting will continue to the next date of hearing. Next. Same 5th February. I vote next.
My lord, senior counsel is on VC, my lord.
My lord, may I be permitted to make a submission, my lord?
ಇದು interim ನಾನು ಕೊಟ್ಟಿದ್ದೆ. This
my lord, in 53,
ಇದು ಯಾವ್ದು
ನೋಡಿ.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೇಸ್ ಡೀಲ್ ಮಾಡಿದ್ನಲ್ಲ ಯಾವ್ದು
ಅದು ಬೇರೆ, ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ.
ರಿಮೆಂಬರ್
Would your
ದಿಸ್ ನೇಮ್ ಅಮರ್ಲಾಲ್.
Would your lordship kindly take the compromise petition, my lord?
ಪೇಜ್
Page 8 of the compromise petition.
ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
Alla, if there is a submission that is made in the compromise petition that in terms of this.
Who is the complainant here?
Complainant is the respondent.
ಮತ್ತೆ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ?
Alla, please have a look at paragraph page 8, my lord.
No problem. To close it, I have no problem, but complainant should be present.
Allah, there is a compromise petition entered in the civil court.
Absolutely no problem, sir.
Allah, decree is passed in terms of that. Allah, ಒಂದೇ ಒಂದು ನಿಮಿಷ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
ಕೊಡಿ ಅದೇನು.
Just have a look at page 4, paragraph Roman 6 subclause A. The complainant in crime number so and so filed by the plaintiff against so and so, which is stayed in criminal petition number 5894 of 25 by the Honorable High Court. Then they refer to two more matters. Then please come to page 8, para 16. The litigation mentioned in para 6A to C will stand withdrawn by the respective parties in view of this compromise.
Then we'll close it.
And then the decree is
sufficiency of notice issued is received by the assistant.
Decree nallu agide for page 19 ನಲ್ಲಿ.
ವಿಶ್ವನಾಥ್ ಸರ್ will grant one opportunity. Monday fresh matters ಎಲ್ಲ close ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಆಗ್ಬೋದು.
Yes, list the matter on Monday in the fresh matters list. Yes.
For the de facto complainant, my lord.
Vacating stay. Yes, sir.
I'll file my objections to that, my lords.
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, they've just given it to me 3 days back, my lords. I'll file it, my lords. They've raised certain new allegations which are not in the complaint, not in the FIR.
Not in the application
For
for
the first
vacating
time now in
stay.
the application it has come in.
In the application for vacating
I'll have
stay,
to
I have not made any factual allegation beyond what is stated in my complaint. In any case, not the stay is granted in the month of August. They're enjoying an anticipatory bail. The company has suffered a loss of over 25 crores. They're protected by an anticipatory bail order. For 6 months, this investigation has been stayed. In a cyber crime law, if there is investigation is stayed, it inures to the benefit of the.
No, my lord,
they've
this is a
deleted.
civil dispute. We are co-directors. I am the founder director. I am the owner of that information.
There are 4 or 5 legal grounds they've
But
raised.
I'm a founder director. I'm a promoter. Even till today, I am a director and shareholder. This is two
Being a
directors. who have
director
ganged
does
up
not give you
against me. This is two directors.
I will give you one opportunity to file objections
Please,
to the application, and next date will.
Being a director does not give you license to
Lord,
delete
6
codes from
months
the Bitbucket repository.
I have filed.
To file your.
I'll file my reply, not to their main petition. In
Main
fact,
petition.
I have to only point out this, not the 482 petition, with great respect to my learned friend, reads more like a written statement to a plaint. There is not a single paragraph in the 482 petition which sets out what the allegation in the complaint are. The allegation in the complaint are
a
not
textbook. This application, my lords, is in the nature of an
purely
essay.
on legal grounds.
It's
There
an
are 4 or
essay,
5 legal grounds raised, not.
My
to
lords may
address all
see
of
the
it.
application.
Heard the learned counsel Suraj Sampath appearing for the petitioner and Angat Kamath representing the respondent. The learned counsel Suraj Sampath seeks a week's time to file his objections to the application seeking vacation of the interim order. In the light of the interim orders, is the crime stage, I know.
It's still in the crime stage, not.
6 months
It's an
investigation went on.
anticipatory bail.
The learned counsel Angat Kamath submits that for 6 months, the matter has been stayed at the crime stage, notwithstanding the fact that issue involves cyber crime, which is seriously disputed by the counsel for the petitioner. In that light, list this matter on.
Can the office objections be overruled?
Nimda.
I'll ತೋರಿಸ್ತಾ ಇದೆ in
Office
compliance
objections
on
on
the
IA.
vacating stay.
Office objections on IA 1 of 2026 stands overruled. Copy ಕೊಟ್ಟಿದಾರಲ್ವಾ? ಅವತ್ತು ಕೊಟ್ಟಿರಲಿಲ್ಲ ಅದಕ್ಕೆ.
Yes, ma'am. Copy ಕೊಟ್ಟಿದ್ದೀವಿ. Can I request for one more indulgence? To their main petition, not along with my applicant for stay, I'm filing a formal statement of objections. I'll
File it.
serve them in advance.
Yes.
So that on the next date. not
ಅದಕ್ಕೆ
they-
rejoinder ಇರಲ್ಲ ಅದು.
ಅಲ್ಲ ಅದಕ್ಕೆ. So that they don't take time. on
Criminal
the next
case
date.
ಅಲ್ಲಿ I'll
I'll serve them in
rejoinder, yes.
advance so that they can come
No
prepared.
rejoinder to that. Yes.
We'll also may fix a date.
Yes, we'll take it on, what year is this?
25 from August, not.
2025. Post for admission on 5th February.
Please.
The pleadings be completed by then.
I'll serve them 1 week
Yes,
in advance, so
whatever.
that on the next date.
Yes, 5th February, no adjournment.
Order may kindly be accepted.
Interim order stands extended to the next date of hearing with the rider that no further adjournment be granted in the matter in the teeth of the vacating stay application subsisting.
I'm so good.
Next,
Appealing for petitioner.
special order.
But in this case, my lord, petitioner is challenging the order passed by the 5th additional civil judge in criminal for
ಇಲ್ಲಿ ಯಾಕೆ ಬಂತಿದ್ದು? ಈಗೇನೋ ಇಲ್ಲಿ ಬರುತ್ತೆ, ಮುಂಚೆ ಯಾಕೆ ಅಲ್ಲೋಗಿ ಹೇಳಿದಿರ ಇಲ್ಲಿ ಬರ್ಬೇಕು ಅಂತ?
ಇಲ್ಲ, the matter was disposed of by their lordship Krishna Kumar my lord.
ಅಲ್ಲೇ ಹೋಗಿ
Thereafter my lord, after hearing my lord, since the other side, after granting this time my lord, they have made disturbance to the court.
Disturbance?
Yes my lord. Therefore my lord, their lordship released the matter.
He got disturbed.
Yes my lord, after getting disturbed
ಸರಿ.
by the respondent my lord. Thereafter matter was listed before other court. Now
ಇದು
yes my lord, same.
ಎಸ್, ಇದು 1 ವರ್ಷದಿಂದ ಕೇಳಿದ್ವಿ ನಾವು, 1.5 ವರ್ಷದಿಂದ.
Now the learned judge
ಆಗಲೇ
my lord,
ನೋಡಿದ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು.
now the learned judge my lord, despite bringing to the knowledge of all these facts my lord, again now granted police protection shareholders my lord. Thereafter my lord,
ನೀವು
thereafter my
ಈ
lord,
ಬಾಗಿಲಿಗೆ ಬೀಗ ಎಲ್ಲ ಇಂಪೋರ್ಟೆಡ್, ಬಾಗಿಲು ಮಾತ್ರ ಇಷ್ಟೇ ಇಷ್ಟಿದೆ, ಅದೇ ಬಾಗಿಲು ಹೊಡೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
thereafter my lord, during the when they had been, when we had been to
Why
the
is
court
this
my lord,
come back here, sir? What is the matter? Domestic violence appeal ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ಗೆ.
my lord, since the matter was disarm court my lord directed the petitioner to file appropriate application for quashing the proceedings my lord. I have filed application my lord. Instead of disposing that application my lord, the learned judge has disposed of this matter my lord.
ಸರ್, DV ಆಕ್ಟ್ ಅಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಕ್ ಪವರ್ ಇಲ್ಲ.
My lord, because my lord, since my lord disarm court my lord has specifically directed the trial court when
How
earlier
long
I have approached
ಇದು
disarm court.
instead of litigating this long, if you had settled the matter with everybody,
My lord,
ಎಲ್ಲ
matter was,
ಆಗೋಗಿರೋದು.
my lord, they want the house to be registered in the NML my lord. That is my allegation my lord. That is my allegation my lord.
List the matter on 5th February in admission.
My lord, now my lord, my lordship, during the pendency of the case, my lord, when he had been to the court my lord, again they went to ಪಕ್ಕದ ಮನೆಯಿಂದ ಆರೋಗಿ ಹಿಂದಗಡೆ ಬಾಗಿಲು ಹೊಡೆದ್ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ.
ಇವರು ಬಾಗಿಲು ಹೊಡೆಯೋದ್ರಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ಸ್, ತೊಂದ್ರೆ ಇಲ್ಲ.
ತಿರ್ಗಾ ಬಾಗಿಲು
ಆಯ್ತಾಯ್ತು.
ಪಕ್ಕದ ಮನೆಯಿಂದ ಹೋಗಿ ಎಗರಿ ಹೊಡೆದು ಇದ್ ಮಾಡಿದ್ದಾರೆ. I have also produced that photo.
ಈ ಬಾಗಿಲು ಆ ಬಾಗಿಲು ಎರಡು 5th
ಹಿಂದಗಡೆ ಮುಂದೆ ಸುಮಾರು ಒಂದು 10 ಸಲ ಹೊಡೆದೋಗಿದೆ.
ಇನ್ ಯಾವ್ಯಾವ ಬಾಗಿಲಿದೆ ಎಲ್ಲ ಫೋಟೋ ಹಾಕ್ಬಿಡಿ.
This is the trial court has granted interim order not to interfere. Your lordship has granted police protection. Despite my lord, they are taking life
Police
to
protection.
Yes, my lord, your lordship granted police protection.
Police production.
Yes, my lord. The learned judge, government advocate has been directed to look into the matter and to take serious action, my lord. Despite my lord, they have not taken action till today, my lord.
Government.
Though FIR has been registered till today, no action has been taken.
ಯಾಕೆ ಬಾಗಿಲು ಹೊಡೆಯಕ್ ಬಿಟ್ಟಿದ್ದೀರಾ? All right. Yes, next. 5th ಹಾಕಿದ್ದೀನಲ್ಲ.
Please, my
That's the state is not.
I appear for the respondents 1 and 2. We've been served with the notice yesterday evening, my lords, without the copy of the petition. I'll
Petitioner to serve complete set of papers upon the council 5th interim
my
order
lords, can I
subsisting.
have it after 7th, my lord,
No
senior
problem.
Irrelevant?
12th.
Please,
Yes,
my lords.
interim order subsisting will continue to the next date of hearing.
My name may be reflected in the.
Print the name of so and so. Yes, next.
Grateful.
7 minutes, kindly pass over minutes, Koka minutes, Jagdish with.
Koka.
I undertake to appear my lords for petition number 6 my lords in this matter.
Petitioner number 6
Sorry, respondent number 6.
ಏನ್ ಕೋಕಾ ಕ್ವಾಶ್ ಆಗಿ ಕೋಕಾ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ ಸ್ಟೇಟ್ ಇಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್? ವೈ?
After charge sheet is filed for IPC offense, it appears my lords invocation of Koka has been done. Now the special court my lords has sent the matter back, that is it appears that my lords. No notice was issued on the last date my lords. They got instructions.
Learned counsel Suyag Khelle
Only for respondent number 6.
undertakes to enter appearance for the 6th respondent, registered to print the name of so and so is appearing for the 6th respondent.
There are other respondents my lords.
Emergent notice to the remaining respondents returnable by the 12th of February. Yes, list on 12th. Next.
My lord.
Sunil Kumar, next week.
My lord. My lord, I appear for the petitioner, my lord.
Yes, sir.
My lord, based upon the predicate offense, my lord, registered by Vidagiri Police Station, my lord. What?
Avinash.
Please,
What
my
are you
lord,
doing here?
My lord, based upon the predicate offense, my lord, ED has registered a case, my lord. Now, my lord, the predicate offense itself, my lord, has been stayed in WP number 10874.
List on Monday in the fresh matters list. Yes.
Please, oblige.
Office objections. Any of the office objections to be
My lord, office objections, my lord,
accepting the submission of the council, office objections overruled, list on Monday in the fresh matters list. Next. ಅವತ್ತು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಿದ್ರೆ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕು.
Beg to appear through VC Lordship.
Yes, Tejas.
Number 59 Lordship. Same multiple FIR matter Lordship. Latest judgment passed on
2
6 January.
judgments covered against you.
Para number 20 Lordship
Yes,
is
yes, sir.
categorically
ಎರಡು
clarify the position.
Pass on the judgments, my lord. The prosecution is alive.
ಆಯ್ತು ಅಷ್ಟೇನಾ, ಏನು ಸಬ್ಮಿಷನ್ ಇದೆಯಾ?
There are submissions there.
Really?
Argue, my lord. My lord, in this matter, my lord, the
I'll take
prayer
it at
what
2:30, I'll take it. Sharp. Yes. Next. ಮೇಡಮ್ ಆ ಕೋರ್ಟ್ ಅರ್ಜೆನ್ಸಿ ಇದು ಕೇಳ್ಬಿಡಿ. ಇನ್ನು ಎಷ್ಟಿದೆ ಮುಗಿಸ್ಕೊಂಡು ತಾಳಿ. ಇಂಟರ್ಲೋಕೇಟರಿ ಅವ್ರಿಗೆ ಬನ್ನಿ.
Seeking for speedy disposal.
Speedy?
And one IA challenging, my lord, that is the protection I sought before the MMTC court. My date of filing is 28/5/2024 and the order has been passed on 10/9/2025.
Come at 2:30. You are here only anyway.
Yes, my lord.
We'll pass orders at 2:30. RP? Madam, ಈ ಕೇಸಲ್ಲಿ the submission was that I have touched upon the merit of the matter also and held something. That is the reason I have issued notice.
My lords, that's not so. Your lordships may kindly
Senior
see.
counsel DR.
I know, wait.
My lords, it's understood that this was on an interlocutory order. Your lordships, if that is their apprehension, your lordships
That
may
is the only
clarify
apprehension.
that,
I'll clarify saying that the observations
merits
made
of
will
the
not come in the
matter.
way of on the merit of the matter in this suit.
That's also
Proxy
understood. A
counsel
review is
appearing, my lords,
unnecessary.
what has happened
Pass over
is
ಮಾಡ್ಲಾ?
while
Pass over
DR,
ಮಾಡ್ಲಾ?
my lord, senior counsel, while he was arguing a matter before court all 12, lord suffered some sort of a cramp in his chest.
ಹೌದಾ?
Now, my lord, he's in the dispensary, my lords, a short accommodation.
All right,
Your lordships
we'll
may
take
have
it
it
on
Monday.
next Thursday, madam.
Very well. My lords, in fact, there's a stay in another writ. It was redundant to have a stay here, but anyway.
That I don't know because that submission was made.
Please,
so
my
I
lords, I'm only
granted.
bringing
Anyway,
it to your
I'll
lordship's
take it
notice
on
that
the.
the submission is incorrect. There was already a stay of the suit in another writ petition. my
Now
lords.
that he's not well, I'll take it on 22nd.
Very good.
Yes, list on 22nd. Yeah, Ravi Shankar ga.
Yes. Now, while he was arguing a matter before court all 12.
Who that?
He was taken to the hospital now.
He was not well. He's been unwell for a while. I think there was some contested matter. He came only for that. So clearly he was not well. He was coughing a lot. So I think just fatigue, nothing to fatigue. Shouldn't have come today.
All right. Speaker ಬೇಡ ಮೇಡಮ್ ಆ ಕೋರ್ಟ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ತಗೊಳ್ಳಿ.
62 my lords, though I just this is that matter, my lords, which got remanded from the Honorable Supreme Court.
Why?
Because my lords, there was
CBI. Ada ಇದು.
Your lordship's order only.
I said place it before the bench having roster ಅಂತ ಅವಾಗ ಈಗ ನನಗೆ
ನಿಮಗೆ roster ಬಂದಿದೆ. So your lordship may fix a date, of course.
CBI.
Date may be fixed, my lords.
Is 6th February.
Great.
This also senior counsel is appearing.
Same day, 6th February.
Great.
Mayur.
My lords, this is a matter where, my lords, the second FIR registered against the petitioners herein. Lord, crime is registered for the offences of cheating and forgery, my lords.
Because ಇಲ್ಲ.
Lord, FIR registered for the offences of cheating and forgery, my lords. My lords, by the brother's son against his own aunts, my lords. My lords, what happens, my lords? The respondent number two's father, who's the brother of the petitioners, comes to be adopted by way of registered adoption deed by the aunt, my lords. Aunt of the respondent number two's father. Lord, subsequent to that, he goes and claims his share in the adopted family. Subsequently comes to the biological family, comes and claims property here as well. Lord, subsequent to that, he comes and files an FIR saying that his name has been removed from the genealogical tree. Lord, that is the connected matter, my lords. Now, this is the second FIR. My lord, that is also stated by your lordships. Now, this is the second FIR where he goes and says.
Which is that?
My lords, your lordships will find the order in page number 127.
The number pending ಇದೆಯಾ ಅದು?
That is also pending.
So you tag this and take it on 6th.
My lord, that is already posted on 20th. My lords.
20th.
ಆಯ್ತು 20th ತಗೋಣ. Tag this petition along with so and
I have
so.
some inconvenience on 20th, madam.
ಅವತ್ತು ಹೇಳಿ ನೋಡೋಣ. ಅವತ್ತು ಕೊಡ ಅಡ್ಜನ್ ಮಾಡೇ ಮಾಡ್ತೀನಿ. 20th I also have inconvenience because hearing ಕಷ್ಟ till I complete this process. Tag this petition along with so and so. List them both on 20th. ಯಾವ ವರ್ಷದಿದು?
This is of 25. The earlier petition is of the year.
ಇದು 24 Mayur.
This is 24, my lords. The earlier one is 23.
23 and 24. Then both 20th ಬರ್ಲಿ.
Grateful.
The 490.
65 ಬಂದಿದೆ. I think Mr. G. Krishnamurthy has informed me that he is not well.
He is not well.
He is not well. ಅದು ಒಂದು date. I think
interim order. Further hearing ಎಲ್ಲ will come on 6th.
Very well. Interim orders maybe.
All wherever interim orders are there will get extended. Yes.
Serial number 66 and 69.
ಎಲ್ಲ further hearing 6ನೇ ತಾರೀಕು interim order continue ಆಗುತ್ತೆ.
ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಮೇಲೆ
settlement
mediation report
Mediation's report is
mediation settlement ಆಗಿದೆ.
In family court it is matter is settled, my lord. Serial number 69 also connected matter.
66 and 69.
Please, my lord.
498 ಏನ?
Please,
ಹೌದು, my lord.
ಅದು ಅವರ
69 is 498. Case and counter case, my lord.
That's all right. Yes. Madam, ಎರಡರಲ್ಲೂ prayer ಹಾಕಿ. Prayer ಹಾಕ್ಬಿಟ್ಟು during the subsistence of the petitions. 66
It is serial number 69.
So and so. The parties to the list have settled the dispute. So the process of mediation in MC 1563 of 2023.
Wife is present before.
Which also, it's okay. Which also notices the closure of all proceedings, including these proceedings.
Please, yes.
The settlement reads as follows. Flag ಹಾಕಿದ್ದೀನಿ. In that light, ಎರಡು disposed, cost.
Both much.
Yes, sir.
Both much.
66, 69, both.
Please.
ಏನು ಸುಧೀಂದ್ರ ಇದು?
It's a maintenance case, my lord. So I have
Memo of calculation.
Trial court has not considered this.
Settlement ಅಂತಂದ್ರೆ?
Settlement, my lords, we are very ready for settlement, but she's not agreeing for it.
I then hear it on merits.
Yes.
There is no settlement in the case at hand, therefore list the matter to hear it on its merit. List the on 20th. Yes.
Yes.
For admission. Next.
I will be extended.
Interim order subsisting will continue to the next date of hearing.
Highly obliged.
Next.
For the respondent number 2, my lords.
I'm for petition.
Offense.
324 506, my lord. Between the landlord and tenant.
ಆಯ್ತು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
Settlement ಆಗಿದೆ. We'll report settlement on Monday, my lord.
ಆಯ್ತು ಮಂಡೇ 2:30 4 PM ಅಲ್ಲ ಸಾರಿ 1:25 to report settlement.
Please.
Next.
Obliged.
Highly.
Same day.
Serial number 7.
Ready na?
The matter has been settled, my lord, before the senior civil judge by
offense ಏನು?
498.
ಕೊಡಿ.
70.
70 ಸೇಮ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದ್ರಿಂದ ಅಲ್ಲ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದ್ರಿಂದ ಬೇಕಾಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
In MC petition, my lord, the matter has been settled, my lord.
ಇಲ್ಲ, it's an order.
Para number 11 may kindly be seen.
Sorry, para 11 ಒಂದು extract ಮಾಡಿ. The petitioners are before this court prayer during the subsistence of the petition The parties to the list have settled the dispute in MC 31 of 2025 before the concerned court, and a decree to that effect is also drawn by the concerned court. Paragraph 11 of the said order reads as follows. In the light of the said so and so disposed cost.
Please.
Next. Monday, 125. 72.
For the petition, my lords. 49.
Respondent LA.
Respondent ಬಂದಿದ್ದಾರೆ kindly pass on, my lords. I will be present before the court.
Pass over, yes.
Yes.
For petitioner, here for the respondent number 2.
Offense.
Alleged under section 420, my lord.
Settlement.
420, 506 and 406, my lord.
ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ.
We have filed, joint memo file ಮಾಡಿದ್ದೀವಿ sir.
ಎಲ್ಲಿದೆ ಸರ್ ಅದು?
We have filed in office, my lord.
ಮೇಡಮ್ ಅದು ಫ್ಲಾಗ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್, ಹಾಕ್ಬಿಟ್ಟು ಕೊಡಿ ಅವ್ರಿಗೆ. ಎಸ್ ಹಾಕಿದ್ದಾರೆ. The petitioners have filed prayer haki. Petitioners have filed an application seeking compounding of the offence accompanied by a joint affidavit. Joint affidavit reads as follows. So and so. Disposed cost. Next.
Please. Before the petition.
Offense.
106 BNS 304 AM. Electrification. Already compensation has been paid. Parties are.
My lord, I am filing wakalat on behalf of respondent number 2.
230 ತಗೊಂಡ. Madam ಸಾಕು.
Case number 57, your lordship is urgent to February.
Huh.
It is on a limited question where we have asked for extension of time, which was not needed. The trial court rejected.
ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ಪಾಸ್ ಮಾಡ್ತೀನಿ. We close it. 494. No urgency.
57 ಅಂತ ಕಳಿಸ್ಬಿಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಮೇಡಮ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಕೇಳ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಿದೆ ಸರ್.
ಹಾ, ಎಸ್ ಎಸ್, ಥ್ಯಾಂಕ್ ಯು. ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಮೇಡಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹೇಳಿ ಮೇಡಮ್. ಗಿರಿಜಾ ಹಿರೇಮಠ HCGP ಧಾರವಾಡಿಂದ ಮೇಡಮ್. ಎಸ್ ಮೇಡಮ್.
ಕೇಳ್ತಾ ಇದೆ ಗಿರಿಜಾ ನಿಮ್ದು. ಸರ್ ಬಂದೀನಿ ಕೋರ್ಟಲ್ಲಿ. ನೀವು ಇದ್ದೀರಾ? ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾರೆ. ನಾನು ವೆಂಕಟೇಶ್ ಕರ್ವಿ ಬಂದೀನಿ. ಹೌದು ಮೆಮೊ ಮತ್ತೆ ಮಾಡ್ಲೇಬೇಕು ಸರ್, ಇಲ್ಲ 19ಗೆ ಹೋಗುತ್ತೆ ಅದು. ಇದ್ದೀರಿ ನೀವು?
My lords, one submission, my lords. My lords, 494, my lord.
With my lord's permission, may I mention the Chamundeshwari matter which was mentioned early in the morning, and the files were summoned by my lords. My lords was kind enough to summon it.
One moment, sir, one moment.
Please.
494, my lord.
When do you want it?
My lords, 494, my lords. Senior citizens. Warrant has been issued.
What is the problem?
494.
Wait, sir. You bigamy or breach of promise of marriage. Yalla, wait.
Married sisters, they have been implicated. They have appeared.
Sir, you give fresh matter. What is?
I had moved it on last week. It has not come on Monday.
So last come. How much can I take? There are 1000 memos pending.
494, my lords. Ajit Tata ಎಲ್ಲಾರನ್ನು ಇತ್ತು.
ಅಜಿತ್ ತಾತ ನೀವೇ ನಿಂತು ಮಾಡಿಸಿರೋದು ಮದುವೆ ಅದಕ್ಕೆ ಕೊಡಿ ಮಂಡೆಗೆ ಹಾಕಿ.
ಮಂಡೆ ಕೋರ್ಟ್ ಹಾಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೆ. ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 7 ಮ್ಯಾಟರ್.
ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 7C 1 ತಗೊಂಡ್ರೆ ಆಮೇಲೆ ಎಲ್ಲ ತಗೋಬೇಕಾಗುತ್ತೆ. Everybody will have urgency. What can I do? Tell me.
Court hall number 1 submission. Court hall number 7. There is a death of disposition from my residential house. I moved the matter 2:30. It was taken up. But I know, my lord, the pressure on the court. My lord, at least it may be posted on Monday.
I have no pressure.
No.
If I was,
I know.
If I was sitting up to 7 o'clock,
I know the
3:30 I have
time
to get up
constraint.
because of the interview.
Yes, my lord. Yeah, I'm aware of it. Time constraint, my lord. Kindly have it Monday, my lord. Yeah, disposition, my lord, because
ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತಾ ಕೋರ್ಟ್?
ಅಲ್ಲಿ ಇಲ್ಲ, ಅಲ್ಲಿ ಹೋಗಿ I went up to Register of Judicial. Says that, my lord, I have to get the order from your lordship.
ಆಯ್ತು, ಅದು ಮಂಡೆಗೆ ತಗೊಳ್ಳಿ.
Serial number 20, list number 2.
Serial number.
Serial number 76.
ಈಗ ಬೇಕಾ ಯಾವತ್ತಿಗೆ ಬೇಕು?
Today only.
See, as I am telling that I will not follow the dates given by the other benches. His lordship also will tell the same thing.
Take end of the bench, end of the list.
ಇವತ್ತು end list ends at 3:30.
Because Gadipar was passed order.
ಏನ್ ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಆರ್ಡರ್? ಪರವಾಗಿಲ್ಲ. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
ಚಿಕ್ಕಬಳ್ಳಾಪುರ, ಬೆಂಗಳೂರು ಟು ಚಿಕ್ಕಬಳ್ಳಾಪುರ.
ಆರಾಮಾಗಿ ಹೋಗಿ ಬನ್ನಿ. ಅಲ್ಲಿರೋ ದ್ರಾಕ್ಷಿ ತೋಟ ಎಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
What happened in a day? Three times they have to visit the police station and put the signature 3 times, my lord.
ಮಂಡೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
My lord, date may be.
ಮಾಡ್ಕೊಳ್ಳಿ ಅದು ಮಾಡಿ. ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಎಲ್ಲ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ. ಯಾವುದು ಸರ್? ಏನ್ ಬೇಕು ಸರ್? ಲಿಸ್ಟ್ ನಂಬರ್ 6 ಇದೆಯಲ್ಲ.
List number 2, serial number 9, 1 week time may be granted.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ಕೇಳಿ, ಅದೆಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ ಮೇಡಮ್.
If my matter is not taken up on Monday, at least.
It may not be
Yesterday,
correct,
I
it
moved
may not
it.
be correct for me to fix the.
Yesterday I moved it, the matter was taken up. However, it is, it has come before my lords.
ಗಮನ ಸರಿ ಅದಕ್ಕೆ.
Last Thursday I mentioned ED matter.
Correct, ಅದೇ, ಹಾ.
Directorate district ಬಂದಿಲ್ಲ.
Because of the interview time constraint ಆದ್ರಿಂದ. Shall I take it immediately after these interviews get over?
When is that?
That is 30th, it will get over, another week. So I'll take it on the 2nd or 3rd. Second, yes.
Lords, in this matter, there is an order passed under PP Act. The public works have been stopped. Yesterday it was listed, so it did not reach. So kindly
Here?
have it on Monday. Yes, my lords.
Before me?
Yes. It was a special order dated 5/10.
ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ?
The railway matters. Nenne passed, sir.
Lords, if it is on Monday, my lords,
ಅಲ್ಲ,
list number 2, my lords, 28, my lords.
ಅಲ್ಲ ಅಲ್ಲಿ what is the urgency?
Lord, the urgency, my lords, is that I have participated in the BM, lords, the municipal solid waste tender. Lords, now what they moved,
yes,
that has been moved, my lords. Now what they say, my lords, is that I have filed an appeal. Lord, there is no provision, my lords, in the e-procurement portal to file an appeal. Lord, when I submit, my lords, on physical mode, they say that no, you should file an appeal through the e-procurement portal. There is no provision at all. Lord, that is why, my lords, yesterday we moved it. Similar matter, my lords, is my lords, allowed.
Monday.
No, my lords, yesterday it was allowed, stating that my lords,
Monday
the appeal is to be
ಬೇಕಾದು?
done Monday. There is no provision, my lords, that they have provided under the e-portal.
Yes. ಸಾಯಿ ದೀಪಕ್ ಅವರು ತಗೊಳ್ಳಿ. ಬಿಡ್ರ ಮಾಡಿಸ್ಕೊಡಿ. ನಾನು ಸೇಮ್. ಸರಿ, ಅವರೇ ಮಾಡಿ.
May it please the Honorable Court. I'm
yes,
led by
with-
learned senior counsel, Mr. Sai Deepak.
Sai Deepak is appearing in this, right?
Yes.
Please, Lords, I am. Lords.
Which is that file ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಒಂದು ನಿಮಿಷ ಸರ್, ನೀವಿದ್ದೀರಾ ಇದರಲ್ಲಿ? ಚಾಮುಂಡೇಶ್ವರಿ. You are appearing, yes sir.
May I, my lord, subject to my lord's permission?
Yes,
may I
yes,
start?
yes.
Please.
Lords,
the
I'm not
issue
sure
is
if the applications have been put on the court's file or not, because they were filed yesterday. May I be permitted to hand over?
Give it. Have you served a copy on the other
Yes.
side?
Multiple copies.
That's the evening 6:30. But if
Let me see what he has to say.
Please, my lords.
Yes, Deepak sir.
Cause list is concerned, but 2 applications are listed.
Mr. Dudas, can I submit, please?
No, let me see.
Those applications.
They're projecting some grave urgency. Let me hear what's the urgency. Yes, sir.
My lords,
Yes,
the
sir.
issue is this. There is a writ petition that was filed challenging the Chamundeshwari Kshetra Authority Act. In that writ petition, on the 15th of October 2024, this honorable court was kind enough to grant certain interim measures, including an undertaking on behalf of the state government, which is that they will not take any decision without issuing prior notices to Srimati Pramoda Devi Vadayar. Now, we moved an application, which is IN number 1 of 2025, to say that we have not been getting these notices of any of these meetings, and therefore decisions are being taken behind our backs. During the pendency of that IA, before it could be taken up for arguments, construction is undertaken around the Chamundeshwari temple, and this construction began barely last week. But the problem with the
One sorry. A Muzarai institution.
That is the issue. So let me answer this question. So this is a private property, and on this there is already a writ appeal pending before this honorable court in a division bench. During the pendency of the writ appeal, they proceed to pass this legislation to take over the temple. Therefore, we had to file the writ petition saying even the legislative rules of Karnataka State Assembly prevent the passing of any resolution or enactment when the property is the subject matter of a pending litigation before a court. It is on that basis we managed to convince the predecessor bench, and therefore on the 15th of October 2024 an order was passed. And specifically paragraph 8 of that order says that no decision will be taken without us being taken on board, and we will be given all notices before decisions are taken, so that we could attend the meetings. This is the issue. Therefore, the property which is our private property as part of the merger between India and the state of Mysore is the subject matter of another litigation. During the pendency of the litigation, this act is passed and therefore the interim order is passed. That's the sum and substance of the matter. Now, during the pendency of this writ petition, where there is an interim order, construction is started by the authority as well as the Ministry of Tourism of the state government of Karnataka. We approached this honorable court last week with pictures saying this is urgent because construction is going on in violation of the 15th of October order without our consent or without even knowledge. At that stage, the learned additional AG appeared on behalf of the state government to say, we are not undertaking any of these activities. This is being undertaken pursuant to sanction of funds under the central government's Prasad scheme. And therefore, we are merely the implementing agency and certain set of documents are produced. Therefore, my Lord predecessor said, we will list this matter today. In the meantime, you move applications, basically impleading the Union Ministry of Tourism, the State Tourism Ministry, and moving appropriate applications, which are the 3 applications before my Lords. Because no decision can be taken by the authority which is in violation of the 15th of October order. And they are saying, we have not taken a decision, the central government has taken a decision. Whereas the central government's job is only to allocate funds. The responsibility and the decision to utilize those funds for a particular activity lies with the state government. And in the context of this temple, they couldn't have taken the decision without bringing us on board, thanks to the order 15th of October. Therefore, those 3 applications are as follows. First application seeks the impleadment of the Union Ministry of Tourism to basically get their position as to whether or not they are the ones who are undertaking this activity. The second application is seeking a stay. One with respect to the existing respondents, which is the state respondents of state government of Karnataka. And the second application seeks restraint against the Union Ministry of Tourism, saying what cannot be done directly should not be done indirectly by the state government of Karnataka, hiding behind the Union Ministry at this particular point of time. Because the explanation given by the learned AG on the last date of hearing was, apparently 45 crores has been sanctioned by the central government for under the Prasad scheme for construction of certain things or for heritage sites. And we will not be in a position to use that 45 crores beyond November 2026. Therefore, there is a tearing hurry to apparently undertake this construction. When the documents placed by the state government themselves show that they have taken multiple extensions. So we are saying, why couldn't you have taken one more extension, citing this order of 15th of October 2024? Because our rights are affected because this is a private property. What is worse is that the scheme under which this construction is undertaken, which is the Prasad scheme of the central government, specifically says in clause 10.1 that you will not construct or undertake or use these funds for construction of anything on private property. Now, whether or not this is private property is already the subject matter of a list here. And even stakeholder discussions are required under the Prasad scheme. Plus the order of 15th of October requires them to talk to us. So this construction activity needs to stop is the humble request here. Because
Now,
I'm so sorry, just one submission.
all right, yes, finish it, yes.
Construction activity is so rigorous at this point that it is affecting the temple structure, including the stability of the gopuram of the temple. Therefore, my lords, this is not a Mujarai property. There is a separate legislation, which is the legislation under challenge. It is my private property, which is specifically listed as part of my merger with the Indian Union. They couldn't have interfered with it. To put it crudely, I am at par with the Travancore royal family insofar as the Padmanabha Swami temple is concerned. My position is even better because the Padmanabha Swami temple was not even mentioned as part of a private list of properties as part of merger. This temple property is specifically mentioned as my private property in my merger with the Indian Union. Therefore, while 2 litigations are pending before this honorable court, on my property, any further construction will result in irreparable consequences, irreversible consequences, plus it threatens the integrity of the temple structure. That's the submission.
I would like to
Now,
hand over the
that's all
photographs
right.
that show the
Now,
construction.
all that you said, you just take me to those pages of the orders.
I am so grateful.
15th October 2024.
Please, minutes.
And all the scheme, the Prasad scheme of the Government of India.
Yes.
And the Government of India in the scheme saying no construction activity should be taken utilizing the funds of the scheme.
I'll
These
show
3
that.
documents I want.
I'm so grateful. Kindly come to the IA, Annexure AM, as part of the first IA. This is IA.
Against the state government,
Which is the
the thickest of the 3.
This one.
the fact,
All right.
yes.
Yes.
Yes,
Hmm.
yes.
So in
Idhar
that
page-
kindly come to page number 19, annexure AM, which is the extraction of the order of 15th of October 2024. In
AM.
fact, all the orders passed in this matter have been placed on record in that IA.
All right. Yes. Hmm.
I would request my lords to kindly bear with me as I read out the entire order so that I'm not seen as quoting something selectively.
No, Sai Deepak sir, don't worry about that. I just
Please,
wanted to see the order. That's all. Yes. Next.
Please, ma'am. 15th of October, and my lords would see para number 8. This is important.
Yes. Additionally, the authority constituted so and so.
Constituted is directed to serve notice of any meetings to the petitioner. In the event that the petitioner, despite being duly served with notice, chooses not to attend, then they can proceed. I am saying I've never even received these notices.
Now, the next page appears to be the scheme.
I'm grateful. The Prasad
Prasadam scheme.
Please, my lords. I'll
The
show the
Prasad
relevant clauses.
scheme, I want to see the clause that it shall not be utilized for construction purposes.
On private property.
Yes.
I'll just show that, my lords. Kindly come to page number. This is, my lords, paragraph clause 5.6, annexure AV. Private property.
Running page 111.
Under state governments and UT governments, my lords would see under clause 5.6.
Yes,
at the bottom of the
5.6.
page. Please, my lords. Can I just read this whole thing, because the buck is sought to be passed on to the central government. I'm saying it lies with the state government. Please see this. State government shall be represented by Department of Tourism and its apex official.
Page 110, your lordship.
Yes.
Clause 5.6, and the heading is state/UT governments.
Yes, yes.
State government shall be represented by Department of Tourism and its apex official for responsibilities as mentioned below. Assist national program. So these are the responsibilities. Assist national program management consultant in preparation of detailed prospective plan for identified sites/destinations for pilgrimage rejuvenation. So the state government, its Department of Tourism, will assist the Prasad scheme in identification of sites. I'll just pause here for a moment. Please make a note of this. Considering that this is bliss pendant's property, this site should not have been identified in the first place under the scheme. Then kindly come to the next one. My lords may see the fourth or the fifth bullet on the next page, page 111, if I'm right. Fourth bullet at page number 111 on the top. It starts with preparation of detailed project reports, DPRs.
Yes. Yes.
On the proposed project from the IPs, state government should prepare comprehensive DPRs for respective identified projects in consultation with respective administration, local bodies, and other stakeholders. I am a recognized stakeholder thanks to the order of 15th of October. Shrine authorities also, NGOs and societies as applicable. I am basically saying I am the custodian of the temple. I am the Shebayat of the temple. I am the owner of the temple. Then my lords may come to the sub bullet under this bullet, the fourth sub bullet. The necessary arrangements for land parcels like signing MOU, getting in principle approval and letter of acceptance from respective land title holders. Anticipating this, we have done all of this, because in the writ appeal we had already launched similar allegations, because they were supposed to undertake a ropeway project. It went before the division bench. That was stalled because we said no permission has been taken. After that, the Authority Act is passed and this happens. Now I'll come to the third document.
Which is that order by the division bench? Page.
I'll just show it, minutes. So the ministry itself, they shelved the ropeway project pursuant to our application.
Ropeway project.
Yes, Milods.
Which is
there is a notification of 15th of July 2022 where they had to shelve it. Annexure AJ.
Where do I get that?
Annexure AJ, page number 16 of the very same application.
All right.
So this is one.
This was stalled by. So this was shelved.
Yes.
Because of the order of the division bench.
Because we had moved an application before the court saying none of these activities can be undertaken because it's a heritage structure, ecologically sensitive, coupled with the fact that the status of the property is in question.
Now what is the construction undertaken? Yes, Mansi.
Now the construction that's undertaken is for a multi-purpose stage area. Those photographs are handed over. I'll just show that, Millards. I'm so sorry, just for a moment. The same document that I was showing, the Prasad scheme, kindly come to clause 10.1. The Prasad scheme, clause 10. My lords was reading clause 5.6. Please continue going down that. Mansi ji, could you please assist the court with the page number for clause 10.1?
Page 117. Yes. 117.
Inadmissible components.
Which clause?
Inadmissible components. Clause 10 at the bottom.
I'm at clause 10. Yes, tell me.
I'll read this. The central financial assistance under this scheme shall not be admissible for the following components. Please see 10.1. For projects on pilgrimage destinations. And importantly, please see bullet number 3. Improvement stroke investment in assets stroke structures owned by private agencies other than shrine authorities at pilgrimage centers. I am saying I'm the private owner.
Now, fair enough. Where does the state government take shelter under this?
I'm so grateful. So on the last date of hearing, the learned AAG appeared and said, this is the scheme. In fact, this entire this Prasad report, this Prasad scheme report was handed over to us by them in court on the last date of hearing before my lord's predecessor.
Correct. Is that recorded by the previous bench?
My lords may kindly come to the order of the last date of hearing, which is 9th of January. This is Annexure 80.
Page 61.
No, the order recording the fact that this was handed over, we'll just show that. So, because we don't have access to this, this was given to us by the Council for the State Government on the last date of hearing. So, my lords could come to Annexure AR, page 61. Where the representation or the submission of Mr. Devdas was specifically recorded. May I show this, Millards?
Yes, I've seen 9/1/2026 order.
So therefore, we are in this court because we've been enlightened by the opposite counsel as to what is the position under which this entire construction activity is undertaken. In light of that, we are saying, and the worst part is between the last date of hearing and today, they have expedited the process even further.
And what is the litigation pending qua, the claim of private property?
I'll answer the question. Kindly give me just 30 seconds. There is a writ petition specifically against a government order of 1976, which resulted in a judgment against us. In that writ petition, we said this government order takes over the Chamundeshwari temple, despite the temple being part of the private properties of the royal family of Mysore as part of its covenant with the union. It has no power to do so because only the central government through the president can do this. The state government has no such power to do so. And we are Shebayats, and the property is specifically listed as part of the list of private properties excluded from acquisition by the union and merger by the union. Now that writ petition results in a judgment of 2001 against us. Writ appeal is pending against that before the Honorable Division Bench of this Honorable Court.
Even today?
And therefore, please, minutes. So sorry. I'll give the writ petition as well. Sorry, the writ appeal number as well.
Writ appeal number?
1011 of 2001.
1011 of 2001.
Please, Millards.
And why is it pending for the last 25 years?
Millards, in fact, we have been moving it, asking for arguments. Unfortunately, it has not been taken up and it's been lying in cold storage. We have no vested interest in keeping it alive and pending because we know that the central government is interfering with the administration of the temple, including the assets of the temple in the name of this.
State government.
I'm so sorry. My apologies. The state government.
Yes.
My is right. So because there was one Supreme Court 9-judge bench matter reference that was pending, that decision has been delivered recently, and therefore the writ appeal can be taken up for arguments. This Supreme Court 9-judge bench matter was delivered last year with respect to the private party's case. So the writ appeal can actually be taken up for arguments. Now, during the pendency of the division bench. My apologies. So therefore, I'll just explain the sequence of events. So the writ appeal was pending. While the writ appeal was pending, and we came to this honorable court citing instances of ropeway construction, they stopped the ropeway construction, and then 2024 they passed the Authority Act. Under the Authority Act, extensive powers have been appropriated and arrogated to the state government, which is what led to the order 15th of October. In fact, on day one, a stay was granted on the order, on the act itself. They said we had notified and implemented the act even before the stay, therefore it doesn't work. Therefore, Justice, I think Hemant Shanta's order has
Hemant.
heard extensively, which led to the order 15th of October after multiple dates of hearing. And then specifically paragraph 8 was included in that order saying, kindly don't take a decision without issuing notices to the petitioner so that they can participate in the decision-making process. And then they undertake this construction activity. Now the latest excuse is, I am not the dramatist person, the central government is responsible.
That's all right.
That's
Yes,
clear.
yes, sir.
But your lordship has
What is the
seen-
tearing hurry in completing the construction till the next date?
but your lordships has seen the same issue, my lord, your lordship has seen the order dated 9/1/2006.
No problem.
Same can be continued, I have no objection. But their claim that Lord Sri Chamundeshwari temple is their private property.
No, that's a claim that is pending adjudication. We will not enter into that. You have taken over, fine, that is pending before the division bench will answer it. Now, on 9/1/2026, there is an order passed by the coordinate bench. I am only asking, where is the tearing hurry? Or, see, pending proceedings or matters not being listed should not render something fait accompli.
Government of India, Ministry of Tourism has introduced this scheme in 2015.
No problem.
But in 2025, my lord, the Joint Secretary to Government of India, my lord, had a meeting with the state government Department of Tourism and said that, my lord, the funds will be lapsing by 2026, and he raised serious objections that in spite of sanctioning of this plan and being to be executed with the Ministry of Tourism, Government of Karnataka, you have not done it. Physical verification is done and some progress has to be made.
Correct.
That is so, my lord, we have undertaken this execution of the
One
scheme.
question,
All
sir.
that I have
No
cleared.
problem, sir. One question. Just now you told the funds are allocated by the government of India in the year 2015, correct?
No, not 2015. Scheme came in 2015.
When was the funds allocated to you?
Funds are allocated only in 2021 or
21 or 22?
22. And when tenders have been called in then, and it was approved.
Well,
again by
2021 and 22 funds are allocated.
No.
But the hurry springs
Time
now.
limit, time limit, my lord, was given about 5 years. 26 would expire.
But for 3 years, what did you do?
No, now we have taken up.
No, 3 years, what did you do?
Work order has been issued. That's what said.
So you have waited for 3 years.
Would suggest is, my lord, these applications are not listed for orders. But only yesterday evening they have served. We have no time even to seek instructions.
No problem.
What to be done in the matter. Let these applications be listed next week. We will come up with our
Absolutely no problem. I will grant you time. Hold your hands
Only on.
of construction.
No, my lord, the order, my lord, this issue, my lord, is already.
You
my lord,
take
there is-
15 days time to file objections, sir. We will not render these objections or delays to become something to become a fait accompli. I told you. Yes.
my lord, this order is made and now only they have filed an application to implead the tourism department, government of India, tourism department. They are not the parties to this petition.
No problem.
Let the notice be issued to them.
ಇಲ್ಲ ಇದಾರೆ ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೆ.
What is government of India?
ಹೌದು,
There are
ಇನ್ಯಾರಿಗೆ?
three government of Karnataka tourism. Then Chamundeshwari Development Authority itself is thought to be implemented. It is not a party before the court so far. Let the notices be ordered. Let the applications be considered.
I have no problem, sir. We'll direct anyway it is before the coordinate bench, they will consider it. By then construction complete agi, project completed, tourism.
Temporary, just
boom.
the construction is not that putting bricks and walls just erecting pillars and only we are providing a shade only for the devotees.
Photographs.
Can you see the
I had passed it photographs.
Where are the
can you
photographs?
see the
There are 3 photographs. The dates are mentioned, your lordships.
we
One
have-
photograph is produced along with the
Kindly
application
see
at
the
page 56.
documents that I have produced.
No, if it is only a shelter to the devotees, what's
Shelter only for the.
No, my lord,
Yes,
the multi-purpose stage areas
It
actually.
can be
I'll
pulled
answer the
down
question.
anytime. It can be
May I
pulled
respond
down
to this?
anytime. All that we are doing is erecting a shelter for the devotees. Even if that they are objecting, my lord, very.
I'll respond. May I just respond?
What vicarious pleasure, my lord, this petitioner will get?
Unfortunate,
Should we
very
not,
sharp.
should we not provide
we'll answer all this.
facilities?
So,
Should we not provide facilities for the devotees?
yes, Saidipak sir.
Millet,
This,
just one second.
if pillars are being erected only for the purpose of shelters being for the devotees, then
Please,
I don't think that will be a permanent structure of construction.
Can I
And
make
you
one
should also not come in the way for that.
If I may, I understand what is calling from the bench. I'll try and
Yes.
meet the bench halfway because I don't wish to be intransigent on this issue. So let me answer the
Yes.
question.
Yes, sir.
Two submissions. So we had moved IA number 1 of 2025, basically saying we have not got any communication whatsoever. That IA is actually pending. We were forced to come in the rest of the 3 IAs because of the construction activity. This is just so that my lords knows the complete picture. So two requests. First, they should not construct anything that is permanent as long as that is there.
Yes, that is not their case also.
If I may, let that be recorded. Nothing permanent.
I will record it right away. Yes.
I'm so grateful. Second, what is the exact nature of construction undertaken? Let them disclose that before the court can finalize whether it's permanent, reversible or not.
Yes.
Because if tenders have been issued, clearly it's not been issued only for temporary constructions.
Where
Surely
is the
45 crores have
tender
not been
issue
signed.
ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲಿ ಉಂಟು tender?
Please see the work orders. It's on record with us. At page number 92 of the IA, we've placed the work orders.
2025.
ಒಂದು ನಿಮಿಷ ಟೆಂಡರ್ ತೋರಿಸಿ ಅಷ್ಟೇ ಸಾಕು.
Tender invite, but there is a reference in that.
Please see the work orders. We have placed it on record. None of them speak of
That I
temporary
have produced
construction.
along with this one, madam. Detailed project report jati ಹಾಕಿದ್ವಿ. Last 9th I have placed on record.
ಇದೇನು ಬರೀ ಶೆಲ್ಟರ್ ಅಲ್ವಲ್ಲ ಇಲ್ಲಿ?
Shelter ಅಷ್ಟೇ.
ಟಿಕೆಟ್ ಕೌಂಟರ್, ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಪಾತ್ವೇ, ಎಕ್ಸ್ಟೆಂಡೆಡ್ so and so.
No, Milas, kindly see the simple premise. Project cost, two mandapam, multi-purpose space, no
wants
room,
my devotees to stand in the queue.
Argument in terrorem ಬೇಡ. Wait. Yes.
My apologies. My apologies.
Work order ನೋಡಿ ತಗೊಳ್ಳಿ.
I will do one thing. I will record your statement that only a shelter with pillars being erected for the purpose of devotees' protection is being done in terms of what construction is taking place now.
Please,
Except that you will not erect any permanent structure and render the rights fait accompli.
Place it under.
Yes. Now, whatever is here, I will record your statement.
Whatever
And
is there,
you will before the coordinate bench place it before the court.
Please.
That what is the nature of construction being undertaken and the entire plan of construction before the court on the next date.
Along with our statement.
Yes.
Objection.
Whatever you want, you can do. Yes, that should suffice for the present.
In fact, I agree. I don't wish to be a stumbling block. Can I just assist the court in making this comprehensive? Can I?
Yes.
Please. So the last order of 9th of June says that if something is found illegal, it will be removed. So my lords may reiterate that as well.
Correct.
Second,
Yes.
The first IA number 1 of 2025 says, give us the details of meetings and notices which we are supposed to receive under the order of 15th of October. We have not got that as well.
Yes.
So if my lords could pass both these orders, I will go back in peace. I have nothing more to submit.
Yes, sir. 1 minute.
And I'm so sorry. Even the disclosures that they're making with respect to this construction activity, the exact role of the Ministry of Tourism Union Government, the exact role of the Ministry of Tourism State Government, and the Authority Act, all that needs to be placed on record, so that they are not constantly playing a ping pong match here. Saying
That the government of India will do. Yes.
I'm so grateful, deeply obliged.
Heard the learned senior counsel Shri Sai Deepak appearing for the petitioner and the learned senior counsel Devdas, learned additional advocate general Devdas appearing for the respondent state. The issue is pending before the coordinate bench due to the matter is placed before this bench as it is the in charge court on this occasion. On 9/1/2026, the coordinate bench had passed the following order. The learned senior counsel Sai Deepak would amplify the observations made by the coordinate bench on 9/1/2026 to contend that another coordinate bench on 15/10/2024 had passed the following order. The learned senior counsel would make particular reference to clause 8 of the said order, which directs that all notices of any kind in the temple, in the property, meetings, all notices of the meetings for a decision making to be taken should be after the petitioner being notified. The learned senior counsel submits that there is no notice issued even as on today, but serious construction activities are taking place in the temple. The learned senior counsel further submits that the activities that are undertaken in the temple cannot be said to be temporary, as they are in effect endangering the heritage, endangering the construction of the temple itself. The learned senior counsel would further take this court through the learned senior counsel submits that they come to know of the state government undertaking construction on a particular scheme when it was brought to the notice of the court on the earlier occasion, which led to the passage of the order dated 9/1/2026. The scheme is now placed before the court by way of an application. The scheme of the Government of India is projects under SDS and Prasad schemes. In terms of the said scheme, no construction, in terms of certain clauses of the said scheme are germane to be noticed. Clause 5.6
and 10.
5.6 reads as follows. Flag hakidini.
And 10.1.
Clause 10 reads as follows.
Read for me.
Clause 10.1 prohibits projects on pilgrimage destinations, projects including resettlement, rehabilitation, operation, maintenance, management of assets created. The learned senior counsel, taking cue from the said clause, would contend that what is now undertaken is from the, admittedly what is now undertaken is from out of the funds that are funds that are sanctioned by the Government of India to the temple, to the state government. The learned, it is its contention that a writ appeal in 1011 of 2001 is still pending adjudication before the division bench with regard to whose property the temple is, whether the petitioners or the taking over of the temple by the state government in the year 1976 was appropriate or otherwise. The said issue being before the division bench and the order passed in the teeth of the learned additional advocate general Shri Devdas would now submit that no construction activity of something being permanent in nature is undertaken in the vicinity of the temple. He would submit that what is being erected are pillars for the purpose of shelter to the devotees who come to the temple, and would further undertake that no construction activities which are of permanent in nature will be done. The said submission is placed on record. In the light of the said submission, the projection of the learned senior counsel that construction, if permitted to be undertaken now, would render the claim of the petitioner fait accompli, need not be considered at this juncture. The matter be placed, therefore the state shall now, the Union of India is implemented?
Yes, 3 years. So that's the
Already
application.
implemented?
No, Millards, not yet.
We filed the impleading application.
I've received the copy.
ಎಲ್ಲ ನೀವೇ ತಾನೆ? For the reason, the order on IA3, which IA?
It's not yet numbered.
Where is it?
It was filed yesterday. The 3 applications, Your Lordship. One for
It's not put up?
No, it was handed over to Your Lordship.
It's all right. It's not. How do I pass an order on an application that is not before the court?
Application will be listed, director will be listed.
It was
Allow
filed
Martin
yesterday.
application. Madam, application Thursday. It is filed, correct?
Certainly.
Yes, it's filed.
Application in IA3 is filed seeking impleadment of the Union of India and the Chamundeshwari authority, temple authority.
And the Ministry of Tourism of the state government as well.
Yes. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same that they are necessary parties for the resolution of the list.
They want to implead Honorable Chief Minister, who is the ex-officio chairman, but give us time to file objections. But it's a corporate body being represented by the secretary.
Why do you want the chief minister?
But they're targeting
Because he is the chairman of the authority under the act.
matter.
So
It's unfortunate. If he becomes the authority chairman,
for
then
the
he
reasons indicated in the affidavit, you file your objections. Subject to the objections by the state, the application so and so stands allowed the petitioner to amend the cost title. amend the cost title. Learned Deputy Solicitor General of India, Sri Shanti Bhushan, is directed to accept notice for the Union of India and its wings that are now impleaded as party respondents, and the state government, yaar is name? AGA. Learned AGA is directed to accept notice for the impleaded respondents - state government.
Implementing objection was in the spot of proposed respond number 8, who is Honorable Chief Minister, except that Madi. Tourism Department state is a Madi, Chabundichure Development
He's
Authority.
been implemented as the chairman of the authority, not as the state.
There is 1 minute authority.
Except in the
One
Madi,
minute.
that issue be kept open.
1 minute, sir.
Please.
Chairman, there is no other authority. There is not an
chairman is
officer. No,
actually
chair,
as the
you
veto
need
power.
not. You need not implement the chairman in everything. If there is any other officer or custodian of records, yaru. Whoever is the custodian of records of the authority will be implemented.
The secretary, the secretary of the authority.
You remove the chief minister and print it as secretary. All right.
Secretary.
Grateful. We'll do that.
Development Authority represented by secretary and R7. Already it's done.
Then not necessary. Remove the chief
Not
minister.
necessary. Name.
Please.
You need not drag it. No problem. Wait.
Illa, idu.
So and so. In the light of the said submission, objections, if any, to the to the applications so filed, the submissions of the learned additional advocate general is placed on record. The state shall place before the court the project that it is undertaking, the manner of implementation of the project under the scheme by the next date of hearing. The learned additional Deputy Solicitor General of India also shall place on record what are permitted under the scheme for any state government for implementation, whether it is construction or otherwise.
Grateful. There's 2 more prayers, one on IA number 1 of 2025, so that all the records are given of meetings.
What is that?
So that was the prior IA saying that all the records of the meetings have to be given to us on 15th of October order, that we have not received any notice of meeting whatsoever.
IA 1 of 25.
IA number 1 of 2025.
Allah, IA 1 of 2025.
Well, to call him for record, that we will file objections.
The learned additional advocate general submits that he would file his objections to the application seeking records. Is it? What is that?
Notices of meetings which have to be issued under the order of 15th of
Seeking a direction at the hands of this court for issuance of notices for the meetings. It is ununderstandable what objections that the state can file now in the teeth of the order passed by the coordinate bench dated 15/10/2024, which clearly directs notice to be issued to the petitioner on all meetings. What objections?
Meetings
ಅದು ಬೇರೆ ಮಾತು. ಈಗೇನ್ objection ಆಗ್ತೀರಾ ಅದಕ್ಕೆ?
Place before the court.
Whatever. What objections can you file in the teeth of that order?
This order, your lordship may dispose of the other 2 applications which are sought to be filed now.
Which application?
Restraining the respondents, proposed
No, kindly
respondents.
keep them
from
pending,
carrying on with the construction anta.
That I will not dispose. No.
Your lordship order covers that.
No. That was your undertaking I have recorded, not my finding on the application. So coordinate bench will render its finding on the application.
Then, my lord, once the objections are filed, let the applications be considered.
Absolutely. No problem. How much time you
3
want?
weeks time.
ಎಷ್ಟು?
3 weeks.
3 weeks.
ಅಲ್ಲ ರಜಾಗಳು ಬರುತ್ತೆಯಲ್ಲ 2 ರಜಾ ನಾಳೆಯಿಂದ
ಎರಡು ರಜಾ?
ಆಮೇಲೆ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಇದು ರಿಪಬ್ಲಿಕ್ ಡೇ ಈಗ working days my lord hardly would be 7 days 7-8 days.
We'll grant you 2 weeks time. List the matter before the appropriate bench on the
28th.
No.
1 week for a rejoinder.
Rejoinder we file everything, sir. We'll post it on 13th February.
So DB.
Yes.
Great. It's a Friday the 13th. I wish everyone the best of luck. I'm so grateful.
That's exactly where I post. Don't worry. It's not going to be unlucky.
There is a change in his face. On 9th when he had grown a long beard. Today he looks smart.
Sai Deepak is always like that. Senior counsel.
I'm grateful for a patient hearing. It's been a pleasure and a pleasure with us. Great. Deeply obliged.
the petitioner herein, my lord, is a jeweler by profession. Notices were issued asking him not to appear for investigation, but to produce the ornaments which the police have already presumed he has already taken it. I have given a reply stating that I have not received any gold ornaments. The same case, C report is filed, closure report is also filed with the police. It is accepted by the magistrate without the permission or the report to the magistrate. They were conducted further investigation, and I am nowhere involved.
So why are you here now? Urgency and
From past 3 days, my lord, they're coming every day near the shop. They're threatening me with arrest. ಬೆಳಗಿನ ಸಂಜೆವರೆಗೂ 5 ಸರಿ ಫೋನ್ ಮಾಡ್ತಾರೆ. ಗೋಲ್ಡ್ ಆರ್ನಮೆಂಟ್ಸ್ ತಗೊಂಬನ್ನಿ.
ನಂಬರ್ ಬ್ಲಾಕ್ ಮಾಡಬೇಡಿ.
The only issue is, let them ask me to come for investigation, allegation ಇದೆ, ಬನ್ನಿ ಅನ್ನೋದು ನಾರ್ಮಲ್ ನೋಟಿಸ್ ಇರುವಂತದ್ದು. My respectful submission is,
ಏನ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ? 35 ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
94 ಅಲ್ಲಿ they are demanding me that I should produce the ornaments which I have not even taken, even after giving the reply also. ನಾನು ರಿಪ್ಲೈ ಕೂಡ ಕೊಟ್ಟಿದ್ದೀನಿ. Entire shop is covered by CCTV, but still they say ದಯವಿಟ್ಟು ornaments ತಗೊಂಬನ್ನಿ.
ದಯವಿಟ್ಟು ಆರ್ನಮೆಂಟ್ಸ್ ತಗೊಂಬನ್ನಿ ಅಂತ ಇದ್ದಾರಾ? ಪೊಲೀಸ್ ಅಷ್ಟೊಂದು ಸಭ್ಯತೆಯಿಂದ ಕೇಳ್ತಾ ಇದ್ದಾರಾ?
Annexure A may kindly be perused, my lord.
Closure report ಆಗಿದೆ. Magistrate
Magistrate
ಹೇಳಿಲ್ಲ
petitioner's name is stated by the accused person.
ಅಂತ ಹೇಳ್ತಾರೆ.
May kindly see Annexure A1, page 13.
ಆಯ್ತು, ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರಲ್ಲ?
Yes, my lord.
ಏನಾಯ್ತು ಕ್ರೈಮ್?
That I have to seek instructions.
ಸಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
ಸಿ ರಿಪೋರ್ಟ್ ಆಗಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಸಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. ಆದ್ಮೇಲೆ ಮತ್ತೆ ಇವ್ರ ಹಿಂದೆ ಯಾಕೆ? ಎಸ್ ಜಗದೀಶ್ ಸರ್, ಸಿ ರಿಪೋರ್ಟ್ ಆದ್ಮೇಲೆ ಹಿಂದೆ ಹೋಗೋದು ಯಾಕೆ?
ಸಿ ರಿಪೋರ್ಟ್ is not closure.
ಸಿ ರಿಪೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಕ್ಲೋಸರ್, ಸಿಗ್ತಾ ಇಲ್ಲ ಕೈಗೆ ಅಂತ ಅಷ್ಟೇ.
ಆಮೇಲೆ ಏನೋ ಸಿಕ್ಕಿರ್ಬೇಕು.
That too with C report with regard to those people.
ಕುಮಾರ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ he knows what it is.
Ships kindly appreciate they have specifically stated Annexure A1.
You do anything in accordance with law.
Please.
ಏನ್ ಕಾಫಿ ಕರಿತಾ ಇದ್ದೀರಾ ಫೋನ್ ಮಾಡಿ?
Stated specifically.
2 days more notice. Even after filing of writ petition, one more notice. Mala intention.
ಒನ್ ನಾಟ್ ಯೂಸ್ ಮಾಡಿ ಸರ್ಚ್ ಮಾಡಿ ಸೀಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು, ನೋಟಿಸ್ ಕೊಡೋದು.
ಮತ್ತೆ ಅದು ಮಾಡಲ್ಲ, ಸುಮ್ಮನೆ ಫೋನ್ ಮಾಡೋದು.
Still 91 notices.
Notice.
Let them cooperate.
He says he has cooperated. Investigation is also over. C report is filed. ಆಮೇಲೆ ಏನ್ ಮತ್ತೆ?
Probably seems to have reopened.
How can you reopen? C report ಆದ್ಮೇಲೆ who has to permit you to reopen? And then where is the order?
ಇಲ್ಲ.
You produce ಮಾಡಿರಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು. Anyway,
I am not involved.
ಆ ಕೋರ್ಟ್ದ ಇದು?
ಆ ಕೋರ್ಟ್ ಅಂದೆ.
I'll accept notice, my lord. I'll seek instructions.
Learned AGA madam.
Please, my lord.
Learned AGA is directed to accepts notice for the respondent state. The petitioner is before this court on this score that the police are continuously summoning the petitioner or is meting out such harassment on such summoning. The petitioner was an accused, is it?
He was not even an accused.
A crime comes to be
Sold it
Jewelry
to the
shop owner.
a petitioner is the owner of a jewelry shop and a crime comes to be registered on certain thieving of gold. A C report comes to be filed thereon, but the police are behind the petitioner. The learned counsel submits that without permission of the learned magistrate on the C report, no further investigation can be taken up, which in the light of the said submission, without there being any permission from the hands of the magistrate to continue further, the investigation or the summoning without authority of law would become illegal. However, the notice that is issued to the petitioner is one under section 94 BNSS, 91 of the earlier regime, the CRPC. That any notice of that kind being issued would necessarily need cooperation from the noticee. But the facts in the case at hand is C report is filed before the learned magistrate unless permission is taken from the hands of the learned magistrate. Even a notice under 94 of VNSS cannot spring. In that light, the police are restrained except after the magistrate would grant such permission to continue the proceedings.
Please.
Order recorded.
Great.
My lord, petitioner is seeking quashing of the FIR, my lord. The FIR is at page number
My lord, FIR is at page number 36, my lord, and complaint is at page number 40. The allegations are that the petitioner has falsified caste certificate of his children and availed reservation for them. My lord, the petitioner.
Caste certificate challenge madidra?
It has been challenged in that petition by the son, my lord, because he was never made a party in that DCVC proceedings. My lord, petitioner belongs to OBC, my lord. His wife belongs to ST category, and the entire school records, the caste certificate was been issued on the basis of.
Jagdish sir, aura. Jagdish Yes, the learned additional SPP is directed to accept notice for the respondents. They list the matter on 2nd February in the fresh matters list. There shall be an interim order of stay of further proceedings till the next date.
Great.
Yes.
My lord, hand delivery.
ಯಾಕೆ?
My lord, our police ನವರು ಪದೇ ಪದೇ ಕಾಲ್ ಮಾಡ್ತಿದ್ದಾರೆ. They are apprehending it.
Only ಪದೇ ಪದೇ ತಾನೆ ಪರವಾಗಿಲ್ಲ. Yes. ಕೊಡ್ತೀನಿ. Don't.
We have a petition in this case. As the petition, the respondents have issued the notice.
Jagdish sir, it concerns this institution. 14 years in the appointment ಆಗಿರೋದು. ಇವತ್ತು ಯಾರೋ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು ಅಂದ್ಬಿಟ್ಟು ಇದು ಕಾಟ ಕೊಟ್ರಂಗೆ ಹೇಳಿ.
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ seems to have already been filed.
ಇನ್ನು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ. They have now give police notice ಕೊಟ್ಟಿರೋದು ಈಗ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಬಂತು. 2012, 2025 ಕೊಟ್ಟಿರೋ ನೋಟಿಸ್.
Charge sheet seems to have filed against some accused.
No, that is concerning others. It emanates from here only. They lose their employment. Learned additional SPP is directed to accept notice for the respondent. There shall be an interim order of stay as prayed for till the notice dated 2012-2025 and all further proceedings taken thereto or to be taken thereto against the petitioner shall remain stayed till the next date of hearing.
For the petition.
Who is the petitioner? Yes. Easy.
Lord, the petitioner, my lord, is an authorized e-waste recycler.
Correct. Recycle karo.
Recycle karo. Lord, he has, my lord, obtained consent from Maharashtra State Pollution Control Board.
Oh, the tender.
Tender matter. Now, my lord, at page 9, if your lordship sees, with respect to Bharat Electronics Limited, respondent number 1, previous tenders, my lord, 3 tenders satisfactorily, my lord, executed. Now, my lord, in the tender that is now issued, uploaded by the respondent, your lordship sees that there are 2 conditions that require need to have an e-waste facility in the state of Karnataka and to obtain Karnataka State Pollution Control Board clearance. Lord, according to me, my lord, both those conditions, my lord, are arbitrary, mala fide, and not in accordance with the e-waste rules. E-waste rules will not permit you to have interstate, my lord, you can have a facility anywhere. Your lordship sees the process in which this is a e-waste in respect of electronic voting machines and VVPAT machines, my lord. What happens is the e-waste cycler, my lord, will dismantle the equipment in the premises of the party, and only the components will be shipped from one state to the other state. It's not as if that the whole machine will be carried with them. So the recycling that is done is only in respect of those items, my lord. I have successfully carried out. I have done it for other states. I have done it for Maharashtra, MTNL, for BSNL, for everything. Your lordship sees, my lord, matter is covered by a judgment, my lord, unless there is a rational nexus between the condition that is imposed and the object that is sought to be achieved. My lord, this kind of is.
How can we sit in the armchair of an expert to
no, your lordship sees
tender?
No, my lord, if it is a job that I have not done before, I can understand. That's why I said, if your lordship looks at page 9.
What's the impending urgency?
The impending urgency, if your lordship looks at page 26, the auction date is on 20th, my lord.
What auction?
E-auction.
They will post it on 19th.
No, but your lordship says, my lord, if I don't get an order as far as this is concerned, I won't be able to participate in the bid. Would your lordship says that notwithstanding these conditions, my lord, which will be subject matter of your lordship, permit me to enter into the bid, my lord?
First thing is not my jurisdiction unless heavens are going to fall.
No, my lord, I filed this last Friday, my lord.
True, but 19th.
Last Friday I filed, I moved it on.
Matter to be listed on 19th.
No, my lord, I filed it on Friday. But I mean, it's a straight covered matter, my lord. If
No.
Your lordship may look at it.
No, if the tender condition says that you should have done something in Karnataka or unit should be in Karnataka, you having done something in Maharashtra, I don't know.
No, it's all borne out by record, my lord. I have produced all the material.
No, you may have done. I'm not saying you. I'm doubting.
Iವ್ರಿಗೆ ಮಾಡಿರೋದೇ ಕೊಟ್ಟಿದ್ದೀನಿ. ಬೆಂಗಳೂರಲ್ಲಿ ಮಾಡಿರೋದೇ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ page 9 ನೋಡಿದ್ರೆ, if your lordship looks at page 9, 3 previous tenders, just look at the dates, my lord, 23, 24, 25, page 9, para 8.
Who pays for the respondent?
My lord, I had served an advance copy, my lord, to them.
They are not on KVT anyway. Yes.
And also sent by email to them, my lord.
All right, you participate, no equity.
Agbod. Dehorse these conditions that I have mentioned at page 40.
No, dehorse conditions, then I will be tinkering with the conditions.
No, but then your lordship.
Notwithstanding the conditions you participate, not dehorse the conditions.
Agbod.
Whether they will assess it or whatever.
Fair enough, fair enough.
They heard the learned senior counsel J.L. Vishwanath appearing for the petitioner. 2 clauses of tender has become the bone of contention. 3 clauses of tender has become the bone of contention to the petitioner or is a fly in the ointment now. The learned senior counsel submits that the petitioner has undertaken such work that is necessary for consideration of the award of tender to the petitioner in the state of Maharashtra and in the state of Karnataka as well. Notwithstanding the same, those 2 conditions have no nexus. Those 3 conditions have no nexus to the object sought to be achieved and for the purpose for which the tender is notified. Therefore, to protect the interests of the petitioner or the balance of convenience at this juncture, I deem it appropriate to permit the petitioner to participate in the tender, notwithstanding the aforesaid conditions, with a rider that the petitioner would not claim any equity in future in the event the writ petition would be going against him. It is made clear that the participation is not dehorse the condition, but notwithstanding the condition. Yes.
And deliver.
Ad kodtivi. Tondre Fast. 4 and 5 withdrawal.
The serial number 4 liberty may be reserved.
Memo helilva for withdrawal. Charge sheet.
Charge sheet is.
Anuje madam, charge sheet liberty. 5 same. Adu adene. Charge sheet agide anta.
But I don't want to tinker with the order that is passed by your lordships and what has fallen, and without looking a gift horse in the mouth. Instead of saying dehorse, would your lordship be subject to the decision of this writ petition? If you're instead of saying dehorse.
No. See, if I.
I'm only saying it will be ultimately subject to the decision.
It is the result of the petition.
If your lordship would say it, that,
right.
Please.
Monday.
The objection is.
KVT ಇದೆ. KVT ಇದೆ.
My lord, KSFC. My lord, what has happened in this, if your lordship could see for a minute, annexure F, my lord, page 17.
3 meeting ಇದೆ
my lord, OTS ಕೊಟ್ಟಿದ್ರು 1 crore 4 lakhs, my lord, and I got a buyer for 80 lakhs. We deposited.
What is the date of auction?
My lord, the date of auction was started yesterday.
Is
No, yesterday it started and it will end tomorrow. That is on Friday, my lord.
Auction ಆಗ್ಲಿ ಬಿಡಿ.
My lord, my
ಎಷ್ಟು ಕಟ್ಟಬೇಕು?
My lord, the OTS, my lord, which was offered to me was 1 crore, my lord. 1 crore 4 lakhs.
ಯಾವ ವರ್ಷ ಎಷ್ಟು ವರ್ಷದಿಂದ?
25 ಅಲ್ಲಿ. My lord, and I got a buyer, my lord, and he deposited 80 lakhs. In the meantime, my lord, they revised.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ಆಕ್ಷನ್ ಆಗ್ತಾ ಇದೆಯಾ, ಬೇರೆ ಎಲ್ಲ ಆಗ್ತಾ ಇದೆ?
ಬೇರೆ ಇಲ್ಲ, ನಮ್ದು ಅಷ್ಟೇ.
3 ದಿನ ಯಾಕೆ ಬೇಕು?
My lord, they have given, my lord, kindly see annexure B, my lord, only one property.
Your OTS is 2024, madam.
My lord, 24, 27/9/24, my lord.
ಹೌದು.
And which will end in February 25, my lord. And I got
ಆಯ್ತು, ಒಂದು ವರ್ಷ ಆಗೋಗಿದೆ ಅದನ್ನು.
I got a buyer, my lord, 80 lakhs he deposited. Then they revised and brought it to 3 crores, my lord. My lord,
ಆಯ್ತು, we will only protect not to create third party
my
rights
lord,
pursuant to the
I
auction.
will deposit, my lord.
Auction start ಆಗೋಗಿದೆಯಲ್ಲ.
ಇಲ್ಲ, ಒಬ್ರೇ ಒಬ್ರು bidder
ಅಲ್ಲ
ಹಾಕಿಲ್ಲ.
ಆಯ್ತು,
ಯಾರು
auction
ಹಾಕಿಲ್ಲ.
start ಆಗಿರೋದ್ರಿಂದ I will permit the auction, but they will not issue any sale certificate or confirm the sale in favor of the auction purchaser. And post this on Monday.
Third party rights will be created.
Well, nothing will be created. Otherwise, ನೀವು ಕಟ್ಟದೆ ಹೋದ್ರೆ ಆಮೇಲೆ ಇರೋ auction ಹೋಗ್ಬಿಡುತ್ತೆ. All the steps that they have taken,
My
that's
lord,
not correct.
my lord, on 10th, my lord, they issued a.
So Supreme Court time and again is saying I should not interfere.
My lord, on terms.
ನಮ್ಮ
my lord, I'll
ಆರ್ಡರ್ಗಳೇ
deposit-
ಎಲ್ಲ ಆಗಿರೋದಲ್ಲಿ.
My lord, I'll deposit, my lord, in 4 weeks, my lord, if 4 weeks
No,
time
no,
is
madam.
granted, deposit.
It is these orders that Supreme Court has told about. My order, in fact, it's my order only. The 10% ಕೊಡ್ತಾ ಇದ್ನಲ್ಲ
But
ಅದು.
if your lordship could see 1 crore, my lord, they increase it to
No,
3
madam,
crores.
ಅದು ಗೊತ್ತಿಲ್ಲ. But I will say, let the auction go on. Its sale certificate will not be issued or sale will not be confirmed in favor of the auction purchaser. Then Monday, we an order back ತಗೊಳ್ಳಿ. The petitioner has moved the matter on the score that auction of the subject property is now being undertaken. The auction is ongoing and is to end tomorrow evening.
No, that's on,
Huh?
on Friday, my lord.
On Friday evening. The learned counsel submits that substantive deposit can be made if the auction is stalled. The said submission is not acceptable. However, the auction shall go on. The sale certificate or confirmation of sale shall not be made of the subject property without the leave of the court. List the matter on Tuesday before the bench having roster.
My lord, make on submission, my lord. My lord.